President's ex officio of the board. The committee shall place a cash valuation on the superstructure and shall be instructed as to the manner in which the valuation shall be obtained. Number 16, see page 1117. The agency. From the Oil City Derrick. There shall be established, under the auspices of the Council of the Petroleum Producers Association of Pennsylvania, an organization under sanction of the laws of Pennsylvania, which shall be known as the Petroleum Producers Agency. 2. The capital stock shall be not less than $1 million, and shall be divided into shares of $100 each, which shall be subscribed only by members of the Petroleum Producers Association, or by such other persons as may be approved by the Council. 3. No transfers of the shares of the capital stock shall be made on the books of the agency, except upon such conditions as the directors may prescribe, subject to the approval of the Council. 4. The business of the agency shall be managed by a board of 13 directors, who shall be elected annually by the stockholders. There shall be an advisory board to consist of one member elected by each local association and approved by the Council. The members of the advisory board shall be admitted to the meetings of the board of directors and shall be entitled to all the privileges of directors, except that of voting. Any member of the advisory board may be removed for any abuse of his trust, or for official misconduct, by a vote of 3/4 of the Council at a regular meeting. 6. The local associations may appoint committees to solicit and receive subscriptions to the capital stock. They may also appoint responsible trustees to receive payments on account of such subscriptions, to whom the subscribers shall pay at least 10 per cent upon their subscriptions at the time of subscribing. The committees of the local associations shall advise the President of the Council, from day to day, of the amount of subscriptions received by them, and whenever the sum of at least $1 million shall have been subscribed in good faith, and approved by the Council, and the organization of the agency legally completed. Subscribers shall be notified to hold an election of directors. The directors shall, as soon as practicable after their election, proceed to elect a president, secretary, and treasurer. The trustees, appointed by the local associations to receive subscriptions, shall thereupon be required to pay over to the agency the amounts received by them on account of subscriptions to the capital stock. The agency shall not be responsible for any subscriptions paid to the trustees appointed by the local associations until the same shall have been paid over to the agency or its authorized representatives. Subscriptions to the capital stock may be received, payable in oil, at $5 per barrel, delivered on the cars or in the tanks of the agency at any sub-agency on the line of the railways, provided, however, that no certificate of stock shall be issued in any case in which payment is made in pipeline receipts until the oil shall have actually been received upon the order by the agency or its agents. But a special guarantee of the order shall be required from the subscriber with an agreement that the stock shall be retained as security for the delivery of the oil on demand, and the demand shall be made within 30 days after the order for the oil is received by the agency. 7 members of the Petroleum Producers Association shall sell their oil only to the agency. The agency shall purchase all the oil offered by members of the association and shall pay therefor at least $5 per barrel for oil of standard grade, and for the heavy oil of the 5th District. Payment for oil purchased shall be made as follows: if the market will take the entire supply as fast as offered, the full market price shall be paid in cash on delivery. But if the Board of Directors, or the Council, shall determine that the oil daily offered to the agency is in excess of the demand, the Agency shall pay $3 in cash and give the seller a certificate entitling him to the net proceeds of the oil when sold, less the amount advanced thereon. 8. The agency shall sell no oil for a less price than $5 in cash, on delivery per barrel without the consent of the Council of the Petroleum Producers Association. 9. To the redemption of the certificates, on and after the 10th of the month succeeding that in which they were issued, shall be applied the proceeds of all the oil sold and delivered during that month, less the amount advanced and the amount required to tank the surplus oil. For the unpaid balance of the certificate the holder shall, upon the surrender of the same, be entitled to a tank receipt, representing his interest in the amount of surplus oil in store and tankage. X. The agency shall be entitled to receive for buying and selling the oil such commissions per barrel as the Council may allow, applicable first to the payment of expenses, second to the payment of dividends on the capital stock, which shall be 6%, semi-annually, free of taxes. 11. All the net proceeds of surplus oil sold shall be applied specifically to the redemption of the tank receipts at their value, the surrender of which shall be at the option of the holder. 12. The agency shall establish sub-agencies at such points within the oil-producing district for the receipt, storage, and shipment of oil as may be necessary to facilitate the convenient and economical transaction of the business of the region, subject to the approval of the Council. 13. The agency shall provide all storage necessary to hold the oil on sale and the surplus oil in store. 14. The price on the cars of oil of the standard grade shall be uniform at all the sub-agencies on the line of the railways within the oil-producing district, provided it be practicable to so arrange with the railroads. 15. A barrel shall be uniformly 42 gallons. 16. Whenever the production of petroleum shall be permanently in excess of the demand, the Council of the Petroleum Producers Association shall determine at what time the production shall be restrained and shall take such measures as may be practicable, necessary, and lawful to prevent the drilling of oil wells, but it shall confine its orders, so far as practicable, to preventing the starting of new wells, allowing those already in process of drilling to be completed. 17. Whenever in the opinion of the Board of Directors it may be advisable, they may, subject to the approval of the Council, provide such refining capacity as may be required to maintain the highest price for crude petroleum consistent with the consumptive demand. 18. The agency shall not at any time sell to, or contract with, or make any arrangement whatever, with any individual, organization, combination, or association, by which they may have a monopoly, inside rate, advantage, or preference over, or to the prejudice of, any present or future competitor for the purchase of the crude oil coming into, or passing through its hands, provided that nothing in this section shall be so construed as to prevent the agency, with the sanction of the Council, from making such temporary discrimination as may be necessary for the purpose of protecting or promoting the interests of producers by securing higher prices for crude oil, increased consumption of refined oil, or decreased margins between the price of crude and refined oil. 19. The agency, with the approval of the Council, may take such measures as may be expedient to increase the consumption of petroleum by securing its application to new uses. XX. The agency shall publish daily a correct statement showing the amount of oil purchased, the oil sold, and oil placed in store during the day, also showing the points at which the same was done, and the amounts at the time in store at the various sub-agencies. Also the destination of the oil sold. XXI. The agency shall publish tri-monthly, full, and complete reports of all its transactions and showing its condition at the date of the report. The correctness of the report shall be verified in such manner as may be prescribed by the Council. XXII committee may be appointed by the Board of Directors, or by the Council of the Petroleum Producers Association, at any meeting, for the purpose of investigating the condition and management of the affairs of the agency, and it shall be the right and duty of such committee, duly appointed, to thoroughly investigate everything affecting the interest of the agency, to examine its books, accounts, and vouchers, its safes, vaults and tanks, and to make a true and faithful report of the condition and management of the affairs of the agency as they may be found, which report shall be published at the expense of the organization which appointed the committee. It shall be the duty of the Council to see that such committee is appointed and such examination and report made and published at least once in every year. XXII The agency shall establish a Bureau of Statistics and Information, which shall carefully collect and publish facts relating to the business of producing, refining, marketing and the consumption of oil. The rooms of the Bureau shall at all times be open to the members of the Petroleum Producers Association, and the agency shall hold itself open for daily communications by telegraph with local associations. Number 17, see page 1123. Contract between Petroleum Producers Association and Petroleum Refiners Association. From the Oil City Derrick. The contract between the producers and refiners read as follows. Whereas the necessities of trade call for cooperation between the producers and refiners of oil, for purposes of mutual protection. Therefore, we, the undersigned, representing the Petroleum Producers Association and the Petroleum Refiners Association, hereby enter into the following articles of agreement, which stipulate as follows. First. Each of the two associations hereby agrees to appoint a representative committee, which committee shall meet together weekly, or as often as may be necessary, and at such places as they may determine. It shall be the duty of these committees, so far as in their power lies, to see that the provisions of this agreement are executed in good faith, and to discharge such duties as are devolved upon them by this agreement, and in general, within the limitation of their authority, to act for the mutual advantage of the trade, whose interests it is the purpose of this agreement to secure. Second. The Producers Association shall appoint a controller, who shall have the right to examine the books of the Refiners Association, and its daily reports so far as they relate to the purchase, sale, and shipments of crude and refined oil, and who, together with the auditor of the Refiners Association, shall make joint reports daily to both associations. The Refiners Association shall appoint a controller, who shall have the right to examine the books of the Producers Association and its agencies, and their daily reports, so far as they relate to the purchase, sale, and shipments of crude and refined oil, and who, together with the Secretary of the Producers Association, shall make joint reports daily to both associations of all sales and shipments. Third. Each association agrees that it will keep accurate books of account, which shall show all purchases, sales, and shipments of crude and refined oil, which shall also be open at all reasonable hours to the inspection and examination of the authorized agents of each association, as hereinbefore provided. Fourth. The Refiners Association agrees to admit all existing refiners to membership, and to a participation in the future benefits of the association on equal terms with present members, and the Producers Association agrees to allow all producers to join its association on the same terms with the present members. Fifth. The Producers Association agrees to sell, through its regular appointed agencies, crude oil exclusively to the refiners Association and its members, and the Refiners Association and its members agree to purchase crude oil exclusively of the Producers Association or its appointed agents. _6th. The Producers Association agrees that all producers enjoying the benefits of this contract shall be required to bind themselves to sell their oil exclusively through the Producers Association. _7th. The Refiners Association and its members agree that they will not until after 60 days from the date of this contract sell any portion of the crude or refined oil now held by them, except so far as they shall have previously purchased the equivalent of crude oil to take the place of the oil so sold. They further agree to buy from the Producers Association daily such quantities of crude oil as the markets of the world may take of them, the same to be determined from time to time by the representative committees herein provided for. _8th. The price of crude oil so purchased and sold to be conditionally $5 per barrel of 42 gallons each, at common points, payment to be made as follows. When refined oil is sold in New York at 26 cents per gallon, no additional amount is to be paid, but for every 1 cent per gallon of advance in the average price of sales of refined oil in New York, 25 cents per barrel shall be added to the price of so much crude oil as shall be the equivalent of refined oil sold at such advance until the price reaches $5 per barrel. A proportionate addition to the average price of crude oil shall be paid for each fraction of 1 cent per gallon increase in the average price of sales of refined oil at New York, by members of the Refiners Association. The price of refined oil in New York and of crude oil at common points to be adjusted by the representative committee herein provided to be appointed. _9th. The representative committees may at any time, when it may be necessary to do so, reduce the prices of crude and refined oils below the minimum or advance them above the maximum prices above named, the increase and reduction in price and the cash payments on crude oil to be determined by said committees. _10th. Settlements to be made to the end of each calendar month, and balances to be paid not later than the 5th of the succeeding month. _11th. The profits on all crude oil sold for export by members of the Refiners Association shall be credited to the Producers Association in the next succeeding regular monthly settlement after delivery of said oil. _12th. Either association may discontinue this agreement at any time by giving to the president of the other association 10 days notice in writing of its purpose to do so. _13th. This agreement to remain in full force and effect for and during the term of 5 years from this date, unless sooner terminated in the manner provided in section 12 of this agreement. _14th. Amendments and alterations may be made at any time by the representative committees, subject to the approval of the respective associations. In testimony whereof, the Petroleum Producers Association, by its Executive Committee, and the Petroleum Refiners Association, by its President and Secretary, have hereunto set their hands this 19th day of December, AD 1872, in the city of New York. Petroleum Producers Association, by C. V. Culver, A. H. Bronson, Samuel Q. Brown, William Parker, B. B. Campbell, Executive Committee Petroleum Refiners Association, by John D. Rockefeller, President Number 18, see page 1132. Testimony of George R. Blanchard on rebates granted by the Erie Railroad. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume 3, pages 3393-3395. October 1, 1872, when I first became general freight agent of the Erie Railroad, no oil was produced in the Bradford district, and all petroleum then transported by the Erie Railway eastward came from the Atlantic and Great Western Railroad. At that time, Adna Nehart, of Tityut, Pennsylvania, represented by W. T. Shade, afterwards by H. C. Olin at New York, shipped small quantities of refined oil, for which he received a rebate of over $7,000 on his shipments for the prior month, to wit, September, 1872. I looked for the reasons, and found the agreement next prior to that time as to shipments and rates was the one already in evidence between producers, shippers, refiners, and railroad companies, dated March 25, 1872. I asked why that contract was not observed, and was then convinced in reply that the agreement of March 25 lasted less than 2 weeks, and that at that early date the Empire Line was receiving a large drawback or commission from the Pennsylvania Railroad, which was either being shared with its shippers or an additional amount was being allowed to them, besides that which the Empire Line itself received from the Pennsylvania system, and as the Empire Line also owned the Union Pipeline, its shippers had advantages which our company and its shippers did not even jointly possess. At the close of that calendar year, 1872, the entire petroleum traffic for the 5 months of the administration of President Watson, the former President of the South Improvement Company, to January 1, 1873, was but 265,853 barrels, or but about 53,000 barrels per month, while the Pennsylvania Railroad was carrying about 6 times as much, or 300,000 barrels per month, and the New York Central was carrying the entire refined oil sent from Cleveland to New York. The representations then made to me also convinced the Atlantic and Great Western Company as to what our rivals were doing, and that Railway Company and our own decided to continue to pay the 24 cents per barrel drawback then being paid on the rate of $1.35 provided by this producers' agreement of March 25, 1872. It is therefore clear that one of the largest of the shippers, who signed that March agreement, did not feel that it bound him to pay the rates he had agreed to pay, and he gave convincing reasons to believe that others, signers and parties to that agreement, did not pay them, and possessed equal or greater advantages by way of rival routes. Early in 1873 Mr. Shade came to our line with M.R. Nehart's crude business, under the circumstances Mr. Shade has stated, but being yet without any shippers of refined oil, and believing that the Empire Line would pay a rebate on refined, as I now know from Mr. Shade's testimony, they had paid Mr. Shade on crude. I opened negotiations to increase our traffic, which resulted in an agreement, with the concurrence of the Atlantic and Great Western, as follows. Erie Railway Company. Office of 2nd Vice President. New York, March 29, 1873. Memorandum. Between John D. Archbold, Mr. Bennett, and Mr. Porter, and M.R. Osborne, and self. Rate for March, 1873, to be 132 1/2 from Union. Rate thereafter to be 125 from same point as the maximum for 1873 if the common point rate is made from Titusville at any time in 1873, on _bona fide shipments, Erie and Atlantic and Great Western will make same rate from same date. With this rate, the refiners agree to give us their entire product to New York for the year, and the preference always at same rate as actual shipment by other lines. Signed, John D. Archbold. G. R. Blanchard. This Mr. Bennett was also one of the signers to the agreement of March 25, as a refiner, and from these gentlemen I also learned it. That time that this producers' agreement was exploded by the action of the producers' union before that time. Notwithstanding this agreement of March 29, 1873, with its reduced rates, its signers left us in November, 1873, and gave the Empire Line their entire shipments, and we were then left with but one small shipper of refined oil, Mr. G. High, whose consignments were small, and to retain even this small business, against similar solicitations by our rivals we were compelled to make his rate $1.10. In November, 1873, instead of $1.50, as provided by this producers' agreement. These facts effectually refute the testimony of Mr. Patterson that the agreement of March 25 continued for 2 years, or any other period beyond 3 weeks, at the rates it stipulated, and show that at least 2 of its signers did not feel bound to pay the rates it named, and that they and others by other lines endeavored immediately after it was signed to obtain, and did secure reduced rates, as usual before its execution, and peddled their oil among different railroads wherever they could secure an advantage, however small, over each other or the railroads. Number 19, see page 1133. Testimony of W. T. Shade. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume 3, pages 2774-2777. _Q. Why were you shipping over the Pennsylvania Road and not over the Erie? A. For the reason that the Pennsylvania was most eligibly situated for our purposes. Q. How did you come, then, to ship over the Erie at all? A. We came to ship over the Erie because of what we considered very bad treatment on the part of the Pennsylvania Railroad. Q. What was that bad treatment that you received at the hands of the Pennsylvania Road? A. It consisted, principally, in a discrimination against us in furnishing us with cars. Q. They refused you transportation? A. Yes, sir. Q. Were they refusing you transportation in the interest of the combination? A. In the interest of a peculiar idea that they had, that all shippers should be placed upon the same basis. Q. And in consequence of that peculiar idea, they gave to other shippers transportation and did not give it to you? A. Yes, sir. Q. And that was the practical way in which that corporation carried out that idea? A. Yes, sir. You will allow me to explain, please? Q. Yes, go on. A. The oil business differs from other business in this, that it is a daily crop. There is a certain amount of oil produced that has to be shipped every day. The consumption, however, is not equal to the daily production of our trade. The consumption varies and the demand varies. The consequence is that there are seasons of the year when a man engaged in shipping oil ships oil really at a loss, because there is no demand for it, and there are other seasons when there is a large profit. Now the Pennsylvania Railroad always insisted upon having a large number of shippers. This large number of shippers would ship only when there was profit, and when there was no profit somebody else had to ship. We had been their shipper for a number of years. Q. When you speak of their shipper, their leading shipper, do you mean? A. Yes, sir. We did their business between Philadelphia and Baltimore and New York. Q. Were you their evener, so to speak? Underscore A dot underscore we did not have any eveners in those days. Underscore Q dot underscore did you practically stand in the position of an evener? Underscore A dot underscore no, sir, we were simply their shipper of crude oil. Underscore Q dot underscore when you speak of their shipper, in the singular, do you mean that you were their sole shipper, as you subsequently became on the Erie? Underscore A dot underscore I mean we had better rates of freight than anybody else could have obtained over the Pennsylvania Railroad at that time. Underscore Q dot underscore and therefore monopolized the business, go on. Underscore A dot underscore and the consequence is that in consequence of this change in the demand that when there comes a season that there is a little money in it, the Pennsylvania Railroad would encourage these numerous small shippers who would come in and they would prorate cars with them. They would only allow us to put in a requisition for a certain number of cars and they would allow anybody else, an entire stranger, a man who never shipped any before, to put in an equal requisition, and they would prorate with him, and the consequence was in the paying business we were out and in the unpaying business we were in. Underscore Q dot underscore and you left it. Underscore A dot underscore yes, sir. Underscore Q dot underscore because you could not get rates better than other people? Underscore A dot underscore no, sir, because we could not stand it, because we were losing money. Underscore Q dot underscore on the same basis that other people were? Underscore A dot underscore no, sir, other people were not shipping except when there was a profit. Underscore Q dot underscore why did you ship when there was not a profit? Underscore A dot underscore because that was our business, we were shippers of petroleum. By the chairman. Underscore Q dot underscore I don't understand why you were obliged to ship at a loss. Underscore A dot underscore that is the reason why we left the Pennsylvania Railroad. Underscore Q dot underscore I don't understand why you were obliged to ship at a loss. Underscore A dot underscore we were in the petroleum business and shippers of petroleum. And we had contracts. In order to keep the cars running it was necessary for us to make a contract for 1, 2, 3, 5, or 6 months ahead. By Mr. Stern. Underscore Q dot underscore isn't it true that upon the basis of your having better rates than anybody else, you proceeded to make contracts to extend your business? Underscore A dot underscore yes, sir. Underscore Q dot underscore with the Pennsylvania Road? Underscore A dot underscore yes, sir. Underscore Q dot underscore and that the moment that you were placed in the position of having underscore A dot underscore no transportation. Underscore Q dot underscore no transportation equal to your expectations, with your special rates? Underscore A dot underscore I had to buy oil in New York. Underscore Q dot underscore that was the real fact? Underscore A dot underscore yes, sir. Underscore Q dot underscore the business was based upon the rate of transportation? By the chairman. Underscore Q dot underscore why did you have to buy oil in New York? Underscore A dot underscore to fill my contract. Underscore Mr. Stern underscore he had made his contract upon the basis of his special rate. Underscore the witness underscore and there was a certain supply of transportation which was given to me by Mr. Stern. Underscore Q dot underscore practically an exclusive supply of transportation you had it one time over the Pennsylvania Road, hadn't you? Underscore A dot underscore yes, sir. Underscore Q dot underscore and when they changed their policy in that respect and gave other people transportation, you could not fill the orders upon the basis of which you had made your contracts? Underscore A dot underscore you will excuse me, this would seem as though this was a sudden arrangement, it was not, it lasted 3 or 4 years. Underscore Q dot underscore you had reason to suppose that it would last, had you not? Underscore A dot underscore this policy of theirs. Underscore Q dot underscore this policy. Underscore A dot underscore yes, sir. Q. That drove you on the Erie? A. Yes, sir. Number 20, see page 1133. Statement of amounts paid for overcharges and rebates on oil during the year 1873 by the New York, Lake Erie, and Western Railroad. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume V, page 275 of Exhibits. Name: Erie Pro. A. Nahart $188,127.78. Gust. High 7235.31. J. Vandergrift 929.11. Durant and Company 145.95. Dudilk and Company 815.95. S.D. Carnes 7089.69. Standard Oil Company 469.11. H.B. Everest 6.66. Lyman and Williams 13.44. J.H. Williver 32.98. L. Van Duzer 3.50. H. Roach and Son 0.29. L. Y. Wiggins and Brother 24.11. P. A. Stebbins, Jr. 4.53. C. P. Prince and Company 2.69. E. L. Houghton and Company 45.24. McCurgan and Company 2.70. Marks and Bean 45.82. McMahon-Eagle and Rogers 18.27. Theodore Merritt 4.56. W. F. Smith 3.86. Vacuum Oil Company 8.80. Van Dusen Brothers 38.88. Woodbury, Morse and Company 5.40. Ward, Leonard and Company 88.06. Young and Borden 7.97. Total $205,170.66. Number 21, see page 1135. Agreement of 1874 between the Erie Railroad System and the Standard Oil Company. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume 3, pages 3398-3402. Agreement concluded this 17th day of April, AD 1874, by and between the Erie Railway Company and the Atlantic and Great Western Railroad Company, parties of the first part, and the Standard Oil Company, of Cleveland, Ohio, party of the second part, witnesseth first. The parties of the first part, Erie Railway Company and the Atlantic and Great Western Railroad Company, agree to furnish a sufficient number of good and suitable cars for the purpose of transporting petroleum and its products from the refineries now owned by the party of the second part, Standard Oil Company, at Cleveland, Ohio, and Oil City, Pennsylvania, and any others they may hereafter control or own, to Weehawken Oil Yards, in New Jersey. Second. The parties of the first part agree to transport said products of said refineries, and deliver the same in cars, if destined for the New York market, at and upon the side tracks connected with said Weehawken Oil Yards, in good order and condition, except as provided for in Article 4, and do all switching of cars at said oil yards necessary to the prompt and rapid discharge and handling of cars employed in said business. They also agree to haul said cars, whenever practicable, in full trains over their respective roads with promptness and uniformity of movement, and accept compensation therefor as hereinafter provided. Third. Rates of freight on all said products to be made from time to time between J. H. Devereux, President of the Atlantic and Great Western Railroad Company, and the Standard Oil Company, the same to be to the satisfaction of the said J. H. Devereux, President, to be, however, no higher than is paid by the competitors of the said Standard Oil Company, from competing Western refineries to New York. By all rail lines each of said railway companies excepting its _pro rata proportion of the through rate thus made. Fourth. The party of the second part agrees not to ship more than 50 per cent of the product of its said refineries by any other line or lines eastward, to be shown by monthly statements, verified by its president and secretary. It also agrees to assume all risks and losses of its property by fire when in the charge or custody of the parties of the first part, whether said property is being moved in trains or stored, or lying at any station between place of shipment and destination, both included. It further agrees to assume all losses from natural leakage or breakage, except the same is caused by collisions or the wrecking of cars by unavoidable accidents. It also agrees, at its own cost, to safely load at places of shipment all of said products, and unload the same when delivered at the said Weehawken oil yards, and furnish said products for shipment with as great regularity as possible. Fifth. In the event of unavoidable detention, occasioned by the elements, or by strikes of employees of the parties of the first part, or either of them, whereby said first parties are unable, for the time being, to fulfill their covenants under this agreement, then it shall be the duty of said first parties to immediately notify the second party of such casualty or strikes, and such casualty or strike shall be considered good and sufficient cause for delay in the execution, for the time being, of the provisions of this agreement. And said first parties, and each of them, shall be saved from all obligation for the fulfillment of this agreement. During the period of such detention, anything in this contract to the contrary notwithstanding, it shall be the duty of said first parties to proceed forthwith to put themselves in position to resume their obligations under this agreement, giving notice at the earliest possible moment to the second party of their ability to resume. Sixth. The Erie Railway Company for itself hereby stipulates and agrees to and with the second party, that on or before the first day of May, AD 1874, it will give full and complete possession of the property known as the Weehawken Oil Yards, in New Jersey, together with all buildings, erections, docks and appurtenances thereunto, belonging unto the second party to have and to hold, with all revenues derived therefrom, from and after the said first day of May, AD 1874, or until the expiration of this agreement, as otherwise herein provided. The Erie Railway Company further agrees, at its own cost, on or before the first day of May, AD 1874, to put said buildings, erections, and appurtenances in good repair, after which said second party shall maintain the same in like good order, and to do all dredging required to provide and preserve the requisite depth of water. Seventh. In consideration of the possession of said Weehawken Oil Yards, the second party hereby agrees to and with the Erie Railway Company as follows, to wit, to pay weekly to said Erie Railway Company the sum of 5 cents on each and every barrel, of 45 gallons, of crude oil, and the same sum on each and every barrel, not to exceed 46 to 48 gallons, of the products of petroleum, passing through or into the aforesaid yards, the rate of 5 cents to be absolute on all said refined products, but subject to rateable reductions on crude oil, in case the terminal charges on crude oil are reduced, taking present schedule of rates thereon. Adopted November, 1872, a copy whereof is hereto annexed, as the standard, the Erie Railway Company retaining the right to reduce said schedule of rates on crude, to meet competition, the second party further agrees to conduct said warehouse business in the name of the Erie Railway Company, at its own cost and expense, to assume such risks on the oil, while in its possession, as the Erie Railway Company or the Atlantic and Great Western Railroad Company would be responsible for to forwarders, consignees, or owners after its arrival and delivery in cars at yards, to make the charges uniform to all parties who use the yards, or for whom services are performed therein, and always as low as any other oil yard affording proper facilities for the transfer, storage, preparation, and shipment of the oil at the terminus of any railway, or other line competing with the Erie Railway, at or adjacent to the Port of New York, and generally so to manage the premises as to give all patrons of the road fair and equal facilities for their oil business at uniform cost, to retain and pay the present superintendent and other officers and employees of the yard, so long as their duties are satisfactorily performed, and from time to time to appoint such other officers as shall not be objected to by the Erie Railway Company, to maintain the buildings, erections, and mechanical appliances of the premises in as good order as when possession is given, natural wear and unavoidable, by due diligence, damages from the elements accepted, to make no rules or regulations discriminating against any other shipper or shippers, or receivers. It is understood and agreed that the consent of the Erie Railway Company is to be obtained before any refined or crude oil shall be received at the Weehawken oil yards, which arrives from the west via any transportation line competing with the Erie Railway. _8. It is further agreed that the second party shall assume the charge and collection of freights and charges accounts to be rendered and adjusted, and paid weekly Erie way bills to govern quantities received, except when the same are shown to be incorrect, or loss in transit, except from natural leakage, has occurred through fault or neglect of said railway companies, or either of them. Any new fixtures which the party of the second part may add to the property shall be and remain its property, and they may remove the same at their cost, at the expiration of this agreement, unless mutually satisfactory terms of purchase and sale can be agreed to. _9. This agreement to take effect and be binding upon the parties hereto, on the first day of May, AD 1874, and to continue until the first day of May, AD 1877, provided, however, that either party may terminate the same upon giving notice in writing to the other party 6 months in advance of its intention so to terminate, and provided further, that within 30 days after the election of a new board of directors, of either the Erie or Atlantic and Great Western Railway Companies, the second party shall have the right to terminate this agreement, by giving notice in writing to the other party 1 month in advance of its intention so to terminate, and upon the expiration of either of said periods, this agreement shall be then at an end. _10. In consideration of the premises, the party of the second part agrees to pay to the Erie Railway Company, weekly, the sums which such weekly settlement shall show to be due to the said first parties, as freight on its property delivered at the Weehawken oil yards. _11. It is hereby expressly understood and agreed that neither of the said parties of the first part shall be liable for the acts or defaults of the other, and that each shall only be liable for its own acts and defaults, on and over its own line and premises. *********** In witness whereof the parties hereto have affixed their hands. This 20th day of April, 1874. Signed, the Erie Railway Company. By G. R. Blanchard, _2nd Vice President _. Signed, the Atlantic and Great Western Railroad Company. By J. H. Devereux, President Signed, Standard Oil Company. By William Rockefeller, Vice President Number 22, see page 1139. Agreement of 1874 between the railroads and pipelines. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume 3, pages 34-31-34-37. Memorandum of Agreement entered into this 4th day of September. AD 1874, by and between the following parties, viz. First. J. J. Vandergrift, G. V. Foreman, and John Pitcairn, Jr. Partners themselves, and agreeing that they have authority to represent all other partners in the association trading under the name of the United Pipelines, and holding themselves individually responsible to the other parties hereto that they have such authority. Second. The Union Pipe Company by Charles P. Hatch, Manager. Third. The Antwerp Pipe Company and the Oil City Pipe Company, each being corporations under the laws of the state of Pennsylvania. Fourth. The American Transfer Company, a corporation under the laws of the state of Pennsylvania. Fifth. The Grant Pipe Company, a corporation under the laws of the state of Pennsylvania. Sixth. The Carnes Pipeline Company, a corporation under the laws of the state of Pennsylvania. Seventh. The Relief Pipeline Company, a corporation under the laws of the state of Pennsylvania. Eighth. The Pennsylvania Transportation Company, a corporation under the laws of the state of Pennsylvania. Ninth. J. J. Vandergrift, G. V. Foreman, and John Pitcairn, Jr. trading under the name of Vandergrift, Foreman and Company, and owning and representing the Milton and Sandy pipelines. Whereas the pipelines owned and controlled by the parties hereto have a joint capacity for transportation more than twice as great as the total volume of petroleum produced in the district traversed by said lines, and whereas the separate and discordant relations now prevailing among the parties hereto lead to a needless multiplication of extensions, branches, and other matters involving heavy cost, which ultimately becomes in some shape a charge upon the business transported, and also leads to the offering of open or secret inducements of an illegitimate nature, such as rebates, special rates, selling oil for less than its cost and full pipage rates, and in other ways hereby to attract an undershare of traffic to the respective lines represented herein, and whereas it is believed to be desirable both for the interests of the parties hereto and those of the public whom they serve, that all needless expenditure and all illegitimate inducements should cease. Now, therefore, for those purposes and for other valuable considerations mutually moving the parties hereto, they do each respectively agree with each other, as follows. First. The parties hereto do not by these presents create in any respect a partnership with each other, but each party is to be wholly and solely responsible for all of its own acts in the conduct of its business, for its certificates, receipts, and collection of its charges, its expenses, shortages, maintenance, and management of its property, and of its engagements and obligations of every sort. Second. The pipelines which are covered by this agreement are those which are or may be owned by any of the parties hereto, and which are situated south of Oil City, and which terminate at any of the following points, viz. Points on the Franklin branch of the Atlantic and Great Western Railway, points on the Jamestown and Franklin branch of the Lake Shore and Michigan Southern Railway, points on the Allegheny Valley, between or at Oil City and Pittsburgh, points on the Shenango and Allegheny Railroad and points on the Butler Branch Railroad, excepting 2 small pipelines, one owned by F. Prentice and Company, running from Mount Hope to Foster, and one owned by Vandergrift, Foreman and Company, called the Franklin Pipeline, running from the heavy oil district to Franklin, Pennsylvania. _3. Each party hereto shall retain 8 cents per each 42 gallons remaining after deduction of allowances for shortage and sediment, on all of the oil it actually pumps, also all allowances made it on such oil to meet shrinkage and sediment, and also all of its other receipts of every description, except as stated in the next article. _4. Each party shall account monthly to the Executive Committee hereinafter provided for, at the rate of 22 cents for each 42 gallons of petroleum, after deducting shrinkage allowances, received by it for transportation during such months, which 22 cents shall be considered by said committee as a common fund to be cleared and divided on the basis hereinafter designated. _5. The Executive Committee shall consist of 1 representative from each of the parties hereto, each representative to be appointed by the party he represents, to be changeable from time to time by such party, at its pleasure. The said committee shall faithfully execute such provisions of this agreement as are by its terms confided to them. Their action must, in all cases, be unanimous before it shall be binding upon any party hereto. They shall keep a record of their proceedings, to which each of the members shall have free access, and whenever desired by any, a full transcript, or any part thereof. The members of said committee shall, until changed, as hereinbefore provided, be as follows: Charles P. Hatch, representing the Union Pipe Company; A.M. Hughes, representing the Antwerp Pipe Company; and the Oil City Pipe Company; D. O'Day, representing the American Transfer Company; R. B. Allen, representing the Grant Pipe Company; S. D. Carnes, representing the Carnes Pipeline Company; F. Prentice, representing the Relief Pipeline Company; H. Harley, representing the Pennsylvania Transportation Company; E. Hopkins, representing the United Pipelines, Milton Pipeline, and the Sandy Pipelines. _6. Each party hereto shall furnish to the Executive Committee, on or before the 5th of each month, a report of its business for the month next preceding, duly verified by the affidavit of its proper officer or agent, and the amounts found due by the Executive Committee from any of the parties hereto shall be paid by them, through the Executive Committee, to the parties to whom they may be due, on or before the 10th of the month in which the report is made. _7. The committee shall prescribe the form of said return, and shall act as a clearinghouse thereof. They shall have power to verify the same by inspection of books and records, and shall make to each party hereto, on or before the 10th day of each month, a full exhibit of the results of the returns and clearings for the next preceding month. _8. The committee shall prescribe and enforce uniform rates and conditions for the reception, storage, and transportation of oil, including substantially uniform wordings of certificates and gaugers' tickets, uniform conditions for the accepting of tanks owned by other parties, uniform conditions as to responsibility for losses through unavoidable causes, such as lightning, and uniform rates of allowances for shrinkages, until changed by said committee. The rates for transportation shall be as follows: for each 42 gallons remaining after deducting allowance for shrinkage and sediment, viz., from all points which, by any pipelines represented herein, which terminate at Oil City or on the Various railways as hereinbefore described, 30 cents. Excepting, first on oil reached by pipes terminating on the Allegheny Valley Railroad south of Oil City, and north of Parker City. Second on oil from the west side of the Allegheny River. Not pumped from north of Bear Creek. Third on oil pumped from Sheakley to Monterey by the United Lines, and from south of Bear Creek, and north of Sheakley District by the Union and Carnes Lines. All of which shall be 25 cents. But the rates on oil covered by the third exception shall be made 30 cents on ore. Before January 1, 1875. The only remaining exceptions to these rates on such private contracts at different figures, as each party may now have, a list of which together with any special conditions appertaining thereto shall be filed with the Executive Committee on or before September 1, 1874, no new contracts for transportation or storage or tankage shall be made by any party whatever, except at the regular rates as herein fixed, or as shall be, from time to time, fixed by the Executive Committee. All rates less than 30 cents may be at any time advanced to 30 cents by the party subject thereto. Ninth. The committee shall adopt all proper and practicable measures to secure the transportation by each line of a share of the total oil pumped each month by all the lines, equal in percentage to the share of the common fund allotted to each herein, having reference to the facilities of each party for doing the work, they shall assign to each party, and as early in each case as possible, such share of the duty of making extensions and connections with wells as most legitimately appertains to it, or as may be required by the well owner, or by the contracts of each party, but constant reference shall be had to maintaining for each party its share as heretofore described of the total oil to be transported, and to distributing the total cost involved as nearly as practicable in the proportion of the common fund assigned to each, and no other party shall make such improvements except by consent of said committee. The committee shall arrange with a chief gauger and the needful assistants, all of whom shall be under oath to act honestly and impartially, to gauge from time to time all tanks with which the lines of the parties hereto are or may be connected, or car tanks, which they may load, and may collect the expense thereof from the parties hereto in proportion to their respective shares in the common fund, and may also assess upon the trade such reasonable charge for car gauging, or may wholly waive such charge as they may deem judicious. The committee shall have general power to inaugurate and carry into effect any other features than those especially named herein which will not be inconsistent with and which will in their judgment more effectually accomplish the purposes and spirit of the agreement. 10th. The division of the common fund shall be as follows. The United Pipe Lines, 29.5% The Union Pipe Company, 25.5% The Antwerp Pipe Company and Oil City Pipe Company, 7%. The American Transfer Company, 7%. The Grant Pipe Company, 7%. The Carnes Pipeline Company, 7%. The Relief Pipeline Company, 7%. The Pennsylvania Transportation Company, 7%. The Sandy Pipeline and Milton Pipeline, 3%. 11th. All parties hereto agree to faithfully carry out the spirit and purposes of this agreement, and to do nothing between the date of its execution and the date of its taking effect inconsistent therewith, and it is mutually agreed that from the date of its taking effect until it is terminated, any violation thereof by any party will work an injury to the whole interest of not less than $10,000, and if any such violation shall not be fully rectified by the offending party within 30 days after written notice shall have been given to the said offending party by the Executive Committee, through its Secretary. Upon a vote of all of said committee except the representative of the offending party, it is agreed that $10,000 shall be the stipulated and liquidated damages for each and every such violation so unrectified, which damages shall be collected by the Executive Committee, and shall be divided among the other parties hereto in the same relative proportion as the common fund is divided. This contract shall take effect on the first day of October, AD 1874, and shall continue for 2 years, and shall continue after the expiration of said 2 years until after 3 months written notice shall have been given by either of the parties hereto, to the Executive Committee, through its Secretary, of a wish to have it terminate, at the expiration of which notice it shall cease and determine, in witness whereof the parties hereto, by their representatives, have affixed their signatures this 4th day of September, AD 1874. The United Pipelines, J. Vandergrift, George V. Foreman, John Pitcairn, Jr., by George V. Foreman, attorney for themselves and others. The Sandy and Milton Lines, J. Vandergrift, George V. Foreman, John Pitcairn, Jr., by George V. Foreman, attorney. For the Relief Pipeline Company, F. Prentice, President. For the American Transfer Company, Daniel O'Day, Superintendent. For the Union Pipeline Company, Charles P. Hatch, Manager. For the Grant Pipe Company, R. B. Allen, President. For the Carnes Pipeline Company, S. D. Carnes, President. For the Antwerp Pipe Company and the Oil City Pipe Company, E. C. Bradley, President. For the Pennsylvania Transportation Company, Henry Harley, President. Number 23, see page 1141. The Rutter Circular. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, page 363. The New York Central and Hudson River Railway Company, General Freight Agent's Office, Grand Central Depot, New York, September 9, 1874. Dear Sir, commencing October 1, 1874, the following rates on refined and crude oil shall govern all lines. The rates on refined oil from all refineries at Cleveland, Titusville and elsewhere in and adjacent to the oil region shall be as follows. Per barrel. To Boston $2.10. Philadelphia 1.85. Baltimore 1.85. New York 2.00. Net rate on Albany 15 per cent less, from which shall be refunded the amount paid for the transportation of crude oil by rail from the mouth of the pipes to the said refineries, upon the basis of 14 barrels of crude oil to the refineries for every 10 barrels of refined oil forwarded by rail from them, the refineries, to the eastern points named. Settlements of this drawback to be made on the refined oil forwarded during each month. No rebate on these rates will be paid on oil reaching refineries direct by pipes. On crude oil, the rates from all initial points of rail shipments in the oil region shall be as follows. Per barrel. To Boston $1.75. Philadelphia 1.50. Baltimore 1.50. New York 1.50. Net rate on Albany 15 per cent less, from which shall be refunded 22 cents per barrel only on oil coming from pipes, which maintain the agreed rates of pipage. A barrel shall in all cases be computed at 45 gallons. You will observe that under this system the rate is even and fair to all parties, preventing one locality taking advantage of its neighbor by reason of some alleged or real facility it may possess. Oil refiners and shippers have asked the roads from time to time to make all rates even, and they would be satisfied. This scheme does it, and we trust will work satisfactorily to all. Respectfully yours, J. H. Rutter. General Freight Agent Number 24, see page 1148. Standard Oil Company's application for increase of capital stock to $3,500,000 in 1875. To the Secretary of the State of Ohio The undersigned, being a majority of the Board of Directors of the Standard Oil Company of Cleveland, Ohio do hereby certify that on the 10th day of March, AD 1875, at a special meeting of the stockholders of said company held at its office in Cleveland, Cuyahoga County, Ohio, by a vote then and there taken, all the stockholders of said company being present and voting therefore, it was resolved and agreed by each and all of them, that the capital stock of said company be increased the sum of $1 million, thereby making the capital stock of said company $3,500,000, which action of the stockholders was as follows, to wit. Resolved and it is agreed by each and all of us that the capital stock of this company, viz., the Standard Oil Company of Cleveland, Ohio be increased to the sum of $3,500,000 and it is also agreed and the proper officers of this company are hereby instructed to take the requisite steps to so increase said capital stock. John D. Rockefeller, S. V. Harkness, H. M. Flagler, Trustee S. Andrews, J. D. Rockefeller, Agent J. D. Rockefeller, Trustee O. H. Payne, B. Brewster, by J. D. Rockefeller, his attorney T. P. Handy, by J. D. Rockefeller, his attorney O. B. Jennings, by J. D. Rockefeller, his attorney W. M. Rockefeller, by J. D. Rockefeller, his attorney J. A. S. Stanley, by O. H. Payne, his attorney A. M. McGregor, by J. D. Rockefeller, his attorney W. C. Andrews, A. J. Pouch, by J. D. Rockefeller, his attorney F. A. Arter, by J. D. Rockefeller, his attorney P. H. Watson, by H. M. Flagler, his attorney J. A. Bostwick, by J. D. Rockefeller, his attorney J. Huntington, by O. H. Payne, his attorney D. M. Harkness, by H. M. Flagler, his attorney Josiah Macy, by J. D. Rockefeller, his attorney W. H. Macy, by J. D. Rockefeller, his attorney W. G. Wardwell, by H. M. Flagler, his attorney D. P. Eels, by J. D. Rockefeller, his attorney S. F. Barger, by J. D. Rockefeller, his attorney W. H. Vanderbilt, by J. D. Rockefeller, his attorney H. W. Payne, by O. H. Payne, his attorney J. J. Vandergrift, by O. H. Payne, his attorney John Pitcairn, Jr., by O.H. Payne, underscore his attorney underscore, L.G. Harkness, by H.M. Flagler, underscore his attorney underscore. And afterwards said meeting was duly adjourned. H.M. Flagler, underscore secretary underscore. Cleveland, March 10, 1875. And we further certify that the whole amount of such increase of capital stock has been paid to said company in money, that no note, bill, bond, or other security has been taken for the same or any part thereof, and that the credit of the company has not been used directly or indirectly to raise funds to pay the same or any part thereof. Underscore in witness whereof underscore, we hereunto set our names at Cleveland, this 10th day of March, A.D. 1875. John D. Rockefeller, Henry M. Flagler, Samuel Andrews, Oliver H. Payne, Stephen V. Harkness. Number 25, see page 1148. Henry M. Flagler's testimony on the union of the Standard Oil Company with outside refiners in 1874. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, page 291 and page 770. Underscore A. Underscore. The original Standard Oil Company was organized in the early part of 1870. The increased capacity and the acquisition of the Cleveland refineries was, as I remember it, in 1872. It remained at that until 1875 or 1876-85 according to the best of my recollection. Then was consummated a negotiation which had been pending for some 2 years, perhaps, with certain parties in Pittsburgh, Philadelphia, and New York, by which a value was agreed upon, and their refinery property was purchased and the capital of the company was increased a still further sum of $1 million, and they were paid for these properties, and money which they contributed, in the stock of the Standard Oil Company of Ohio. By Mr. Gowan. Underscore Q. Underscore when did the Standard Oil Company of Ohio first enter into an alliance with other refineries? Underscore A. Underscore if you mean, by an alliance, Mr. Gowan, I should say never. Underscore Q. Underscore I am only endeavoring to aid your friends in getting at what they want. Here, I notice, they propose to prove by you I will give it in this way that on account of the disastrous condition of the refining business, the Standard, on October 15, 1874, entered into an alliance with a number of Pittsburgh refineries. Underscore A. Underscore that is more correctly stated by saying that the Standard Oil Company underscore purchased underscore the refineries owned by the parties in Pittsburgh. Underscore Q. Underscore who were they? Underscore A. Underscore Lockhart, Frew, and Company, I think was the company. Wait a moment. It was the Standard Oil Company of Pittsburgh, it being a corporation, and Warden, Frew, and Company, of Philadelphia, and, I should say, Charles Pratt and Company, of New York. Underscore Q. Underscore any others? Underscore A. Underscore that is all. Underscore Q. Underscore all those gentlemen, Warden, Frew, and Company, and the Standard Oil Company of Pittsburgh, Charles Pratt and Company of New York, are now associated with you as parties interested in the present oil trust. Underscore A. Underscore they are stockholders. The property formerly owned by them was at that time purchased by the Standard Oil Company. Underscore Q. Underscore when you speak of purchasing their interest, you do not exclude them from their interest? They united with you and remained as your associates in the business? Underscore A. Underscore if it was not from the fact that ours was a corporation, we might call it a CO partnership. Underscore Q. Underscore they becoming interested in yours, and you in theirs? _A. Sir. Q. And you simply used your name to represent the joint ownership, as it was a corporation? _A. Yes, sir. Number 26, see page 1153. George H. Blanchard's testimony on the breaking up of the pipe pool of 1874. Report of the Special Committee on Railroads, New York Assembly. 1879 Volume 3, pages 3445, 3447 and 3449, 3451. The contract with the Standard Company of April 17, 1874, as I have said, contained nothing inconsistent with our obligations to the Pennsylvania and New York Central Railroads, and the New York Central, under their later contract, and our company, convinced the Pennsylvania Railroad of that fact during the discussions both as to rates and each and every other detail agreed to, but President Jewett thought it better to rely upon the arrangements between the railway companies alone, and decided to avail himself of the 9th clause of the agreement with the Standard Oil Company of April 17, 1874, which provided that either party might terminate it by 6 months' written notice, but that notice might be given by the Standard Company within 30 days after the election of a new Board of Directors of the Erie or Atlantic and Great Western Company. This trunk line oil pool of October 1 being in operation, President Jewett gave notice of the termination of the Standard Agreement of April 1, 1874, on October 31, 1874, which would have terminated in 6 months. It was the 31st of the following May, but an election having in the meantime taken place upon the Atlantic and Great Western Railroad, the Standard Oil Company gave the 30 days' notice it had the right to do on January 13, 1875, which, therefore, terminated the agreement upon February 13, 1875. About 3 months and a half before President Jewett's notice could, under the contract, take effect. The trunk line agreement of October 1, 1874, continued in force, and pool settlements were made thereunder for but 5 months, namely, until the close of February, 1875, during which time the Erie Company paid $31,019.05 and received $6,570.55. Notice of the abandonment of that contract was given by the Erie Company, April 1, 1875, although no statements or monies were exchanged for March, and dissatisfaction with its operations had been expressed by us prior to that time, the reasons therefore being as follows. The higher rates of the pipe pool had stimulated new pipelines, and the Hunter and Cummings line and other small pipes had been completed, or did not maintain the agreed rates of pipage. The Columbia Conduit Company had also been completed to Pittsburgh, in the interest of the Baltimore and Ohio Company, and either acting upon the then policy or advice of that company, or with a desire to be bought out, declined to charge equal rates of pipage or agree to any fixed rates, a fact which threatened the diversion of oil largely to Baltimore, the Baltimore and Ohio Railroad not being in the trunk line oil pool of October 1, 1874, and publicly and frequently announcing its endeavor to divert the oil trade to Baltimore. We also believed that large drawbacks or commissions were paid by the Pennsylvania Railroad to the Empire Line in addition to those provided in our joint pool contract, and our belief has since been confirmed by later knowledge of the fact that the Pennsylvania Railroad paid to the Empire Line about 30% or including the use of cars, and the mileage, being about 10 per cent at current rates of car service, left the commission equal to about 20 per cent, an advantage not possessed by any other shipper or company over any of the northern lines. It was clear that, as the Empire Line added to its already large resources, not only this commission upon the oil business excepting Pittsburgh, but the added profits upon its pipelines, that its combined operation and profit united to control an increasing share of the entire trade and put it in strong financial shape for a control which it subsequently entered upon to absorb also a large refining interest. As the northern trunk lines made no similar arrangements, allowances, or commissions to any forwarder or receiver, and derived no profit from any pipelines, it was clearly unfair to concede them to the Empire Line, and the agreement which gave it these growing advantages was very properly annulled. We also desired the actual transportation of the oil rather than to receive money from others, as we had done during the pool, as their increased business might finally result in a demand for larger percentages if the pool continued. I directed careful examination of our records up to date of the abandonment of this oil pool contract, and upon the authority of General Freight Agent Vilas, state that the net rates charged to the Standard Company during this period to through points were uniform with the rates charged by our lines to other shippers, taking into account, as before stated, the transportation of the crude equivalent to their refineries. The preliminary discussions and general conclusions relating to those new contracts were all with President Jewett, although many of their details were subsequently discussed and suggested by me, and the reasons influencing him to make them have been stated by him in his testimony. I was directed to carry them out, and have from time to time attended meetings at which the rates thereunder were advanced or reduced. I believe those contracts were not concluded until the latter part of April or early in May, and were then dated back to the disruption of the trunk line oil pool, in order to secure our guaranteed proportion of oil shipments from that earlier date and without interruption. The transportation contract continued to guarantee us 50% of the business of the Standard Oil Company, which 50% should not be less than the percentage we had received in the year 1874 of the total arrivals at the seaboard, and at this time, for that reason, the Standard Oil Company had no transportation arrangements with the Pennsylvania Railroad, and this fact and guarantee induced us to disregard the question as to whether or not the Standard Company had similar or other contracts with the New York Central or its connections, our only interest in the question being as to whether rates were equal and if we received our guaranteed share of the oil. There was no understanding or agreement by the Erie Company to my knowledge that the New York Central Company or Pennsylvania Railroad, or either of them, had or had not similar or other contracts with the Standard Oil Company. They were shipping by the New York Central route, and we assumed from their large business, terminal arrangements, etc., that some defined understanding probably regulated such large interests, but we were not consulted as to the terms or conditions of its contracts with other companies if it had any, because we relied upon their responsible guarantee to give us our proportion of the total arrivals of oil at the seaboard and at rates equal to those of other companies, as ample protection to our interests. At the time this transportation contract was made by the Erie Company, other considerations than relief from risks and the equalization of the arrivals at the seaboard bore upon the contracts for an allowance of 10%. It continued to be our belief, since fully confirmed by Mr. Cassatt's testimony, that other shippers via the Empire Line over the Pennsylvania Railroad had at least similar rates and arrangements, to which, on the part of the Erie Company, no objection was offered. It also continued to be the fact that the Empire Line continued to receive in addition to its Probable pipe profits, the same or about the same, large commission. As before, from the Pennsylvania Railroad, and it was believed by the officers of the Erie in making this contract with the Standard Company that the allowance to it of 10% was not much more than one half the allowance then being made by the Pennsylvania Railroad to the Empire Line. In addition thereto, we secured the actual transportation of our full share of the oil, at the agreed rates, without delays or disputes in adjustments, or the preparation or exchange of the pool statements. It maintained the business to New York and provided against any increase to our rival railways or ports, no matter how the territory of oil production might shift or vary, and while under the trunk line pool we could not influence the various shippers to send them oil over our railway or to this city, unless their varying and dissimilar interests all agreed, as they did not, and no matter how much one company might be in deficit, the Standard Company is compelled to send it over our line. The loading and unloading, and taking the risks, were also important items to us as has before been detailed, and relieved us from a class of claims we had paid prior to that time. It was also important to us that by this contract we were explicitly released from large losses when the Great Fire consumed the Weehawken docks in July, 1874. The 9th section of the contract has also been of much value to us. In the delivery of oil to vessels or exporters, the Standard Company assumes all the risks and expenses of delays to ships, and their demurrage, even if it be the fault of the railway by non-delivery. And I have known of cases where this amounted to a large sum. In 1877, when the general and extended railway strikes occurred, this clause also released us beyond doubt from large claims that might otherwise have been urged. The freight rates provided by the railway pool of October 1, 1874, were not changed until October 1, 1875, and my recollection is that it was not until the discussion upon that change that anything was definitely known by any of the trunk lines of the arrangements of the others with the Standard Oil Company. At that meeting the 10 per cent reduction to be allowed the Standard was distinctly understood as due upon its shipments via all the trunk lines in consideration of the facts stated, and it then first came to my knowledge that Warden, Frew, and Company, of Philadelphia, represented the Standard Oil Company, as Charles Pratt and Company represented their crude interests at New York via our line. Number 27, see page 1196. Mr. Flagler's explanation of the commission of 10%er allowed the Standard Oil Company in 1877. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, pages 774-775. I would like the privilege of explaining about that 10%er commission. The railroad companies, as perhaps Mr. Gowan will remember, he at that time having been head of the Reading Railroad, tried and did agree among themselves for divisions of the oil business. I know that they agreed among themselves that a certain percentage of it the New York Central should take, a certain other percentage the Erie should take, a certain other percentage the Pennsylvania Railroad should take, and a certain other percentage the Baltimore and Ohio should take. We were only anxious that uniform rates should be maintained by these roads. All these roads, and each one of the roads, found it impossible to secure the divisions of the business as they had agreed upon. Notwithstanding, we co-operated with them, for we were heartily in favor of its being done and were only seeking for a uniformity of rates by the different roads. But as any gentleman connected with railroad interests well knows, there always is that desire to get more than belongs to the line. That desire kept cropping out in the practical shape of cutting under rates for the sake of getting a little more. Each road feeling that it was not getting enough to ensure its percentage. The Standard Oil Company at that time owned a very large percentage of the entire oil traffic. It was possible for it to do a service for the roads that the roads were unable to do for themselves. That service, however, involved a good many hardships. The practical working of it was this, that at the end of each month, after the arrangement had been made, each of these railroad companies, they first having agreed how they would divide among themselves and not seek to go beyond that certain percentage at the end of each month, each railroad company sent to us a statement of the number of barrels of oil they had transported during the month. It was incumbent upon us during the succeeding month to ship over the road or roads which had received less than its percentage in amount during that following month, sufficient to bring up the deficit of the previous month. Undertaking to do that meant, as I well knew at the time, a responsibility imposed upon us, and an obligation to run refineries at certain localities which perhaps at the time it was unprofitable for us to run. It meant a steady continuance of a large volume of business at periods of time when it might not be profitable to run them, and if the gentlemen of the committee will bear with me just a moment, you will see the difficulties. It was not only the three trunk lines, the New York Central, terminating at Buffalo, the Pennsylvania, terminating at Pittsburgh, and the Baltimore and Ohio, I don't know where, but there came in their western connections. I remember well the New York Central had two, the Lake Shore was its connection west of Buffalo to Cleveland, and the Dunkirk and Allegheny Valley was its western division to the oil region. It was not an easy matter, for we had not only to regard the percentage delivered at the seaboard, but we had to try to keep the Lake Shore satisfied with its proportion, the New York Central's proportion, and the Dunkirk and Allegheny Valley's proportion. As I say, it was no light task, and realizing that, I said to these gentlemen, we will undertake to do this business for you, to secure to each one of you the percentage which we may have agreed upon condition that we are paid for that service a sum which shall be equal to 10% of the rate you receive for doing the business. There were, however, to be added to what I have already stated as an inducement for the railroad companies to pay that commission, other agreements, one of which was that we assumed the risk of loss by fire in transportation. That may seem to be to the gentlemen of the committee a cheap thing to do. But Mr. Gowan understands, as well as I do, that a railroad company cannot divest itself of the obligations by the common law imposed upon it as a common carrier without a special agreement to that effect. We took that risk, and did not collect from the railroad companies, any of them, any losses sustained by fire in transit. We furnished terminal facilities at the seaboard free of charge to the railroad companies, and for all this service the Pennsylvania Railroad agreed to pay us a commission of 10%. We carried out our part of the contract faithfully, and secured to the roads such a division of the traffic as kept them in a state of accord and peace, so far as quantity was concerned, and yet the Pennsylvania Railroad paid to other shippers than ourselves a rebate or a drawback, or whatever you choose to call it, on their shipments, which were exactly equal to the 10% they agreed to pay us. So that in that respect we were not favored at all. Number 28, see page 1196. Correspondence between William Rockefeller and M.R. Scott in October 1877. Commonwealth of Pennsylvania _VS. Pennsylvania Railroad Company. United Pipelines, etc., Testimony. Appendix, pages 734-736. Philadelphia, October 17, 1877. Thomas A. Scott. President, Pennsylvania Railroad Company. Dear Sir, in consideration of the covenants by your company to be performed as hereinafter mentioned, we will agree as follows. First. It having been agreed by the trunk lines that of all the oil shipped by the trunk lines to the cities of New York, Philadelphia, and Baltimore, 63% shall be considered American Samoa, the proportion which would naturally go to the city of New York, and it having been further agreed that of this percentage 1/3 shall be transported over each of the trunk lines having termini in New York, viz., the New York Central, Erie, and Pennsylvania, we agree. Unless the aforesaid division shall be changed by mutual consent of said trunk lines, to ship such quantities of oil over your lines from time to time, as will, when added to the quantities shipped by parties other than ourselves, give your line 1/3 of the shipments to New York by the said trunk lines, or 21% of the whole amount shipped to the 3 cities above named by the said trunk lines, it being understood that in stating the number of barrels for the purpose of making this division or for carrying out any of the other stipulations herein contained, the barrel of 45 gallons of crude shall be the unit, and that each barrel of the usual size of refined oil shall be counted as equal to 1 3/10 barrels of crude. Second. It having been agreed, as we are informed, between your company and the Baltimore and Ohio Railroad Company, that of the remaining 37% of the total shipments aforesaid you should be entitled to transport by lines owned and controlled by your company to Philadelphia and Baltimore, 26%, and the Baltimore and Ohio Railroad Company to Baltimore by its lines 11%. We agree, until these proportions are changed by mutual consent, to ship such quantities to Philadelphia and Baltimore by lines owned and controlled by your company as will, when added to shipments of parties other than ourselves, give for transportation by your lines to Philadelphia and Baltimore, 26% of the total shipments by the 4 trunk lines to the 3 seaboard cities above named. Third. We further agree that the quantity of oil which we will ourselves ship over your line shall not in any calendar year be less than 2 million barrels, based upon an average production of not less than 30,000 barrels per day. If we should fail to give you traffic herein named, we will pay to you a sum equal to the profits which you would have realized upon the quantity in deficit, provided, however, that you will at all times furnish us with transportation, as we may reasonably require it. Fourth. We will, of the proportion of oil going to Philadelphia, refine as much as is practicable in Philadelphia, as we understand that you desire to see the refining capacity of Philadelphia fully employed, and, if needful, increased, and in shipping by your lines, whether to Philadelphia, Baltimore, or New York, we will endeavor to deliver the oil to you at points from which you will have short hauls, and to the extent that we can, we will make the proportion of crude shipped as large as possible, as we understand its transportation to be more profitable to you than that of refined oil. Fifth. We ask, in consideration of the above-named guarantee of business, upon which it is understood we shall pay such rates as may be fixed from time to time by the 4 trunk lines, which rates it is understood shall be so fixed by the trunk lines as to place us on a parity as to cost of transportation with shippers by competing lines, that you shall furnish us promptly all the transportation we may reasonably require, and that you shall allow to, and pay us weekly, such commission on our own shipments and the shipments which we may control, as may be agreed to by your company and the other trunk lines from time to time. This commission, it is understood, has for the present been fixed at 10% or upon the rate, and shall not be fixed at a less percentage, except by mutual agreement of your company and ours, provided that no other shipper of oil by your line shall pay less than the rate fixed for us before such commission is deducted. And no commission shall be allowed any other shipper unless he shall guarantee and furnish you such quantity of oil for shipment as will, after deduction of commission allowed him, realize to you the same amount of profit you realize from our trade. That is, you will not allow any other shipper of oil any part of such commission, unless after such allowance you realize from the total of his business the same total amount of profit you realize from the total of our business, except so far as your company may be compelled to fill certain contracts for transportation made by the Empire Line with refiners and producers, which contracts terminate on or before May 1, 1878, a statement of which shall accompany your reply to this letter, such contracts to be fulfilled. We agree that all the stipulations herein contained shall be carried out by us for the period of 5 years from the date hereof, unless sooner changed or terminated by mutual consent, provided that you advise us in writing within 10 days that your company accept, and will carry out its part of the arrangement for the like term. In entering into this agreement we desire to put ourselves on record as expressing our wish and intention of making our business relations with your company such that not only your main lines but the connecting lines controlled by you, especially the Allegheny Valley Railroad, shall secure the best possible results from the oil traffic consistent with our existing obligations to other transportation interests. We feel that the location of our refineries, all of which can be reached by your lines, should naturally create a close alliance between your company and ours, and that the best results from this important traffic can only be secured to yourselves and ourselves, and, we might add, to the entire petroleum interests of the country, by the establishment of friendly and mutually satisfactory arrangements between us. Yours truly, Standard Oil Company. By William Rockefeller. Vice President Office of the Pennsylvania Railroad Company. Philadelphia, October 17, 1877. William Rockefeller. Vice President, Standard Oil Company. My dear Sir, I am in receipt of your letter of this date, reciting the understanding and agreement to exist between the Pennsylvania Railroad Company and your company for a period of 5 years. I beg leave to say that the same covers the whole basis of the arrangements, and is satisfactory to this company, the provisions of which will be duly carried out by it. Very respectfully yours, Thomas A. Scott. President Number 29, see page 1197. Correspondence between M.R. O'Day and M.R. Cassatt. Commonwealth of Pennsylvania _VS. Pennsylvania Railroad Company. United Pipelines, etc., Testimony. Appendix, pages 732-733. Office of the American Transfer Company. Oil City, Pennsylvania, February 15, 1878. A. J. Cassatt. 3rd Vice President, Philadelphia. Dear Sir, referring to the conversation I had with you in January, I wish to submit the following facts, that our company has at large expense, involving the payment of several $100,000, purchased and created certain pipelines to Pittsburgh, through which we are able not only to protect the Allegheny Valley Road in a paying rate of freight for the oil it carries, but also to secure to that company, by agreement with it, its full proportion of the oil traffic going to Pittsburgh. You are acquainted with the efforts we have put forth in other Directions during the last months in which we have acted in thorough accord with the trunk line interests, and I believe I may say, without egotism, we have, to the extent of our ability, effectually protected their interests in such action. I here repeat what I once stated to you and which I asked you to receive and treat as strictly confidential, that we have been for many months receiving from the New York Central and Erie Railroads certain sums of money, in no instance less than 20 cents per barrel on every barrel of crude oil carried by each of those roads. Operating, as we are doing, with the Standard Oil Company and the trunk lines in every effort to secure for the railroads paying rates of freight on the oil they carry, I am constrained to say to you that, in justice to the interest I represent, we should receive from your company at least 20 cents on each barrel of crude oil you transport. The fruit of cooperation referred to has been fully evidenced in the fact that since last fall your company has received 50 to 60 cents per barrel more freight than was obtained by it prior to our cooperation. In submitting this proposition, I feel I should ask you to let this date from the 1st of November, 1877, but I am willing to accept as a compromise, which is to be regarded as strictly a private one. Between your company and ours, the payment by you of 20 cents per barrel on all crude oil shipments commencing with February 1, 1878. I make this proposition with the full expectation that it will be acceptable to your company, but with the understanding on my part that in so doing, I am not asking as much of the Pennsylvania Road and its connections as I have been and am receiving from the other trunk lines. You are doubtless aware that during the last 2 years a large amount of oil has been shipped to Richmond via the Chesapeake and Ohio Road, and that since the purchase of the Pittsburgh lines by us, not one barrel has been permitted to go in that direction. During the season of 1877, and so long as the Columbia Conduit Company afforded the Baltimore and Ohio Road access to the oil regions, that company, I understood, refused to accept from the other trunk lines, for its proportion of the oil traffic, less than 20% or but after the purchase by us of the Columbia Conduit, you succeeded in arranging with the Baltimore and Ohio for about half as much as they previously claimed. I may add that the Baltimore and Ohio Road are wholly dependent upon us for any oil they may carry. Yours truly. Signed, Daniel O'Day. General Manager Philadelphia, May 15, 1878. R. W. Downing, Controller. Dear Sir I enclose herewith copy of letter from Daniel O'Day, General Manager of the American Transfer Company, which refers to a conversation I had with him in January last in reference to allowing the American Transfer Company a commission of 20 cents per barrel on all crude oil transported over this company's lines to New York, Philadelphia, and Baltimore. I agreed to allow this commission from and after February 1, until further notice, after having seen receipted bills showing that the New York Central Railroad allowed them a commission of 35 cents per barrel and that the Erie Railway allowed them a commission of 20 cents per barrel on Bradford oil, and 30 cents per barrel on all other oil, and that they had been doing so continuously since the 17th of October last. Of this, however, you saw the evidence yourself in the bills which I submitted to you last week. Please, therefore, prepare vouchers in favor of the American Transfer Company per Daniel O'Day, for this commission of 20 cents on shipments during February, March and April, and hereafter make settlements with that company monthly. Yours truly. Signed, A. J. Cassatt. Third Vice President Number 30, see page 1197. Henry M. Flagler's testimony on the rebate paid to the American Transfer Company. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, pages 777-778. _Q. Mr. Cassatt testified and offered in evidence the correspondence which showed that his company agreed to the payment of that 22½ cents to the American Transfer Company on every barrel of crude oil passing over their line in consequence of the fact that the writer of the first letter on behalf of the American Transfer Company had asserted that the New York Central and the New York and Lake Erie roads paid the same amount. You know that to be a fact, do you not? _A. May I explain that now? _Q. You are entitled to make any explanation you wish. _A. The American Transfer Company was built originally for, really, the New York Central Road. The New York Central had no means of getting south of Titusville with its cars. The American Transfer Company's lines were built really in the interest of the New York Central Road. In those days the pipelines purchased the oil and oftentimes sold it at just what they paid for it, and sometimes less. They got more when they could. The New York Central, as I said, paid the American Transfer Company a price, which I presume was the figures named in Mr. Cassatt's testimony, for collecting oil in the lower country and delivering it to the Dunkirk and Allegheny Valley, which is the New York Central's connection. As that pipeline increased its business, the Erie Road did the same thing. Later the Pennsylvania Railroad wanted the service of that pipeline in collecting oil. Mr. O'Day did what I suppose any manager would do. He said to Mr. Cassatt, "If you do the same thing for me that the other roads are doing, I have no objection to making the same arrangement with you." The payment made by the Pennsylvania, the Erie, and the New York Central roads constituted the gross income of the American Transfer Company, out of which it paid its expenses of doing its business and its losses, if it made any, in the purchase and sale of oil. It acted as a factor for those northern roads, and, as I said, was originally built in order that oils might be reached by the New York Central. _Q. But in addition to the sum of 22½ cents, or whatever it may have been, which these trunk lines paid to the American Transfer Company, that company as a transporter of oil through its own pipe got this pipage charge besides? _A. I never so understood it. As I remember the facts in the case, while there was a nominal pipage there might have been, I do not say there was, I do not remember. _Q. You do not say there was? _A. I do not remember. But while there might have been a nominal pipage, that nominal pipage might have been absorbed in the crude oil. In other words, it threw away its nominal pipage and relied. _Q. I am speaking now solely of the relations of the American Transfer Company to the railroads. The former received 22½ cents on every barrel of oil passing over the Pennsylvania Road and the other roads. But the American Transfer Company was a transporter of oil itself, and to the extent it transported oil through its pipes it made charge for that service also. _A. That is a point where I say I want to correct you. While it may have made a nominal charge, about which my memory fails me, I say it threw away that nominal charge by paying to the owner or the producer of the oil the value of the oil at the wells, plus what that pipage might have been, and that 20-odd cents paid by the Pennsylvania constituted its gross revenue. Number 31, see page 1199. Letter to President Scott of the Pennsylvania Railroad from B.B. Campbell and E.G. Patterson. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, pages 363-365. To the President and Directors, Pennsylvania Railroad Company. Gentlemen about July 1 last the undersigned were of a delegation from the oil region of our state, asking of your road an assurance that its course during the preceding 2 months, in giving to all producers and shippers of petroleum equal facilities and impartial rates, might be formally made its permanent policy. In an interview with your President at that time, that assurance was given, coupled with the requisition that such support should be given it by the producers and shippers as would repay it for the exertion it must make in defending that policy, and guaranteeing that such support should be continuous and permanent. The people of the oil region were only too glad to enter into such an agreement, and steps were immediately taken of a practical nature to carry it out. It was understood that it could not be immediately done. After the formal abandonment by the trunk lines of the South Improvement Company in 1872, your road for some months faithfully adhered, as we believe, to the pledge then given by all the trunk lines, that no discrimination should thenceforth be permitted. We believe also that it stood alone among the roads in adhering to it. For gradually the persons constituting the South Improvement Company were placed by the roads in as favorable a position as to rates and facilities as had been stipulated in the original contract with that company. At this time the line of your road in western Pennsylvania, including that under your influence and control, was dotted with refineries capable of producing a large proportion of the refined oil needed by the world. The policy of the Standard Oil Company, the successor in everything but name of the South Improvement Company, has resulted in the dismantling and abandonment of every one of those refineries, as soon as they fell into their possession, which could not be reached by some other and a rival road to yours, and now there are in the oil region proper but few refineries, and those universally owned by the Standard Oil Company, those in Pittsburgh being owned or controlled by that combination or by the Conduit or Empire lines. The use and export of crude oil is but a small proportion of the consumption, and time and money were required to re-establish this great product upon its former basis, and these people were glad to furnish all needed means to accomplish this end. As are also capitalists at other points not strictly within the oil region, yet upon your lines. We are met in the midst of this preparation by assertion of agents of the combination, and as accepted news by the press, that such a combination is entered into, or under consideration by your road and the Empire Transportation Company, the Erie, Central, Lake Shore, and Baltimore roads of the one part, and the Standard Oil Company of the other, as would preclude your road from carrying out the policy announced by your President at the interview heretofore referred to. We believe there is danger that such a result may be reached, and we, in behalf of these whom we represent, in making our efforts to prevent its accomplishment, or if accomplished to defeat it, as the first step, address this communication to you, desiring to present its aspect as affecting your road from our standpoint. So far as we, and the general public are affected, you will not question that the present scheme is but the repetition of the South Improvement Scheme, never abandoned by its authors, and seeking the sole and absolute control of all petroleum produced, purchased, refined, and shipped within the states of Pennsylvania, New York, Ohio, or West Virginia. The overproduction of 1873, 1874, 1875, and the consequent almost entire destruction of petroleum values, gave the Standard Oil Company, with its organization and capital, almost the desired monopoly. The equalization of consumption and production of 1876–1877 brought that combination to the same point that they were in 1872 utterly unable by reason of geographical position, if for no other, to monopolize this product without the cooperation of _all_. The transportation, and then only under a contract similar to that of the South Improvement Company, and including all of its dangerous and extraordinary features. None other can serve them, and so they stand today, and we believe that your road can enter into no compromise, treaty, or arrangement which will serve the ends of the monopoly, under any less stringent stipulations and devoid of the liabilities thereof. Under such an arrangement it is probable that the Central and Erie have transported its oil, during nearly all of this year. It is now an open secret in the producing region, that no charges follow the shipments over at least one of these roads, and crude oil is delivered in New York, on shipping order, at prices which barely repay the cost of packages and contents, with little or no remainder for transportation charges. This aid to the scheme of the combination is possibly given in view of the high tariff and consequent large revenue promised to be derived hereafter, when the scheme has been made a success, and all opposition in trade and transportation extinguished. Suppose your opposition to be withdrawn, and you join the alliance. When does your profit come in? We are entitled to impartiality. As we are advised, the law, common and statute, provides for it. It pronounces those participating in such a scheme conspirators against the public weal, and there is no court upon your line but what will enforce by mandamus and injunction the impartiality that we ask. The combination will promise you an immediate increase of revenue. If we are well advised, will you realize upon that promise? Can you make a contract with them that if we do not succeed in destroying, it will be their interest to keep? You will not have a refinery left, and they are now completing pipelines from Pittsburgh to Oil City, and can deliver the oil received by all their pipelines, independent of your road and its branches. In case of a contract with them executed, but afterwards broken, from what source will you derive your oil traffic, and what court will enforce the broken contract in your favor? We urge that you cannot enter into any arrangement with the monopoly that can be permanently useful to it and to you, and doubt if it can be made temporarily so. Suppose that you decline to enter into such a treaty, or any such scheme, but announce and adhere to the opposite policy. There is no law, not even that of necessity, to compel you to serve the ends of the Standard Oil Company. If Messrs. Vanderbilt and Jewett believe that their aid alone is insufficient to the establishment of the monopoly, for how long will they carry its oil as at present for nothing, when they could have full rates, by uniting the railroad interest, and leaving the Standard Oil Company to do its business in common with all others? If the Pennsylvania Railroad, having the geographical position in its favor, will announce and adhere to the policy of impartial and competitive rates, in 3 or 6 months, it can have all the facilities and extent of business which the Standard Oil Company can give the competitive roads, and by men who have all to gain by so doing. We ask consideration of our views and of our assurance of good results from their favorable consideration. If you choose to place the matter in the light of an experiment, its trial can cost you nothing but the failure to realize upon the immediate fulfillment of the promises of the common enemy, and that realization we believe will not be permitted. Very respectfully, B. B. Campbell, of Pittsburgh. E. G. Patterson, of Titusville. Philadelphia, September 11, 1877. Number 32, see page 1225. Producer's Appeal of 1878 to Governor John F. Hartranft, of Pennsylvania. Proceedings in relation to trusts, House of Representatives, 1888. Report number 3112, pages 351-356. Sir, the undersigned, members of a committee appointed by the General Council of the Petroleum Producers Union for that purpose. Address to you, as the official head of the Commonwealth, a plain statement of facts, to a great extent known to be true from personal knowledge, and all material parts of which are susceptible of proof by competent evidence. We address you, not only as individuals whose personal interests have been affected, whose property has been rendered comparatively valueless, and whose capital and labor are bound against their consent to increasing the gains of grasping corporations, but as citizens of the great Commonwealth of Pennsylvania, apparently prostrate and powerless to control one of its greatest products, and the immense business that annually flows from it. The petroleum production of Pennsylvania is confined geographically to the northwestern portion of the state, extending from its border upon New York State nearly to Pittsburgh, and is the chief interest in the counties of McKean, Warren, Forest, Crawford, Venango, Clarion, Butler, and Armstrong. The amount of money invested in well property, constantly to be renewed and kept good, represents at least $20 millions of dollars, and while the value of the lands upon which the wells are located is not easily determined, it represents many times the value of the well property. Petroleum should yield at the wells, with its transportation and sale unfettered, $25 to $35 million annually, while as an article of export, it ranks third among the products of the nation, and as first among its manufactured exports. For transportation outlets, it has the Pennsylvania Railroad to the seaboard at an average distance therefrom of less than 400 miles. The New York Central and Lake Shore Railroads reach Oil City by way of Cleveland, Ohio, 764 miles from the seaboard, and Titusville, by way of Dunkirk, New York, 571 miles to the seaboard, and the New York, Lake Erie, and Western, and Atlantic and Great Western Railways reach Oil City by way of Meadville, 550 miles to the seaboard. Condition of the trade in 1871. At that time the lines of the Pennsylvania Railroad in the oil region were dotted with refineries located at Tidioute, Henry's Bend, Oleopolis, Oil City, Corry, Titusville, Miller Farm, Rowsville, and other points on the Oil Creek Railroad, at various points on the Philadelphia and Erie Railroad, and on the Allegheny Valley Railroad, these roads being tributaries of and controlled by the Pennsylvania Railroad, while upon its main line extensive refineries were located at Pittsburgh and Philadelphia. The refineries at Cleveland, Ohio, confined themselves in a measure to the western domestic trade, and those of Portland, Boston, and New York had generally specialties in the trade. The markets were filled with buyers of crude and refined information as to stocks, production and consumption was open and obtainable, and values were regulated by the law of supply and demand. In its relation to this trade, western Pennsylvania almost exclusively possessing this product, with ample refineries in its midst, with its great state railroad penetrating the producing region, and by it, having the shortest route to the seaboard, with the Allegheny River as an additional means of transportation to Pittsburgh, the western terminus of the Pennsylvania Railroad, and with Philadelphia, its eastern terminus as an exporting point. Pennsylvania had, and was entitled to, the control of the refining and transportation of its own product. Condition of the trade in 1877-1878. Now, this is all changed. The refineries on the lines of the Pennsylvania Railroad have been demolished, excepting where reached by rival railroads, and this business has been transferred to Cleveland and New York, the refineries remaining in this state having passed into the ownership and control of a foreign organization, as has also the local transportation from the wells by means of pipelines to the lines of the railways. The transportation of every nature is subject to its dictation, it possesses every avenue of information, it affixes its own value to the crude product when purchasing and the refined products when selling, it establishes its own rates of compensation to be paid the railways, and the laws of commerce which govern values in other products are in this a part of the history of the past. So far as the petroleum trade is concerned, an enterprise or investment therein is only a wager as to what step the Standard Oil combination will next take, with the world consuming double the amount of our petroleum that it did in 1871, the 30 millions which should be received from the crude product has dwindled to its half, the 15 millions which should be the profit of Pennsylvania refineries has been transferred to Ohio and New York, and the 20 millions which should have swelled the earnings of the railways have gone no one dare say where, but the colossal fortunes acquired since 1872 by every member, so far as its members are known, of this now world-renowned organization, are proofs of the success attendant upon a scheme, no less unlawful than gigantic, and which has all the outward and visible signs of inward and spiritual corruption. Today, a foreign corporation is the absolute master of the production and its value, of transportation by pipelines, transportation by railroad and the compensation therefore, of storage and refining, and the profit thereof, and dictates prices through the world of the first, or among the first, of the products of Pennsylvania, and of the United States, and this to the impoverishment of thousands of citizens, and the destruction of each of these interests within the state. That this has been accomplished through and by means of the cooperation of the Pennsylvania Railroad, its management and influence, is matter of record. The first attempt to monopolize the trade was initiated by the conveyance, by R.D. Barclay, Thomas A. Scott's private secretary, and S.S. Moon, the legislative agent of the Pennsylvania Railroad, to a party composed principally of Cleveland and New York men, headed by an agent of the New York Central and Erie Railways, of a charter granted by the legislature of Pennsylvania for a different purpose, under which they organized for the seizure of the petroleum trade, retaining the charter title of the South Improvement Company, the then managers thereof being the managers of the organization now known as the Standard Oil Company, with the South Improvement Company, not a member of which lived in the oil region, or was an owner of oil wells or oil lands. The Pennsylvania Railroad hastened to execute a contract, January 18, 1872, giving it the sole and exclusive control of all petroleum shipments thereon, regardless of ownership, and securing this by the payment by the railroad of a rebate or drawback to the South Improvement Company of such a sum as would have inevitably driven all others out of the trade, and lest there might be doubt as to the intent to so do, it was expressly stipulated in the 4th article thereof that was the result aimed at, and the Pennsylvania Railroad therein bound itself, so far as it legally might, to aid in accomplishing it. The action of the legislature and of Congress, and the uprising of the people against this unparalleled iniquity, destroyed the combination for the time being, the railroads having pledged themselves to never attempt a similar outrage. The local transportation of crude petroleum had been gradually changing from movement by barrels to carriage in pipelines, from the wells to tankage located on the lines of railway, the principal of which pipelines, at this time known as the Pennsylvania Transportation Company, formerly Allegheny Transportation Company, was under special charters of the legislature and owned and controlled by Messrs. Scott, of the Pennsylvania, and Fisk and Gould, of the Erie Railways. The legislature had been petitioned at various times since 1866 to pass a free pipe law, but the various bills introduced for that purpose could never overcome the opposition of the Pennsylvania Railroad in the legislature. During the excitement attendant upon the rise and fall of the South Improvement Company scheme, the effort was renewed, and the legislature enacted a law, restricted to the 8 oil-producing counties, but the Pennsylvania Railroad influence was strong enough to exclude Allegheny County from the operation of the act, thus shutting out western Pennsylvania from Pittsburgh, the terminus of the Pennsylvania Railroad, the natural outlet of the oil region, and the natural refining point of the United States. The succeeding efforts to pass a free pipe law, either general in its nature or to permit construction of pipelines to lines of railway within the state, or to include Allegheny County in the law of 1872, have been defeated invariably by the opposition of the Pennsylvania Railroad, and the law of 1874, known as the Wallace Act, was so framed and enacted as to leave it doubtful whether it had not succeeded in withdrawing from the 8 counties referred to all the rights conceded to them by the Act of 1872, a wrong which no subsequent legislature has been able to redress. Under the law of 1872, pipelines owned by citizens in the oil region had been organized and were in operation, giving free access to the railways, but after the passage of the Wallace Act, April 29, 1874, the Standard Combination, which had never really abandoned the South Improvement Scheme, systematically undertook their destruction by forcing them into insolvency and then absorbing them. This required railway cooperation, and various means were employed therein, notably among which is the scheme adopted by the Ring and promulgated by the railroads October 1, 1874. An explanation is necessary to understand why the railroads should unite, first, to carry oil received by them through pipelines that had combined to maintain a given rate for pipage 22 cents per barrel cheaper than on oil received from pipelines not so combining, and second, to further weaken the refineries remaining in western Pennsylvania by depriving them of their geographical advantage of proximity to the crude product, to the coal used as fuel, and to the exporting ports by free transportation of crude petroleum to the ring refineries in other states. Various pipelines had already been forced out of existence, had been bought up and united under the name of the United Pipelines, which was owned, 1/3 by the Standard Oil Company, 1/3 by the Lake Shore and New York Central Railroads, and 1/3 by individuals who were members of and directors in the Standard Oil Company. The Pennsylvania Railroad had as its particular feeder a similar organization, known as the Empire Pipeline. This explains the first point referred to above. The second so far as the Pennsylvania Railroad is concerned, is inexplicable upon any ordinary hypothesis or under any known theory in railroad politics. The scheme was a success. Pipelines one after another succumbed, and refiner after refiner was bankrupted and his works absorbed. This effected the monopoly, backed by the New York railroads, in one of which it exercised unlimited power, felt strong enough to demand of the railroads that it should be given the future sole conduct of the trade under the Old South Improvement Plan. Upon this, the Pennsylvania Railroad apparently awoke to its danger, resisted the demand, and in July 1877, President Scott announced as the policy of the Pennsylvania Railroad open and free trade to all shippers of petroleum. It was then conducting its oil traffic through its ally, the Empire Transportation Company, which possessed a system of pipelines, before referred to, extending over the oil region, controlling a large portion of the production, with ample tankage, with a large rolling stock upon the Pennsylvania Railroad, and owning or controlling a refining capacity nearly equal to one-half the consumption of the world. In the following month, August 1877, immediately after the riots at Pittsburgh, which were in their extent the natural outgrowth of railroad freight discrimination against that city, the monopolists succeeded in convincing the officials of the Pennsylvania Railroad that it was to their or its interests to force the Empire Company, its cars, its pipelines, its tankage, and its refineries into their hands. The people of Western Pennsylvania protested in a communication to the President and directors of the Pennsylvania Railroad in September, before the extent of the proposed iniquity had become fully known to the public, which communication seems never to have reached the Board of Directors. The outrage was finally consummated October 17, 1877, and the Pennsylvania Railroad was left without the control of a foot of pipeline together, a tank to receive, or a still to refine a barrel of petroleum, and without the ability to secure the transportation of one except at the will of men who live and whose interests lie in Ohio and New York. Into those hands had now passed the last refineries of Pennsylvania, the last means of transportation from the wells to the railroads, and the last means of carriage to the markets of this country and of the world. The South Improvement Scheme, less its chartered organization as in 1872, was at last an accomplished fact, and in the successful designing, prosecution, consummation and operation of which it is impossible not to believe that railroad officials were personally interested. Congressional legislation. As the conspiracy was evidently gaining strength, the people of Pennsylvania united in an effort to induce Congress to again interfere as in 1872, and in 1876 it directed an investigation, which was conducted in a dilatory manner by a committee, a prominent member of the Standard Oil Company, and not a member of Congress, presiding behind the seat of the chairman. Vice President Cassatt of the Pennsylvania Railroad was the only prominent railway official who appeared in obedience to the subpoenas of the Speaker of the House of Representatives, and he refused to give the committee any information as to the matter under investigation, and the counsel of the Pennsylvania Railroad, ex-Senator Scott, appeared before the committee in justification of his so doing. The financial officer of the Standard Oil Company appeared before the committee, accompanied by a member of Congress, also a member of that company, and promptly refused to give the committee any information as to the organization, or the names of its members, or its relations with the railroads. The influence and power of the combination was apparent. The committee never reported, never complained of the contempt of its witnesses, and all the evidence and record of its proceedings effectively disappeared. In 1877-78, a bill was introduced by Representative Watson, of Western Pennsylvania, seeking to prevent discrimination in interstate commerce, which has been reported by a committee, but which can hardly overcome the covert opposition which it meets. Recent state legislation. All efforts to obtain a free pipe law in this state having through a series of years proved unavailing, although New York, in its efforts to control the trade in Pennsylvania petroleum, had enacted such a law. A bill was prepared enforcing in this state the third and 7th sections of the 17th article of its Constitution. This bill, known as the Anti-Discrimination Act, provided that shippers of property by carload from any point on a railroad within the state to any other point within the state should be charged equal rates and given equal facilities. Copies of the proposed law were sent to the prominent railroad officials in the state, but its provisions were so fair and protective to every citizen of the state, and to every legitimate railroad interest, that neither before the Judiciary Committee of the Senate, which reported it favorably by an unanimous vote, nor in the Senate, which passed it with but one dissenting voice, nor before the Judiciary Committee of the House, which reported it unanimously, did any railroad stockholder, official, or legislative agent appear to offer an objection to its becoming a law. Yet it was killed in the House by the familiar means employed by legislative agents in disposing of measures objectionable, but not debatable. Had the bill become a law, it would have rebuilt the refineries of the state. With Philadelphia, whose petroleum trade under the monopoly has gradually dwindled to a fraction of its former magnitude, as the exporting point, with the Pennsylvania Railroad as the transporter. There too, and the people of western Pennsylvania might have arisen from a community of miners, working for the benefit, and under the rule, of a foreign corporation, to their former conditions as citizens of a prosperous mining and manufacturing section of the state. Results and effect of the success of the conspiracy. Upon or with the New York railroads, no appeal or representation of the people of this section would have any weight or influence. Their managers reside in Cleveland and New York, and are subject to the daily manipulations of the monopoly managers, while in our own state, to all efforts for emancipation or toward the restoration of trade to its natural channels, the Pennsylvania Railroad and its power is as a Chinese wall. Its president and vice president admit the preferences in rates given to the monopoly, and boldly announce their intent to continue in so doing. They claim the legal right to so do, and challenge resistance. They obstruct all efforts of producers, shippers, and refiners by delaying or restricting facilities, by threatening other railroads with severance of connections and deprivation of general traffic if they transport petroleum for parties outside the monopoly. They refer applicants for rates and facilities over the Pennsylvania Railroad to the Standard Oil Company, and offering their personal service as negotiators for such rates and facilities, assure all that there is no hope of success in the trade unless by a coalition with the Standard. We have thus far given not more than an outline sketch of this enormous monopoly, its plan, its growth, and its results. We have not burdened Your Excellency with details of individual oppression and outrage, but we should fail to discharge our duties to ourselves and as citizens if we neglect to recite some of the means by which the most deplorable results are produced to our state and section. Wrong is constantly perpetuated and right driven from us. True it is that in many things the monopoly has been unwittingly aided in its schemes by unwary concessions as to the management of its business by producers of petroleum themselves, but they had a right, as men pursuing an honest calling, to believe that they were dealing with honest men, and not with a gang of public plunderers, leagued together by no better tie than the sordid desire of gain, to be acquired by methods of corruption and lawlessness. By the theory of the law, corporations derive their powers from the people of the Commonwealth in General Assembly convened. They have no powers not delegated to them by the people. They take nothing by implication. They are public servants, invested for the public benefit with extraordinary privileges, and their charters may be taken from them when they cease to properly perform the duties of their creation. The railroad and pipeline companies are common carriers of freight for all persons, are bound to receive it when offered at convenient and usual places, and to transport it for all. For reasonable compensation, without unreasonable discrimination in favor of any. These are but simple statements of well-established legal principles, never doubted in any court, but affirmed by every tribunal that has ever considered them. Yet the people who granted these special privileges are now upon the defensive, their rights denied by these corporations, and they are challenged to enter the courts to establish them, while in the meantime they are inoperative, to the irreparable injury of their business. They have yielded to the railways that they have created a part of their sovereignty, and given them the right to take private property for public use, but restricting such taking, strictly to such use. Yet where the narrow strip of land used as a railway roadbed runs through valuable oil lands, this combination is strong enough to demand from the railways its transfer to them, that they may and do thereon sink their own oil wells, and thereby drain the oil from the adjoining lands whose owners gave the strip for public use by a railroad. The owners of lands along the line of the Allegheny Valley Railroad, producing petroleum from those lands, with their own pipeline running to their own shipping racks by the side tracks of that railroad, are unable to obtain cars in which to load their product for transportation, at any rate of freight, while their tanks overflow. Shippers of petroleum are refused cars, or are promised them, only to find the promises broken, and their contracts rendered impossible of fulfillment, while the monopoly demands and is given all the cars belonging to the railroads, it permitting its own private cars to meantime stand idle, so that the railroads may assert its inability to accommodate all owners of tanks connected with the monopoly pipelines, with ample storage therein for their own product, are refused transportation from their own wells upon the ground that their tanks are full, a barefaced and daily demonstrated falsehood. Other producers of petroleum are refused transportation by the pipelines, on the plea of want of capacity to carry, and at the same time are informed that their oil will be carried if they will sell it to the ring immediate shipment. If the applicant's tanks are overflowing, or if he needs money and complies with their terms, he is offered a price from 2.5 to 25 cents below the market value. If he accepts and sells a fixed amount of his oil, the pipeline removes all but 5 or 10 barrels, delays for days and weeks to take the remainder, and refuses to pay for any until all is taken. This is known as the immediate shipment swindle. By their use of the petroleum of others stored in their tanks and lines, by the overissue of pipeline certificates, by refusal to perform their public duties, by open defiance of the law and impudent evasions of its provisions, the pipeline and railroad companies leave to the people, whose creatures they are, but two remedies: an appeal for protection, first to the law of the land, next to the higher law of nature. These corporations have made themselves the interested tools of a monopoly that has become the buyer, the carrier, the manufacturer, and the seller of this product of immense value. It needs no argument or illustration to convince that in such a position this foreign corporation is in direct antagonism to the producer, the laborer and the consumer. The South Improvement Conspiracy embraced in its scheme the ownership of the oil-producing territory, wells, and machinery. If the present course of its successor cannot be stayed, it is merely a question of time when the ownership of the entire oil production will fall into its hands through the impoverishment of thousands of our citizens and their inability to contend longer. That monopolies are dangerous to free institutions is a political maxim so old as to have lost its force by irrelevant repetition, but if anything were needed to awaken the public sense to its truth, the immediate effect of this giant combination is before us. Throughout The oil region, as wherever it does business, it now has its own acid works, glue factories, hardware stores and barrel works. We have seen that it is master of the railroads, and owns and controls all the refineries, all the pipelines. All these enumerated industries controlled by them employ large numbers of laborers, dependent for the support of themselves and their families upon the daily labor given or withheld by this powerful conspirator. At the flash of the telegraphic message from Cleveland, Ohio, hundreds of men have been thrown out of employment on a few hours' notice and kept for weeks in a state of semi-starvation and justifiable discontent, deceived meanwhile with delusive promises of work, until the autocrat of a foreign corporation, maintained and upheld by the chief among Pennsylvania corporations, gives leave from within the borders of a foreign state for the Pennsylvania laborer to earn his bread. Along the valley of Oil Creek and the Allegheny Valley, where a few years since the smoke of busy refineries and their attendant industries darkened the air, piles of rusted iron and heaps of demolished brickwork mark the results of the conspiracy, where a few years since busy men crowded to and fro in the pursuit of lawful trade in a great staple, there is now silence and emptiness. The producer, once surrounded with competitive buyers of his product, now goes with crowds of his fellow victims to wait his turn for leave to sell it at a dictated price to a single agent of a single purchaser. To permit to stand unattacked the foul principles of such an organization, to permit them to be fastened as lawful or right upon the policy of the Commonwealth or the nation, is to lay the foundation for the exile of capital, endless injury to the public interests, endless oppression of the laborer, riots, tumults, and the decay of the state. So far as this public wrong is within the scope of executive interference, we ask that immediate steps be taken to enforce by legislative enactment the wise provisions of our state constitution, and by such legal processes as are necessary, compel obedience to law and the performance by chartered companies of their public duties. B. B. Campbell, of Pittsburgh. E. W. Codington, of Bradford, McKean County. Lewis Emery, Jr., of Bradford, McKean County. George H. Graham, of Petrolia, Butler County. J. A. Vera, of St. Petersburg, Clarion County. H. O. Robbins, of Turkey City, Clarion County. L. H. Smith, Petrolia. R. B. Brown, Clarion. D. S. Criswell, Oil City. A. J. Salisbury, Carnes City. A. N. Perrin, Titusville, Crawford County. W. B. Benedict, Enterprise, Warren County. H. W. Bumpus, Monroe, Clarion County. Samuel Q. Brown, Pleasantville, Venango County. Number 33, see page 1233. Statement of crude oil shipments by Green Line during the months of February and March, 1878, to New York, Philadelphia, and Baltimore. Showing drawbacks allowed to American Transfer Company. Commonwealth of Pennsylvania vs. Pennsylvania Railroad Company. United Pipelines, etc. Testimony. Appendix, page 737. Shipper. Consignee. Destination. Total. No. Of barrels. Barrels. February. March. H.C. Olin H.H. Olin Compa 18,320 11,556 29,876. W.H. Nicholson. 16,983 31,169 1/2 48,152 1/2. E. N. Hollock. 1,160 1/2 1,160 1/2. S. Craig. 2,384 1/2 2,384 1/2. H. L. Taylor and Co 1,439 1/2 1,439 1/2. Heirs, Lombard. And Co 2,688 1/2 2,688 1/2. J. Rousseau J. Rousseau. 6,377 1/2 6,932 1/2 13,310. W. L. Fox. 3,150 1/2 3,150 1/2. W. H. Nicholson Heirs, Lombard. And Co 979 1/2 979 1/2. J. A. Bostwick J. A. Bostwick. N.C.O. And Co 43,074 45,915 1/2 88,989 1/2. D. Grimm J. N. O. Ellis and Co 722 1/2 1,185 1/2 1908. 87,617 106,422 194,039. J. Bushnell Warden, Frew and Philadelphia. Co 1,725 1/2 22,105 1/2 23,831. J. A. Bostwick. And Co 12,994 12,994. J. Bushnell Atlantic. Ref. Co 10,137 31,917 42,054. J. Bushnell W. L. Elkins and Co 14,684 7,793 22,477. G. M. Robinson. 761 1/2 1382 2,143 1/2. E. N. Hollock Greenwich. Refining Co 3,413 1/2 3,414 1/2. Mary R. Fox. 1308 1308. S. Craig. 1,241 1/2 1,241 1/2. Fox and Fink. 2,541 2,541. Fox Estate. 501 501. M. Lloyd. 3,803 2,696 493. S. Craig. 2,426 2,426. W. L. Fox. 1,960 1/2 1,960 1/2. G. M. Robinson F. Farnsworth. 362 1/2 84 42 1/2. W. G. Laird. W. G. Laird. Agent 302 302. Payne, Abbott and Payne, Abbott and Co. Co 403 403. J. S. Davis J. S. Davis. 501 501. A. And GWRRA. And B. Cooley. And Co 2525. 51,135 1/2 73,922 125,057 1/2. J. Bushnell Balto. United Balto. Oil Co 7,435 16,692 1/2 24,127 1/2. G. M. Robinson. 261 1/2 261 1/2. E. J. Waring and E. J. Waring and Co. Co. Care of S.E. Poultney 282 282. 7,717 16,954 24,671. Equals Grand total 146,469 1/2 197,298 343,767 1/2. Total 343,767 1/2 barrels at 20 cents per barrel, $68,753.50. This amount, $68,753.50 to be paid to American Transfer Company, per Daniel O'Day, General Manager. Audited May 29, 1878. Ghd. Approved. A.J. Cassette. _3rd Vice President _ Number 34, see page 1239. Bill of Particulars of Evidence to be offered by the Commonwealth. In the case of Commonwealth of Pennsylvania _vs. John D. Rockefeller, William Rockefeller, Jabez A. Bostwick, Daniel O'Day, William G. Warden, Charles Lockhart, Henry M. Flagler, Jacob J. Vandergrift, Charles Pratt, and George W. Gertie, in the Court of Quarter Sessions of the Peace for the County of Clarion, Pennsylvania, 1879. First count. First. That each one of the defendants is associated with each and all others, in business, by means of stock, issued to each, of several corporations, to wit, the Standard Oil Company of Cleveland, Ohio, the Standard Oil Company of Pittsburgh, Pennsylvania, the Acme Oil Company of Titusville, Pennsylvania, the Imperial Refining Company of Oil City, Pennsylvania, the Camden Consolidated Oil Company of West Virginia, the DeVoe Manufacturing Company of New York. Second. That Charles Pratt is associated in business with others under the name of Charles Pratt and Company, that William G. Warden and Charles Lockhart are associated in business with others under the firm name of Lockhart and Frew, and Warden, Frew, and Company. That J. A. Bostwick is associated with others in business under the name of J. A. Bostwick and Company. Third. That the several defendants and others now unknown are associated together by means of the corporate and CO partnership organizations stated in paragraphs 1 and 2 for the purpose of carrying on the business of refining crude petroleum and selling the refined product. That each of the said defendants is interested in each of the several corporations and firms in refining and selling refined petroleum, and, in refining and selling, the said defendants, each and all, act in concert and harmony with each other, and as against all other persons not associated with them, and share in the profits of the business. Fourth. That the said several defendants, and all of them, and they said several firms and corporations of which they and each of them are members, by stock ownership or otherwise, are engaged in the business of buying crude petroleum, in the county of Clarion, in the state of Pennsylvania, and also in the counties of Armstrong, Butler, Crawford, Forest, McKean, Venango, and Warren, in the state of Pennsylvania, also in the counties of Allegheny and Philadelphia, in said state, and in the counties of Cattaraugus and New York, in the state of New York, also in the city of Cleveland in the state of Ohio, and in counties in the state of West Virginia. Fifth. That in the said several states and counties, and in divers localities in said several states and counties, to wit, at Pittsburgh, Philadelphia, Butler, Carbon Center, Millerstown, Petrolia, Parker's Landing, Foxbug, Turkey City, Edenbug, Shippensville, Pickwick, Elk City, Monterey, Emlenton, Bullion, Scrubgrass, Forster Station, Oil City, Franklin, Reno, Rouseville, Titusville, Warren, Tidioute, Hickory, Bradford, DeGolia, Derrick City, Gilmore, Forster Brook, and Tarport, in the state of Pennsylvania, Knapp Creek, Rock City, 4 Mile, 2 Mile, Olean, Carrollton, Salamanca, and in the city of New York, in the state of New York, the said defendants, and the several firms and corporations with which they are associated and in which they were interested, carried on the business of buying crude petroleum from producers and owners thereof, and the business of refining said crude petroleum, and selling the refined product, and in so doing, acted in concert. _6th. That the said business therein before referred to was so carried on at the several counties, cities, localities, and in the several states aforesaid, by the said defendants in concert, in person, and through agents acting under the instructions of the said defendants, and pursuant to their directions. _7th. That the said defendants were engaged, and are engaged, in the business of transporting crude petroleum through iron pipes, in the counties of Allegheny, Armstrong, Butler, Clarion, Crawford, Forest, McKean, Warren, and Venango, in the state of Pennsylvania, and the county of Cattaraugus, in the state of New York. That they are so engaged by being associated together in the ownership of several pipelines, such association being accomplished by the said defendants being owners of shares of stock in incorporated companies, to wit, the United Pipeline and American Transfer Company, an interest in capital and limited partnerships, to wit, the Tityute and Titusville Pipe Companies, Limited, and others. Which said companies, the said defendants, at the time of the conspiracy and combination charged in the indictment, controlled, and thereby controlled the transportation of crude petroleum from wells and points of storage in said several counties and at the said several localities. _8th. That the said defendants, and each of them, and the said several corporations, firms, and limited partnerships, were and are engaged by means of the ownership and control of said several firms, limited partnerships, and corporations, and by means of ownership of stock and interests therein, were and are engaged in the business of storing crude petroleum in the said several localities, cities, counties and states, by means of storage tanks, and said business was carried on in said counties, each and all of them, by themselves, personally, and also through agents acting by their directions. _9th. That each one of the said defendants and all of them in concert were engaged in the several kinds of business hereinbefore referred to, by themselves and their agents in the county of Clarion, and in the other places mentioned hereinbefore, during the whole period of 2 years prior to the day upon which the indictment was found against them in this case, and during that time by themselves and their agents acting under their directions in the said county of Clarion, combined, confederated and conspired together to cheat and defraud numerous citizens of the county of Clarion, to wit, J. A. Vera, William L. Fox, and M. L. Lockwood, and divers others, and to cheat and defraud the public by securing to themselves a monopoly of the business and occupation of buying and selling crude petroleum in the county of Clarion, and to prevent all other persons engaged in said business, from making, receiving and obtaining the fair value, profit, price, and return from such business, by fraudulent devices, practices, and secret contrivances, and among others the following. _A. Falsely pretending during the times aforesaid and at all times, that the storage tanks owned and controlled by them, and of which they had the possession, measurement, and accounts, were full of crude petroleum to the extent of the capacity of said tanks, and that the said defendants could not receive and store crude petroleum from and for citizens of Clarion County and the other counties and localities named, when in truth such representations and statements were false, and thereby divers citizens lost oil and were compelled to sell petroleum at less than the value thereof. _B. By representing to divers citizens of the county of Clarion, engaged in the business of producing, buying and selling petroleum, and to divers other persons engaged in said business in the other counties and localities named, that the said defendants were enabled to receive and transport for said well owners, citizens and producers of such petroleum, by reason of lack of capacity and transportation facilities, when in fact said representations were false, and thereby divers producers, dealers and well owners were compelled to sell petroleum at less than the value thereof. C. That said defendants by themselves and their agents within the county of Clarion, in the state of Pennsylvania, and at the other counties, cities, and localities, hereinbefore named, had the control of the entire transportation of crude petroleum from the producing wells and districts, and the control of storing of crude petroleum produced, that they and the several firms and corporations of which they were members, and their agents and the agents of said firms and corporations acting under the direction of the said defendants, corruptly and oppressively used the power and control they so as aforesaid held, to compel producers and owners of petroleum to sell the same to them, the said defendants, their agents, and the several firms and corporations aforesaid and their agents, and to sell the said crude petroleum at less than its value, and less than the market price thereof. D. That the said defendants and each of them, through the several firms and corporations of which they were members, and by their agents acting under their directions and the agents of the said firms and corporations, corruptly and oppressively used the power so acquired by them to enable them to become the sole buyers and refiners of crude petroleum. E. That among the means used to obtain control of the business of transporting crude petroleum were the following. First. The said defendants and the several firms and corporations of which they were members laid iron pipes in the county of Clarion, and the other counties and states named, under charters and pretended charters from the state of Pennsylvania, pretending that they so did for the purpose of transporting for the public petroleum from the oil wells and producing districts, to the railroads, for shipment to the seaboard, when in fact the said pipelines were not laid for that purpose, but for the purpose of transporting oil for the said defendants, and the said several firms and corporations of which they were the members, and not for the public, and to enable the said defendants and the said firms and corporations to dictate the rate of freight to be charged to them by the railroad companies engaged in the business of carrying petroleum as common carriers, and to force the said railroad companies to charge a greater and unreasonably high rate of freight to all others, and that this was for the purpose of preventing citizens of Clarion County and the public from engaging in the business of buying, selling and shipping crude petroleum. Second. The said defendants, and their agents acting under their directions, and the several firms and corporations of which they were members also so acting, pretended, and represented to the several railroad companies engaged in the transportation of petroleum, and to the agents and officers of said companies, that they, the said defendants and the several firms and corporations of which they were members, and in which they were interested, controlled the shipments of said crude and refined petroleum, by deliveries thereof to the said railroad companies, and that the said defendants were enabled to withhold, and drive said traffic and business from them. Said representations were false, but by means thereof, they said defendants, procured and obtained from said several railroad companies enormous and unjust rebates, commissions, and deductions from the rates of freight charged to citizens of Clarion County and the public. The citizens of Clarion County and the public were thereby prevented from engaging in the business of producing and shipping crude petroleum. Third. That on or about the 30th day of August, 1877, and again on or about the 17th day of October, 1877, the said defendants met together in the city of Philadelphia and then and there agreed together that they would represent to the officers of the Pennsylvania Railroad Company that they, the said defendants, and the several firms and corporations of which they were members, could and would control and guarantee to the said railroad company a certain proportion of the carrying traffic of crude petroleum over said railroad. And on or about the same dates the said defendants further agreed together and did represent to the officers of the New York, Lake, Erie and Western Railroad Company, and to the officers of the Erie Railroad Company, and to Mr. Jewett, receiver of the Erie Railroad Company, and to the officers of the New York Central and Hudson River Railroad Company, and to the officers of the Atlantic and Great Western Railroad Company, and to V. H. Devereux, receiver thereof, and to the officers of the Michigan Southern and Lake Shore Railroad Company, and to the officers of the Baltimore and Ohio Railroad Company, that they the said defendants and the several firms and corporations of which they were members, could and would control and guarantee to each of them a certain proportion of the carrying traffic of the crude petroleum over said railroads, respectively. But by reason thereof the said Pennsylvania Railroad Company and the Empire Transportation Company were induced to, and did sell, transfer, mortgage and dispose of, to said defendants and to the several corporations and firms of which they were members, all of the pipelines, crude oil cars and transportation equipment, of which they had control or ownership in the oil regions of Pennsylvania, including the county of Clarion, and all the refineries, for refining crude petroleum, of which they had ownership or control. Fourth. The objects and purposes of said representations and said transfer were to enable the said defendants to control the business of buying and selling crude and refined petroleum, and the transportation and storage thereof. Fifth. That, as stated in the foregoing paragraphs, during the greater part of the year of 1877, and for some time previously, they Pennsylvania Railroad Company owned or controlled through its shipping agents, the Empire Line, a full and complete system of pipelines throughout the counties of Clarion, Armstrong, and Butler. Known as the Empire Line, numerous and well-appointed tank oil cars. The shortest and best route to the seaboard over its own lines and the Allegheny Valley Railroad, and other connecting lines, also controlled large and complete refineries, situated in Pittsburgh, Philadelphia and New York, and was by these means a competitor with the defendants and the several corporations owned by them, in the business of piping, transporting, buying and refining crude oil, enabling producers, citizens of Clarion County and elsewhere, without difficulty, to have their oil piped and transported, and to sell the same at enhanced prices, owing to competition. That the defendants, combining and conspiring to monopolize the entire and sole business of buying, selling and refining oil in Clarion County and elsewhere, did demand of the Empire Line and the Pennsylvania Railroad Company that they and each of them should abandon and desist from the said business of buying, selling and refining oil, and that the said Railroad Company and Empire Line should grant to them exclusively large rebates and low or cheap rates of transportation of oil, and by means of withdrawing and procuring others to withdraw the transportation of crude and refined oil over and along said Pennsylvania Railroad, and by means of the procuring from other railroads exclusive rebates and low rates of freight for transportation below a fair and just compensation for such transportation did compel the said Pennsylvania Railroad Company and the Empire Line to sell to said defendants, or to some of the corporations controlled and owned by them, said pipeline, tank cars, and refineries, to the injury of the producers of oil of Clarion County and elsewhere, by depriving them of the benefit of competition in buying, piping, storing or refining this crude oil. Sixth. That the defendants and others combined and confederated with them did conspire to monopolize the entire and exclusive Business of refining crude petroleum in Clarion County and elsewhere. By means of throwing quantities of refined oil on the market and selling the same at less price than the fair market value of the same in the vicinity of independent refiners in Clarion County and elsewhere, and by means of such sales did compel such refineries to sell out to companies with which defendants were connected, or to abandon or quit the business of refining. _7th. That the said defendants did with others conspire together to purchase all the pipelines for the transportation of oil within the producing oil region and all the refineries for the refining of oil, for the purpose of controlling the price of oil and compelling the oil producers of Clarion County and elsewhere to sell their oil to the said defendants at ruinous low rates far below the value thereof and the price that could have been obtained for the same in a competitive market. _8th. Although the said representations were false, the said defendants and the several firms and corporations of which they were members procured the control of the business of producing, buying, and selling crude petroleum, and of about 90% thereof, by following acts done in furtherance of the agreements aforesaid. _A. To buy only petroleum for immediate shipment from the wells of producers. And when so bought they refused to remove it. It was so bought at less than its value and market price, and the producers of petroleum were compelled to sell the same by reason of the false representations as to capacity, storage, and transportation hereinbefore fully set forth. _B. By giving themselves and procuring for themselves exorbitant and unreasonable rebates, commissions, and allowances from the railroads and pipelines owned and controlled by them, which rebates, commissions, and allowance could not be procured by any other than the said defendants and the several firms and corporations of which they were members. _C. By impeding transportation by railroads, procuring them to refuse and delay cars for shipment of petroleum, procuring they breaking connections with connecting railroad lines, refusing and procuring the refusal of railroad companies and pipelines to receive and transport petroleum, by refusals and procuring refusals to store petroleum, by refusing and procuring the refusal of railroad companies to furnish side tracks, cars and transportation facilities to pipeline companies other than those of the defendants, and to individuals, by selling refined petroleum at less than the cost of manufacture, by carrying and storing oil at less than the cost of transportation and storage, by thereby forcing competing lines to sell to them at a loss, by issuing certificates or accepted orders of pipeline companies in violation of law not representing the petroleum in the custody of said corporations of the said defendants, and placing such certificates upon the market, thereby causing an apparent increase in the quantity of oil in the market for sale and depressing the price of crude petroleum by making false and fictitious reports of stock of petroleum in the custody of the United Pipelines, a corporation of which the defendants are the owners and which they control, by violating the laws relative to making reports of business of the said pipeline company, by neglecting and refusing to make the required oath thereto, by destroying refineries purchased by them at less than their value, of those they had compelled to sell to them by the fraudulent acts aforesaid, by hiring and paying salaries to men to remain out of business for a term of years, and to act as spies for the said defendants and the corporations and firms of which they are members, by selling crude and refined petroleum at less than its cost to them, by increasing the production by entering into agreements relative to the price the said defendants and the corporations and firms of which they were members, by threatening common carriers with destruction of the business of carrying oil, if they carried for others than themselves, and those associated with them, or permitted other pipeline companies to deliver petroleum to them, or railroads to carry to them, by means of said threats to prevent the building or operation of competing lines of pipe or railroad for transportation of petroleum, by refusing to store petroleum in tanks owned by individuals for them, and by filling such tanks with their own oil, thereby causing a waste and loss both of petroleum and in the price obtained, by refusals to the citizens of Clarion County and elsewhere, at the several localities named, to transport or store crude petroleum. Second count. All of the evidence hereinbefore offered in support of the first count. Third count. All of the evidence hereinbefore stated to be offered in support of the first and second counts, and, in addition thereto, evidence of purchase of refineries under false representations, that refiners were forced to sell by reasons of enormous rebates fraudulently obtained from railroad companies, as hereinbefore stated, the business being thereby, and not otherwise, rendered unprofitable to such refineries as could not obtain said rebates, commissions and allowances, they being all in the said business, except the said defendants, and the firms and corporations of which they were members. Fourth count. All the evidence hereinbefore stated to be offered in support of the first, second, and the third counts, and, in addition thereto, that the said defendants and their agents diverted traffic from the Allegheny Valley Railroad Company by threatening the said company and those who were delivering petroleum to it for transportation with loss and injury to their business, and by shipping themselves over other railroads, unless the said Allegheny Valley Railroad Company would allow them exorbitant rebates, commissions and allowances upon petroleum carried, that other dealers and shippers could not obtain. Fifth count. All the evidence hereinbefore stated to be offered in support of the first, second, third, and fourth counts, and, in addition thereto, that the traffic was diverted from the Pennsylvania Railroad Company, a common carrier, by the same means, devices and threats as hereinbefore stated. Sixth, seventh, and eighth counts. All the evidence hereinbefore stated to be offered as the first, second, third, fourth, and fifth counts. Number 35, see page 1253. Contract of Petroleum Producers Union with Standard Combination. From A History of the Organization, Purposes, and Transactions of the General Council of the Petroleum Producers Unions, and of the suits and prosecutions instituted by it from 1878 to 1880, pages 41-44. Articles of Agreement made the 29th day of January, 1880, by and between the Standard Oil Company, a corporation of the state of Ohio, the Standard Oil Company of Pittsburgh, a corporation of the state of Pennsylvania, the Imperial Refining Company, Limited, of Oil City, Pennsylvania, the Acme Oil Company of New York and Pennsylvania, the Atlantic Refining Company of Philadelphia, the American Transfer Company, the United Pipelines, a corporation of Pennsylvania, the DeVoe Manufacturing Company of New York, the Eclipse Lubricating Oil Company, Limited, of Franklin, Pennsylvania. J. D. Rockefeller, William Rockefeller, H. M. Flagler, William G. Warden, Charles Lockhart, William Frew, Charles Pratt, Henry H. Rogers, Jabez A. Bostwick, Jacob J. Vandergrift, O. H. Payne, John D. Archbold, respectively, buyers, refiners and carriers of petroleum, parties of the first part, each, however, contracting severally for himself, themselves, or itself, and not one for the others, and Benjamin B. Campbell, for himself and as President of the General Council of Petroleum Producers Union, and for the members thereof as shall signify their assent hereto by signing this agreement within 60 days from the date thereof, the parties of The second part, each contracting severally and in the manner aforesaid, witnesseth. Whereas the several parties above named have been and are now engaged in some one or all of the branches of business connected with the petroleum trade, in buying, selling, shipping, storing, refining, transporting, and producing petroleum, and controversies have arisen between the said parties of the first and second part, hereinbefore named, out of which have grown certain suits, hereinafter named, and it is desirable to amicably adjust said controversies and settle said suits and proceedings. Therefore, it is hereby agreed between the said parties of the first and second parts, that the said parties of the first part shall and will make no opposition to an entire abrogation of the system of rebates, drawbacks and secret rates of freight in the transportation of petroleum on the railroads. 2. That said parties of the first part further agree that the railroad companies may make known to the other shippers of petroleum on their several roads all the rates of freight, and that said parties of the first part or any of them will not receive any rebate or drawback that the railroad companies are not at liberty to give to other shippers of petroleum. 3. The said parties of the first part further agree that so far as the said pipelines are concerned there shall be no discrimination used or permitted by the said pipeline companies between or against their patrons, that the rates of pipage and storage shall be reasonable, uniform, and equal to all parties, and shall not be advanced except on 30 days' notice, that to the extent of their influence the United Pipelines and the other companies' parties hereto do agree that there shall be no difference in the price of crude oil between one district and another, excepting such as may be based upon a difference in quality, to be determined by tests, that the said pipelines will make every reasonable effort to receive, transport, store, and deliver all oil tendered them, and will receive, transport, store and deliver all oil so tendered so long as the production does not exceed an average of 65,000 barrels per day during 15 consecutive days. Unforeseen emergencies and unavoidable accidents excepted, and if the production shall exceed the amount stated, and also the storage capacity of the pipelines, the parties of the first part, buyers of oil, agree that they will not purchase any so-called immediate shipment oil, at a lower price than the price of certificate oil, provided that the owners of immediate shipment oil in the oil region do not sell to any other party or parties at a lower price. 4. And all the parties of the first part further agree that until the production of oil reaches the daily maximum of 65,000 barrels as aforesaid, certificates or other vouchers will be given for all oil taken into the custody of the pipelines, and the transfer of such certificates or other vouchers in the usual manner shall be considered as a delivery of the oil mentioned therein as between the pipelines and the seller, subject to the provisions of such certificate or other vouchers. In consideration of the agreement hereinbefore set forth, and of the execution thereof by the first parties, the said second parties do hereby agree as follows: that the Governor and Attorney General of the Commonwealth of Pennsylvania shall be requested by them within 10 days of the execution hereof, to enter a motion to dismiss the bill filed by the Commonwealth of Pennsylvania against the United Pipelines and others at number 309, October and November term, 1878, in the Supreme Court of Pennsylvania, and the proceedings by _quo warrant to number 12, November term, 1878, in Venango County, and will do all that may be lawfully done to have the same dismissed of record. That, upon written motion and agreement, the Supreme Court of Pennsylvania may make of record by consent of both parties, an order discharging the rules to show cause in the case of the Commonwealth _vs. Rockefeller _etal_ granted by E. M. Paxson on the 11th day of December, 1879, and made returnable January 5, 1880, and annulling the order staying proceedings made by the Supreme Court on the 8th day of January, 1880. It is further agreed that this agreement shall, upon execution thereof by the parties, be a full release and satisfaction between the parties of all causes of action of any and every kind whatsoever, arising out of the past transactions involved in the said several suits, controversies, or prosecutions, or incident thereto, so far as the parties hereto or any of them are in any manner interested or have any cause or rights of action for or against each other. And it is hereby further agreed that the Court of Quarter Sessions of Clarion County be, and they are hereby respectfully requested to give their consent to the entering of a _null prosequi _ in the case of the Commonwealth of Pennsylvania _vs. John D. Rockefeller _etal_ of April Sessions, 1879, number 25, in which the defendants named in said case are charged with conspiracy, and the District Attorney of said county is hereby requested, on receiving the consent of the said court, to enter in said case a _null prosequi _ and the same to be entered of record in said court, with the intent that the same be a judgment of said court disposing of and ending all proceedings under indictment hereinbefore referred to, forever. In witness whereof the aforesaid parties to these presents have hereunto set their hands and seals, the said corporations having caused their seals to be affixed this 5th day of February, A.D. 1880. Standard Oil Company, by seal, John D. Rockefeller, President L.S. Attest, H. M. Flagler, L.S. John D. Rockefeller, L.S. O. H. Payne, L.S. United Pipelines, by seal, J. J. Vandergrift, President L.S. Attest, H. M. Hughes, Secretary L.S. Henry M. Flagler, L.S. J. J. Vandergrift, L.S. William Rockefeller, L.S. Imperial Refining Company, Limited, by seal, J. J. Vandergrift, Chairman L.S. Attest, D. McIntosh, Secretary L.S. Eclipse Lubricating Oil Company, Limited, by Thomas Brown, Chairman L.S. F. Q. Barstow, Secretary L.S. Standard Oil Company, by seal, Charles Lockhart, President L.S. A. F. Brooks, Secretary L.S. W. G. Warden, L.S. Charles Lockhart, L.S. The Atlantic Refining Company, by Charles Lockhart, President L.S. Charles Pratt, L.S. Henry H. Rogers, L.S. Acme Oil Company, by John D. Archbold, President L.S. Attest, George F. Chester, Secretary L.S. John D. Archbold, L.S. American Transfer Company, by George H. V. Laws, President L.S. Attest, George F. Chester, Secretary L.S. J. A. Bostwick, L.S. B. B. Campbell, L.S. Witness, John V. Keefe. Witness as to signature of B. B. Campbell. W. Bakewell. Number 36, see page 1254. Agreement between B. B. Campbell and the Pennsylvania Railroad Company. From A History of the Organization, Purposes, and Transactions of the General Council of the Petroleum Producers Unions, and of the suits and prosecutions instituted by it from 1878 to 1880, pages 45-46. This agreement, made on the 27th day of April, AD 1880, between B.B. Campbell and the Pennsylvania Railroad Company. Whereas it having been alleged by persons engaged in the production and shipping of petroleum and the products of petroleum, that discrimination had been practiced in the rates of freight and in the distribution of cars by the Pennsylvania Railroad Company, in such manner as to be injurious to the business of such producers, and bills in equity having been filed in the name of the Commonwealth in the Western District of the Supreme Court of the State of Pennsylvania, for the purpose of restraining such discrimination, and whereas in pursuance of an agreement signed on the 12th of February, 1880, by the said B.B. Campbell, representing the oil producers, at whose instance such bills were filed, and Thomas A. Scott as president of the Pennsylvania Railroad Company, the said bills were withdrawn, and whereas in said agreement the Pennsylvania Railroad Company agreed, upon the withdrawal of said bills, that it would enter into written contracts with the said B.B. Campbell, representing said producers, and all such producers as should within 60 days after the date of said agreement signify their assent to said agreement by signature to the same or duplicate thereof, which contracts should stipulate as therein mentioned, and as hereinafter provided, and whereas on the 25th of February, 1880, the Board of Directors of the Pennsylvania Railroad Company approved the action of the President in signing said agreement, and authorized the President or one of the Vice Presidents to execute such further and formal agreements as might be deemed necessary to carry out the terms of said agreement. Now therefore this agreement witnesseth, that in consideration of the premises, and other good and valuable considerations to them thereunto moving, it is covenanted and agreed between the parties hereto as follows, to wit: first that the Pennsylvania Railroad Company shall and will make known to all shippers of petroleum and its products all the rates of freight intended to be charged to all shippers upon such petroleum and its products. Second that the said Pennsylvania Railroad Company shall not and will not pay or allow any shipper of petroleum or its products any rebate, drawback, or commission upon the shipments of such petroleum or products different from or greater than that which shall be paid to any other person shipping or offering to ship like quantity, and that any discrimination that may be made in favor of shippers of the large quantities shall be reasonable, and shall, upon demand made, be communicated to all persons shipping, or who are now or may be hereafter engaged in the business and desire to ship petroleum and its products. Third that the said Pennsylvania Railroad Company further agrees that upon its own road, and upon any other road or roads upon which it shall furnish cars and engage in the business of a common carrier of petroleum and its products, it will not practice any discrimination in the distribution of its cars, but will make fair apportionment in such distribution among all applicants for cars having actually in their custody and ready for shipment at the time of their application the petroleum or products for the shipment of which they ask facilities. In witness whereof the individuals parties hereto have hereunto set their hands and seals, and the said Pennsylvania Railroad Company has caused its corporate seal to be hereunto affixed, duly attested, the day and year first above written. The Pennsylvania Railroad Company, by Thomas A. Scott. President attest John C. Sims. Assistant Secretary B.B. Campbell. Seal. The history of the Standard Oil Company. Illustration: John D. Rockefeller. A sketch from life by George Varian, made in Cleveland, October, 1903. The history of the Standard Oil Company. By Ida Tarbell. Author of The Life of Abraham Lincoln, The Life of Napoleon Bonaparte, and Madame Roland, a biographical study. Illustrated with portraits, pictures and diagrams. Illustration. Volume 2. New York. McClure, Phillips & Co. MCMV. Copyright, 1904, by McClure, Phillips & Co. Published, November, 1904, N. Second impression. Copyright, 1902, 1903, 1904, by the S.S. McClure Co. Contents. Chapter 9. The Fight for the Seaboard Pipeline. Project for Seaboard Pipeline pushed by Independence. Tidewater Pipe Company formed. Oil pumped over mountains for the first time. Independent refiners ready to unite with Tidewater because it promises to free them from railroads. The Standard face to face with a new problem. Day of the railroads over as long-distance transporters of oil. National Transit Company formed. War on the Tidewater begun. Plan to wreck its credit and buy it in. Rockefeller buys a third of the Tidewater's stock. The Standard and Tidewater become allies. National Transit Company now controls all pipelines. Agreement entered into with Pennsylvania Railroad to divide the business of transporting oil. Pages 2003-2030. Chapter 10. Cutting to Kill. Rockefeller now plans to organize oil marketing as he had already organized oil transporting in refining. Wonderfully efficient and economical system. Installed curious practices. Introduced reports of competitors. Business secured from railway agents. Competitors' clerks sometimes secured as allies. In many instances full records of all oil shipped are given. Standard by railway and steamship companies. This information is used by Standard to fight competitors. Competitors driven out by underselling. Evidence from all over the country. Pretended independent oil companies started by the Standard. Standard's explanation of these practices is not satisfactory. Public derives no benefit from temporary lowering of prices. Prices made abnormally high when competition is destroyed. Pages 2031-2062. Chapter 11. The War on the Rebate. Rockefeller's silence. Belief in the oil regions that combined opposition to him was useless. Individual opposition still conspicuous. The Standard's suit against Schofield, Shima, and Teagle seeks to enforce an agreement with that firm to limit output of refined oil. Schofield, Shima, and Teagle attempt to do business independently of the Standard and its rebates. Find their lot hard. They sue the Lake Shore and Michigan Southern Railway for discriminating against them. A famous case and won. The railway loses another case in this war of individuals on the rebate. Shows the Standard still to be taking drawbacks. The case of George Rice against the receiver of the Cincinnati and Marietta Railroad. Pages 2063-2087. Chapter 12. The Buffalo Case. The Standard buys 3/4 of the vacuum oil works of Rochester. 2 vacuum employees establish Buffalo Lubricating Oil Company and take with them an experienced stillman from the vacuum. The Buffalo Lubricating Oil Company has an explosion and the stillman suddenly leaves. The Buffalo Lubricating Oil Company is sued by Vacuum for infringement of patents. Matthews sues the Everests of the vacuum for deliberately trying to ruin his business. Matthews wins his first civil suit. He files a second suit for damages, and secures the indictment of several Standard officials for criminal conspiracy. Rogers, Archbold and McGregor acquitted the Everests. Find pages 2088-2110. Chapter 13. The Standard Oil Company and Politics. Oil men charge Standard with entrenching itself in state and national politics. Election of Payne to Senate in Ohio in 1884 claimed to establish charge of bribery. Full investigation of Payne's election denied by United States Senate Committee on Elections. Payne himself does not demand investigation. Popular feeling against Standard is aggravated. The Billingsley Bill in the Pennsylvania legislature, a force bill directed against the Standard Oil men fight hard for it. The bill is defeated. Standard charged with using money against it. A growing demand for full knowledge of the Standard. A result of these specific cases. Pages 2111-2128. Chapter 14. The breaking up of the trust. Epidemic of trust investigation in 1888. Standard investigated by New York State Senate. Rockefeller's remarkable testimony. Inquiry into the nature of the mysterious Standard Oil Trust. Original Standard Oil Trust Agreement revealed investigation of the Standard by Congress in 1888 as a result of the uncovering of the Standard Oil Trust Agreement. Attorney General Watson of Ohio begins an action in quo warranto against the trust. Marcus A. Hanna and others try to persuade Watson not to press the suit. Watson persists. Court finally decides against Standard and trust is forced to make an apparent dissolution. Pages 2129-2155. Chapter 15. A Modern War for Independence. Producers Protective Association formed a secret, independent organization intended to handle its own oil agreement made with Standard to cut down production. Results of agreement not as beneficial to producers as expected. Producers proceed to organize Producers Oil Company, Limited. Independent refiners agree to support movement. Producers and Refiners Company formed. Lewis Emery, JRS, fight for seaboard pipeline. The United States pipeline standards. Desperate opposition. Independent refiners almost worn out. They are relieved by formation of Pure Oil Company. Pure Oil Company finally becomes head of independent consolidation. Independence possible, but competition not restored. Pages 2156-2191. Chapter 16. The price of oil. Earliest designs for consolidation include plans to hold up the price of oil. South Improvement Company so intense combination of 1872-1873 makes oil dear. Scheme fails and prices drop. The Standard's great profits in 1876-1877 through its second successful consolidation. Return of competition in lower prices. Standard's futile attempt in 1882. Repeat rate of 1876-1877. Standard is convinced that making oil too dear weakens markets and stimulates competition. Great profits of 1879-1889. Lowering of the margin on export since 1889 by reason of competition. Manipulation of domestic prices even more marked. Home consumers pay cost of Standard's fights in foreign lands. Standard's various prices for the same goods at home. High prices where there is no competition and low prices where there is competition. Pages 2192-2230. Chapter 17. The legitimate greatness of the Standard Oil Company. Centralization of authority. Rockefeller and 8 other trustees managing things like partners in a business news gathering organization for collecting all information of value to the trustees. Rockefeller gets picked men for every post and contrives to make them compete with each other. Plants wisely located the smallest details in expense. Looked out for quick adaptability to new conditions as they arise. Economy introduced by the manufacture of supplies. A profit paid to nobody. Profitable extension of products and byproducts. A general capacity for seeing big things and enough daring to lay hold of them. Pages 2231-2255. Chapter 18. Conclusion. Contempt proceedings begun against the Standard in Ohio. In 1897 for not obeying the court's order of 1892 to dissolve the trust, suits begun to oust 4 of the Standard's constituent companies for violation of Ohio antitrust laws. All suits dropped because of expiration of Attorney General Monnett's term. Standard persuaded that its only corporate refuge is New Jersey, capital of the Standard Oil Company of New Jersey increased, and all Standard Oil business taken into new organization. Restriction of New Jersey law. Small profits are great and Standard's control of oil business is almost absolute. Standard Oil Company essentially a realization of the South Improvement Company's plans. The crucial question now, as always, is a transportation question. The trust question will go unsolved so long as the transportation question goes unsolved. The ethical questions involved. Pages 2256-2292. Appendix pages 2293-2396. Index pages 2397-2409. List of illustrations. Sketch of John D. Rockefeller _frontispiece 2 _ A sketch from life by George Varian, made in Cleveland, October, 1903. Facing page. Portrait of Alanson A. Sumner 2004. Prominent supporter of the Tidewater Pipe Company, still active in its councils. Portrait of Henry Harley 2004. President of the Pennsylvania Transportation Company. Projector of the first seaboard pipe line. Portrait of Samuel Van Sickle 2004. The first successful pipeline for gathering and transporting oil was completed by Mr. Van Sickle in 1865. Portrait of General Herman Haupt 2004. Civil engineer for the first and second pipe lines projected to the seaboard. Portrait of Byron D. Benson 2012. The first president of the Tidewater Pipe Company. Portrait of David K. McKelvey 2012. The successor of Mr. Benson as president of the Tidewater. Portrait of Major Robert E. Hopkins 2012. Treasurer of the Tidewater from its organization until his death in 1901. Portrait of Samuel Q. Brown 2012. The present president of the Tidewater, successor to Mr. McKelvey. Portrait of John D. Rockefeller in 1880 2032. From a photograph by Sereny. Portrait of William C. Schofield 2068. Senior member of the firm of Schofield, Schermeyer and Teagle, of Cleveland. Plaintiff in important suits against Lake Shore Railroad for freight discriminations. Portrait of Daniel Skirmer 2068. Associate of Mr. Schofield and Mr. Teagle in the war on railroad rebates which the firm waged for nearly 20 years. Portrait of John Teagle 2068. Independent refiner of Cleveland, Ohio, prominent in struggle against freight discriminations by the railroads. Portrait of Charles B. Matthews 2068. Independent refiner of Buffalo. Plaintiff in Buffalo case, where members of the Standard Oil Company were indicted for conspiracy. Burst in a pipeline 2076. Bleaching tank 2092. Constructing an iron tank for storing oil 2092. Oil agitators 2092. 5-barrel still used in the 50s in distilling crude oil as a luminant 2092. Portrait of John D. Rockefeller 2120. By Eastman Johnson. Portrait of David K. Watson 2142. Attorney General of Ohio from 1887 to 1891. Mr. Watson brought suit against the Standard Oil Company in May, 1890, in the Supreme Court of Ohio. Portrait of Frank S. Monnet 2142. Attorney General of Ohio from 1895 to 1899. Mr. Monnet brought suit against the Standard Oil Company in 1897 in the Supreme Court of Ohio. Portrait of Lewis Emery, Jr. 2142. Independent oil operator and refiner. Leader in movement for free pipeline bill and anti-discrimination laws. Founder of the United States Pipeline. Portrait of George Rice 2142. Plaintiff in numerous cases brought against the Standard Oil Company. Prominent independent witness in various state and congressional investigations. Group of Cleveland citizens 2146. Who called on John D. Rockefeller at his residence, Forest Hill, on July 25, 1896, to thank him for his gift of park lands to the city. Mr. Rockefeller is in the center of the group, the late Senator Marcus A. Hanna in the right lower corner, and Governor Myron T. Herrick in the center of the top row. Michael Murphy 2164. The present president of the Pure Oil Company. David Kirk 2164. The first president of the Pure Oil Company. James W. Lee 2164. The chief counsel of the Pure Oil Company. President of the company from 1897 to 1901. Thomas W. Phillips 2164. A leader in the independent movement, which resulted in the Pure Oil Company laying a 6-inch pipeline, Cairo, West Virginia 2182. A typical oil farm of the early days 2216. Portrait of SCT. Dodd 2232. Chief Counsel of the Standard Oil Company. Framer of the Trust Agreement of 1882. Portrait of Jabez A. Bostwick 2232. From 1872 to 1892 the chief oil buyer of the Standard Oil Company. Portrait of Joseph Seep 2232. Head of the Seep Agency, through which all oil transported by the Standard Oil Company goes. Portrait of Daniel O'Day in 1872-2232. Vice President of the National Transit Company. The pipeline company owned by the Standard Oil Company. Portrait of John D. Rockefeller 2256. From a photograph by Alan A. Ralt Green, taken about 1892. A 25,000 barrel tank of oil in flames 2280. The History of the Standard Oil Company. Chapter 9. The Fight for the Seaboard Pipeline. Project for Seaboard Pipeline pushed by Independence Tidewater Pipe Company formed. Oil pumped over mountains for the first time. Independent refiners ready to unite with Tidewater because it promises to free them from railroads. The Standard face to face with a new problem. Day of the railroads over as long distance transporters of oil. National Transit Company formed. War on the Tidewater begun. Plan to wreck its credit and buy it in. Rockefeller buys a third of the Tidewater's stock. The Standard and Tidewater become allies. National Transit Company now controls all pipelines. Agreement entered into with Pennsylvania Railroad to divide the business of transporting oil. The project for a seaboard pipeline to be built by the producers and to be kept independent of Standard capital and direction had been pushed with amazing energy. Early in the fall of 1878, General Haupt reported that his right-of-way was complete from the Allegheny River to Baltimore. Contracts were let for the telegraph line and preparation begun to lay the pipe. Before much actual work had been done, it became clear to the company that it was not from the Butler oil field but from that of Bradford that a seaboard pipeline should run, that the former field was showing signs of exhaustion, while the latter was evidently going to yield abundantly, with a promptness which would have done credit to Mr. Rockefeller himself. Messrs. Benson, Hopkins, and McKelvey changed their plan. The new idea was to lay a 6-inch line from Rixford, in the Bradford Field, to Williamsport, on the Reading Railroad, a distance of 109 miles. The Reading, not having had so far any oil freight, was happy to enter into a contract with them to run oil to both Philadelphia and New York until they could get through to the seaboard themselves. In November 1878, a limited partnership, called the Tidewater Pipe Company, was organized with a capital of $625,000 to carry out the scheme. Many of the best-known producers of the oil regions took stock in the company, the largest stockholders being A.A. Sumner and B.D. Benson. 86. The first work was to get a right-of-way. The company went at the work with secrecy and dispatch. Its first move was to buy from the Equitable Pipeline, the second independent effort to which, as we have seen, the Producers' Union lent its support in 1878, a short line it had built, and a portion of a right-of-way eastward which Colonel Potts had been quietly trying to secure. This was a good start, and the chief engineer, B.F. Warren, pushed his way forward to Williamsport near the line which Colonel Potts had projected. The Standard, intent on stopping them, and indeed on putting an end to all future ventures of this sort, set out at once to get what was called a dead line across the state. This was an exclusive right for pipeline purposes from the northern to the southern boundary of Pennsylvania. As there was no free pipeline bill in those days, this dead line, if it had been complete, would have been an effectual barrier to the Tidewater. Much money was spent in this sordid business, but they never succeeded in completing a line. The Tidewater, after a little delay, found a gap not far from where it wanted to cross, and soon had pushed itself through to Williamsport. With the actual laying of the pipe there was no interference which proved serious, though the railroads frequently held back shipments of supplies. At Williamsport, where the pipe crossed under the railroad, it was torn out once. The Tidewater had no trouble in this case in getting an injunction which prevented further lawlessness. Illustration: Alanson A. Sumner, prominent supporter of the Tidewater Pipe Company, still active in its councils. Illustration: Henry Harley, president of the Pennsylvania Transportation Company, projector of the first seaboard pipeline. Illustration: Samuel Van Sickle. The first successful pipeline for gathering and transporting oil was completed by Mr. Van Sickle in 1865. Illustration: General Herman Haupt, civil engineer for the first and second pipelines projected to the seaboard. By the end of May the company was ready for operation. The plant which they had constructed proposed to transport 10,000 barrels of oil a day, over a distance of 109 miles. The apparatus for doing this consisted simply of tanks, pumps and pipes. At Corryville, on the edge of the Bradford Field, 2 iron tanks, each holding 25,000 barrels of oil, were connected with an enormous pump of a new pattern devised by the Hawley Company especially for this work. This pump, which was driven by an engine of 70 horsepower, was expected to force the oil through a 6-inch pipe to a second station 28 miles away and about 700 feet higher. Here a second pump took up the oil again, driving it to the summit of the Alleghenies, a few miles east. From this point the oil ran by gravitation to Williamsport. It was announced that the pumps would be started on the morning of May 28 The experiment was watched with keenest interest. Up to that time, oil had never been pumped over 30 miles, and no great elevation had been overcome. Here was a line 109 miles long, running over a mountain, nearly 2,600 feet high. It was freely bet in the oil regions that the tidewater would get nothing but a drizzle for its pains. However, oil men, standard men, representatives of the Pennsylvania Railroad, newspaper men and natives gathered in numbers at the stations, and indeed all along the route, to watch the result. The pump at Station 1 was started by B.D. Benson, the president of the company. There were present with him several members of the concern. And today these men speak with emotion of the moment when Mr. Benson opened the valve to admit the oil to the pump. Would the great venture, on which they had staked all, be a success? Without a hitch the oil flowed in a full stream into the pipe and began its long journey over the mountains. It traveled about as fast as a man could walk, and, as the pipe lay on the ground, the head of the stream could be located by the sound. Patrolmen followed the pipe the entire length watching for leaks. There was now and then a delay from the stopping of the pumps. But the cause was trivial enough, never anything worse than chips under the valves or clogging in the pipe by stones and bits of wood which the workmen had carelessly left in when joining the pipe. When the oil reached the second station there was general rejoicing. Nevertheless, the steepest incline, the summit of the Alleghanies, had yet to be overcome. The oil went up to the top of the mountain without difficulty. And on June 4, the seventh day after Mr. Benson opened the valve at Station 1, oil flowed into the big receiving tank beyond Williamsport. A new era had come in the oil business. Oil could be pumped over the mountains. It was only a matter of time when the tidewater would pump to New York. Once at the seaboard, the tidewater had a large and sure outlet for its oil in the group of independent refiners left at the mercy of the Standard in the fall of 1877 by the downfall of the Empire Line. These refiners had most of them run the entire gamut of experiences forced on the trade by the railroads and the Standard. Take, for instance, the experience of Ayres, Lombard and Company, related by Josiah Lombard in 1879 in the Pennsylvania suits. They had gone into the business in 1869. In West 66th Street. At the beginning they had shipped principally over the Erie, sometimes as high as 50,000 barrels a month. But when that road came into the hands of Fisk and Gould, those gentlemen began to try to build up a refining business in New York for their own friends. Edward Stokes was at that time hand in glove with Fisk. He had in the oil regions an able friend, Henry Harley. Harley bought and shipped the oil over the Erie, special rates were given him, and the Stokes refinery soon began to flourish at the expense of the former shippers of the Erie. Mr. Lombard, finding, as he says, that there was no possibility of doing business with that road under the Fisk and Gould management, went over to the New York Central. Here he furnished his own cars. Ayres, Lombard and Company owned 100 cars on the Central in 1872, worth about $35,000, and in these they shipped the bulk of their oil. The South Improvement Company maneuvers in the spring of 1872 completely stopped their shipping over that road, and in 1872 they sold their cars. Mr. Lombard said in his testimony, "We sold them, the cars, because the Standard Oil Company were getting the ascendancy so much over the New York roads that we could not get a rate of freight from the lower districts in the Parker district, where the bulk of the oil was produced at that time, that would enable us to compete with them in the New York market, so there was no use in owning the cars. Driven off the Erie and Central, the firm made a running arrangement with Mr. Rockefeller for a year. The Standard bought the cars and agreed to furnish Ayres, Lombard and Company crude oil for a certain price at a certain time, and take the refined oil from them at a fixed price. This contract was made probably under the Refiners Association, which Mr. Rockefeller succeeded in effecting in August 1872, after the failure of the South Improvement Company, which association, as we have already seen, took in fully 4/5 of the refining interests of the country. The contract continued, Mr. Lombard said in testimony, for a year or more, and was then terminated by notice from the Standard Oil Company. Soon after the termination of the contract with the Standard, which was either late in 1873 or early in 1874, Mr. Lombard was not able to decide this when he was under examination. The firm began shipping over the Pennsylvania Road. They bought part of their oil at this time from Adna Nehart. Now, sometime in 1875, as we have seen, Mr. Nehart began to feel the Standard pressure and his business was sold to the Standard. Again Ayres, Lombard and Company found a large part of their supply of oil cut off. For about a year they shipped over the Pennsylvania. It was not long, however, before the concern found that even on the Pennsylvania they were under a disadvantage, that road having made in 1875 discriminating contracts with the Standard. Again, the firm changed, buying its oil from J. A. Bostwick and Company of New York. Now Bostwick was the Standard oil buyer, one of the original South Improvement Company, and a stockholder in the Standard Oil Company. Mr. Lombard swore that he had not been taking oil of Bostwick for more than a year before the Standard began to draw its lines around him, as he put it, and again the question arose, how were they to get oil for their refinery? There seemed no way but to try to make a contract with the Pennsylvania Company. On the 18th of May, 1877, he went to Philadelphia and saw Colonel Potts, who told him he would be glad to have his shipments on the Pennsylvania. Accordingly a contract was made for a year, the company guaranteeing them as low a rate as anybody else had. But this contract of Mr. Lombard was destined to end as speedily and as disastrously as all of those he had been making for over 5 years, for in the fall of the year the Empire line was sold to the Standard, and in the spring of 1878, when Mr. Lombard's contract ran out, the Pennsylvania refused to renew it on the terms they gave the Standard. Mr. Lombard gave a very interesting account of the interview he and his fellow refiners of New York had with Mr. Cassatt in reference to this matter. In March 1878, I think it was by appointment, we had an interview with Mr. Cassatt, third vice president of the Pennsylvania Railroad. There were present Mr. Bush, Mr. Gregory, Mr. Burke, Mr. Olin, and myself, besides Mr. Cassatt. It was held in Mr. Bush's office, 123 Pearl Street, New York. We sought that interview for the purpose of finding out what our position would be on the Pennsylvania Railroad after the termination of our contract with the Empire Line, which they had assumed. We had quite a plain talk on the subject. We began by telling Mr. Cassatt something that he already knew, that we for the past year had been probably the largest shippers over the Pennsylvania Railroad that they had had, largest shippers of petroleum. He acknowledged it, and we asked him if we should, after the 1st of May, be on the same footing and have as low a rate of freight as anybody else, which was guaranteed by contract up to that time. He said no, we would not. We asked him why not. Well, he said. It would not be satisfactory to the Standard Oil Company. I then put the question to him what difference it made to the Pennsylvania Railroad Company whether it was satisfactory to the Standard Oil Company or not. He said that the Standard Oil Company was the only party which could keep peace between the trunk lines. I said, "It seems to me you have the matter very much in your own hands. There are but 4 of you. If you agree upon a certain rate of freight the oil is to come forward I see no use of the intervention of a third party or a fifth party in this case." He said, "I cannot trust, or rather," he said, "they are the only people that can keep harmony." Then we had a little discussion about the rates. He said that they had been bringing oil for the past year at a very low rate. I told him I understood it was a little over 70 cents an average on crude petroleum. He denied it, and said it was not. Then, when we were talking about the subject of rates, he said of course the rates on petroleum were very profitable, and said we could find out the rate at which they could bring petroleum, if they were compelled to, by looking up their annual report, and seeing the cost a ton per mile, which was something like 5 or 6 mils per ton per mile, and which if we figured that it would be a very profitable business. We told him we did not object to him making a good profit at any time, all we wished was to have as low a rate of freight as anybody else had, which we could not get. He said we had better make an arrangement with the Standard and we would all of us make money, and that they had a very large business and proposed to make money, and the discrimination would be so light against us that we would hardly notice it, and we formed the idea from what he said. We asked him whether the discrimination against us would be larger if the rate of freight were high than it would if the rate of freight were low. He said, yes, it would be, but he said the discrimination would be very small. We tried to find out by asking what it would be, but did not succeed. He then said if we would unite with the Standard we would do better and everything would be peaceable and harmonious, and he would use his efforts to promote such a union if we wished it. We told him we did not wish to unite with the Standard, we dealt on freight matters with the Pennsylvania Railroad, not with the Standard Oil Company. There was another interview at which Mr. Bush, Mr. Olin, Mr. Cassatt, and myself were the only parties as I remember it. It was held in Pennsylvania, at the office of the Pennsylvania Railroad Company, in the last part of May or early part of June. It was at the time of what we called the squeeze-in cars. Previous to that time we had had all the cars we wanted without any difficulty, at that time, and when we were wanting just about the same kind of cars we had previously been wanting, and business was running on very easily, we found we were unable to get anything like the amounts we had before. Instead of getting for the firm I represented from 12 to 15 cars a day, we were getting only 1 or 2, utterly insufficient for the business. We came over to see Mr. Cassatt about it, Mr. Bush, Mr. Olin, and myself. He said he knew there was trouble, that the other side, the Standard Oil Company, had some 500 cars full here at Philadelphia and Baltimore. That he had not discovered it until recently, but that he would have it remedied. They had been holding them here full. I asked him why. If he knew of the cars being detained, he kept giving them cars. He said he did not know exactly how that was. I told him if these cars were shipped here and held, it seemed to me they ought to stop giving cars to parties holding them. He said the matter would be remedied soon. We asked him how soon. He could not tell exactly. I said, can't you stop giving them cars? He said he would remedy the matter, we should have all the cars we needed, and it was at that time that he made the remark to which Mr. Bush testified, when we had some little general conversation, that if we built a pipeline, he would buy it up for old iron in 60 days. I think I remarked that the conduit pipe brought a good price for old iron, in a laughing way. The interview was pleasant enough. Then early in July, I think it was the last part of June or early part of July, Mr. Olin, Mr. Bush, Mr. Wilson, Mr. King, Mr. Gregory, and myself came to Philadelphia and met Colonel Scott, President of the Pennsylvania Railroad, Mr. Cassatt, and Mr. Brundred at the office of the Pennsylvania Road, with the same trouble, the same two troubles as of old, a scarcity of cars and a discrimination in freight. As to scarcity of cars, they claimed that we were getting our allotment. We told them we knew nothing about an allotment, that previous to the 1st of May we had sufficient cars for our business, since that time we got scarcely any, that if they had not sufficient cars to do the business with we would put on cars. Mr. Scott said they would not allow that, they had bought out one line and did not propose to have another. We then demanded cars for the business, making again the offer to put on cars if they could not furnish them, with the same result. He said they had already fought one fight in our behalf, which cost them $1.5 million. We told them not it all in our behalf, we had nothing to do with it, we were simply shippers over the road and did not participate in the matter at all. It was a matter of their own. He seemed to be a little sore about that when he made the remark which has been given in evidence before. He said there would be no peace or profit in the business until we made some arrangement with the Standard Oil Company. He would be very glad to have such an arrangement made, and would do all in his power to accomplish it. We told him we did not wish any arrangement with the Standard Oil Company. We had been dealing for years with the Pennsylvania Railroad Company, and we wished to deal with them now on all transportation and freight matters. I think there was nothing further in that interview. He asked why we did not apply to the other roads for transportation. We told him we had. He said, with what results? That the Central Road had no cars of their own. He said that was a very flimsy pretext. I said that the Erie Road cars were controlled by the Standard Oil Company, and the Central cars were controlled by the Standard Oil Company. That in fact the whole transportation of the oil country seemed to be controlled by the Standard Oil Company. And the New York Central, and the Erie, and the Pennsylvania Central, and the Baltimore and Ohio, they controlled the whole thing, and there was no chance, and in addition to that we had been shippers and customers of the Pennsylvania Road for years. Naturally enough, men who had been through such experiences as these of Mr. Lombard were glad to unite with the Tidewater, which promised to free them from the railroads and their chief competition, and they promised to take all their supply from the line. The success of the Tidewater experiment brought Mr. Rockefeller face to face with a new situation. Just how serious this situation was is shown by the difference in the cost of transporting a barrel of oil to the seaboard by rail and transporting it by pipe. According to the calculation of Mr. Gowan, the president of the Reading Railroad, the cost by rail was at that time from 35 to 45 cents. The open rate was from $1.25 to $1.40, and the Standard Oil Company probably paid about 85 cents, when the roads were not protecting it from injury by competition. Now, according to General Hopp's calculation, in 1876, oil could be carried in pipes from the oil regions to the seaboard for 16 cents a barrel. General Hopp calculated the average difference in cost of the two systems to be 23 cents, enough to pay 28% dividends on the cost of a line even if the railway put their freights down to cost. This little calculation is enough to show that the day of the railroads as long-distance transporters of crude oil was over, that the pipelines were bound to replace them. Now, Mr. Rockefeller had by 10 years of effort made the roads his servant. Would he be able to control the new carrier? A man of lesser intellect might not have foreseen the inevitableness of the new situation. A man of lesser courage would not have sprung to meet it. Mr. Rockefeller, however, is like all great generals, he never fails to foresee where the battle is to be fought, he never fails to get the choice of positions. He wasted no time now in deciding what should be done. He proposed not merely to control future long-distance oil transportation, he proposed to own it outright. Hardly had the news of the success of the Tidewaters experiment reached the Standard before this truly Napoleonic decision was being carried out. Mr. Rockefeller had secured a right-of-way from the Bradford Field to Bayonne, New Jersey, and was laying a seaboard pipeline of his own. At the same time he set out to acquire a right-of-way to Philadelphia. And soon a line to that point was under construction. Even before these seaboard lines were ready, pipes had been laid from the oil regions to the Standard's inland refining points Cleveland, Buffalo, and Pittsburgh. With the completion of this system Mr. Rockefeller would be independent of the railroads as far as the transportation of crude oil was concerned. It was, of course, a new department in his business, and, to manage it, a new company was organized in April 1881, the National Transit Company, with a capital of $5 million, and a charter of historical interest, for it was a mate of the charter of the ill-fated South Improvement Company, granted by the same legislature and giving the same omnibus privileges, the right in fact to do any kind of business, except banking, in any part of the world. The South Improvement Company Charter, as we have seen, was repealed. The charter, which the National Transit Company now bought, seems to have gone into hiding when the character of its mate was disclosed, and so had been forgotten. How it came to be unearthed by the Standard, or what they paid for it, the writer does not know. However, as H. H. Rogers aptly told the Industrial Commission in 1899, when he was asked if a considerable sum was not given for it, I should suppose every good thing had to be paid for. I should say a man owning a charter of that kind would sell it at the best price he could get. Illustration: Byron D. Benson, the first president of the Tidewater Pipe Company. Illustration: David K. McKelvey, the successor of Mr. Benson as president of the Tidewater. Illustration: Major Robert E. Hopkins, treasurer of the Tidewater from its organization until his death in 1901. Illustration: Samuel Q. Brown, the present president of the Tidewater, successor to Mr. McKelvey. And while Mr. Rockefeller was making this lavish expenditure of money and energy to meet the situation created by the bold development of the Tidewater, what was his attitude toward that company? One would suppose that Mr. Rockefeller, of all men, would be the first to acknowledge the service the Tidewater had rendered the oil business, that in this case he would have felt an obligation to make an exception to his claim that the oil business was his, that he would have allowed the new company to live. But Mr. Rockefeller's commercial vision is too keen for that. That would not be business. The Tidewater had been built to feed a few independent refineries in New York. If these refineries operated outside of him, they might disturb his system, that is, they might increase the output of refined and so lower its price. The Tidewater must not be allowed to live, then. But how could it be put out of commission? It had money to operate. There were plenty of oil producers glad to give it their product, because it was independent. The Reading Railroad had gone heart and soul into its fight. It had refiners pledged to take its oil. And these refiners had markets of their own at home and abroad. What was he going to do about it? There were several ways to accomplish his end. In two of them, at least, Mr. Rockefeller excelled from long practice. The first was to get out of the way the refineries which the Tidewater expected to feed, and this was undertaken at once. The refiners were approached usually by members of the Standard Oil Company as private individuals, and terms of purchase or lease so generous made to them that they could not afford to decline. At the same time they were assured confidentially that the Tidewater scheme was a pure chimera, that they understood the pipeline business better than anybody else, and they knew oil could not be pumped over the mountains. All but one firm yielded to the pressure. Ayres and Lombard stood by the Tidewater, but soon after their refusal to sell they were condemned as a public nuisance and obliged to move their works. The Tidewater met the situation by beginning to build refineries of its own, one at Bayonne, New Jersey, and another near Philadelphia, in the meantime storing the oil it had expected to sell. Having done his best to cut off his rival's outlet, Mr. Rockefeller called upon the railroads to carry out that article of their contract with him which bound them to protect him from injury by competition. What was done was told a few months later to the Committee on Commerce in the House of Representatives by Franklin B. Gowan, the president of the Reading Railroad. According to Mr. Gowan, the Tidewater and Reading were no sooner ready to run oil than a meeting of the trunk lines was held at Saratoga, at which the representatives of the Standard Oil Company were present, and on that day the through rate on oil was reduced to 20 cents per barrel to the Standard Oil Company. It was subsequently reduced to 15 cents, Mr. Gowan told the committee. And I believe, though I do not certainly know, to 10 cents per barrel in cars of the Standard Oil Company, and I am told that at the meeting at Saratoga a time was fixed by the Standard Oil Company within which they promised to secure the control of the pipeline provided the trunk lines would make the rate for carrying oil so low that all concerned in transportation would lose money. I know this, that only 3 or 4 months ago we were told, I do not mean myself, but the gentleman who directly represented the pipeline which leads to our road, that if they would agree to give all their oil to the Standard Oil Company to be refined, we could carry 10,000 barrels a day, and the rates would be advanced by the trunk lines. But, to use the language of those making the offer, we, meaning the Standard Oil Company, will never permit the trunk lines to advance the rate on oil until your pipeline gives us all its product to refine, and the prophecy of 4 months ago has become the history of today. Mr. Flagler differs with Mr. Gowan in his explanation of this cut in rates. Mr. Flagler contends that the Standard Oil Company really opposed it, but that the railroads insisted on it. Mr. Flagler's testimony is interesting reading in connection with all that we know about the Tidewater Company. It will be found in the appendix. 87. This was the Tidewater's first year's experience. The second and third were not unlike it. But the company lived and expanded. It bought and built refineries, it sent its president to Europe to open markets, it extended its pipeline still nearer to the seaboard, and it did this by a series of amazingly plucky and adroit financial moves, borrowing money, speculating in oil, exchanging credit, chasing checks from bank to bank, hustling, in short, as few men ever did to keep a business alive. And every move had to be made with caution, for the Standard's eye was always on them, its hand always outstretched. Samuel Q. Brown, the present president of the organization, when on the witness stand in December, 1882, said that so much did the Tidewater fear espionage that they were accustomed to keep their oil transactions as a private and not a general account, in order that they might not be reported to the Standard, that even matters which they believed they were keeping in an absolutely private way frequently leaked out, to the injury of the business. Illustration. Scale 3 miles to each division. Condensed profile of Tidewater pipe. Line between Rixford and Tamanend, Pennsylvania. The pipe followed the jagged line representing surface of the ground. The numbers above the surface line show the location of the pumping stations from which the oil was forced. The pump at Station 1 lifted the oil over 600 feet. From here it flowed by gravitation until the gradient line, the sloping straight line above the surface line, touched the ground. A new station, number 2, then lifted the oil to the next high point, the crest of the Alleghenies. As the gradient line shows, the oil now would flow to Station 4, making many steep ascents without further pumping. Station 3 was added to increase the speed of the flow. By January, 1882, the Tidewater was in such a satisfactory condition that it decided to negotiate a loan of $2 million to carry out plans for enlargement. The First National Bank of New York, after a thorough examination of the business, agreed to take the bonds at 90 cents on the dollar, but trouble began as soon as the probable success of the bond issue was known. The officials of the First National Bank were called upon by stockholders of the Tidewater, men holding nearly a third of the company's stock, and assured that the company was insolvent, and that it would be unsafe for the bank to take the loan. The First National declined to be influenced by the information, on the ground that the disgruntled stockholders had sold themselves to the Standard Oil Company, and were trying to discredit the Tidewater, so that the Standard might buy it in. It had been planned to place some of these bonds in Europe, and Franklin B. Gowen was sent over for that purpose. Mr. Brown said on the witness stand, a few months later, that as soon as Mr. Gowen started from this side it was cabled to Europe that he was going over to place bonds which were not sound, that the stockholders were all of them wealthy men, and if the bonds had been good property, they would have taken them themselves. Mr. Brown declared this report was spread so generally on the other side that it interfered seriously with Mr. Gowen's attempt to place the loan. These maneuvers failing to ruin the Tidewater's credit, a more serious attack was made in the fall of 1882, by the filing of a long bill of complaint against the management of the company, followed by an appeal that a receiver be appointed and the business wound up. The appeal came from E. G. Patterson, a stockholder of the Tidewater, and a man who, up to this time, had been one of the most intelligent opponents of the Standard in the oil regions. Mr. Patterson was one of the few who had realized, from the first development of Mr. Rockefeller's pretensions, that it was a question of transportation, and that, if the railroads could be forced by courts and legislatures to do their duty, the coal oil business would not belong to Mr. Rockefeller. He had been one of the strongest factors in the great suits compromised in 1880, and his disgust at the outcome had been so great that he had washed his hands of the Producers' Union. Later he had been engaged by the state of Pennsylvania to collect evidence on which to support a claim against the Standard Oil Company for some $3 million of back taxes. The Standard had made Mr. Patterson's services unnecessary by coming forward and giving the Attorney General all the information as to its financial condition, which he desired. Exasperated at the result of all his efforts, and feeling that he had been deserted by the public he had tried to serve, Mr. Patterson sent word to the Standard that he proposed still further to attack them, just how he never explained, unless they would give him not to attack, as much as there was in the contract from the state. 88. They seem to have thought it worthwhile to buy peace, and agreed to give Mr. Patterson some $20,000 in all, and secure him a position for a term of years. The first payment was made at the end of April, 1882, and $5,000 of the money received Mr. Patterson paid to the Tidewater for stock he had taken at its organization. No sooner was the stock in his hands than he began the preparation of the bill of complaint above referred to, and in December the case was heard. The oil regions watched it with keenest interest. That Mr. Patterson had made some settlement with the Standard was generally known, and the charge was freely circulated that they had bribed him to bring this suit, in hopes of blasting the credit of the Tidewater and getting its stock for a song. The testimony brought out in the trial did not bear out this popular notion. The case was rather more complicated. That the suit was backed by the Standard, one would have to be very naive to doubt, but they were using other and stronger parties than Mr. Patterson, and that was a faction of the company known as the Taylor-Satterfield crowd. These men, controlling some $200,000 worth of Tidewater stock, had been professing themselves dissatisfied with the management of the business for some months, though always refusing to sell their holdings at an advanced price. It was generally believed in the oil regions that their dissatisfaction was fictitious, that they were in reality in league with the Standard in an attempt to create a panic in Tidewater stock, a belief which was strengthened when it was learned that a big oil company, which the gentlemen controlled, the Union, had been sold about that time to the Standard Oil Trust for something like $500,000 in its stock. The first maneuver of the Taylor-Satterfield faction had been the attempt to dissuade the First National Bank from taking the Tidewater loan referred to above. Failing in this, they seem to have imbued Mr. Patterson thoroughly with their pretended dissatisfaction and to have persuaded him to bring the suit. For some reason which is not clear they failed properly to support him in the suit, and when it came off they practically deserted him. The Tidewater had no trouble in proving that the complaints of insolvency and mismanagement were without foundation. And Judge Pearson Church, of Meadville, before whom the case was argued, refused to appoint the receiver, intimating strongly that, in his judgment, the case was an attempt to levy a species of blackmail, in which it must not be expected that his court would cooperate. Judge Church's decision was given on January 15. 2 days later a sensation came in Tidewater affairs, which quite knocked the Patterson suit out of the public mind. It was nothing less than a bold attempt by the Taylor Party, or, as it was now known, the Standard Party, to seize the reins of government. It was a very cleverly planned coup. The yearly meeting for the election of officers in the company was fixed for a certain Wednesday in January. By verbal agreement it had been postponed, in 1882, to some time in February. The controller, D.B. Stewart, a member of the Taylor faction, representing that he could not have his statement ready earlier. No notices were sent out to this effect, although this should have been done. Taylor and his party, taking advantage of this fact perfectly well known to them, appeared at the Tidewater offices on January 17, and although one of the Benson faction, as the majority was known from the name of the company's president, was present with sufficient proxies to vote nearly 2/3 of the stock, they overruled him and elected themselves to the control. They also elected to the Board of Managers, Franklin B. Gowan, the president of the Reading, and James R. Keene, the famous speculator. both large holders of Tidewater bonds. They followed their election immediately by sending out notices to the banks with which the company did business not to honor checks drawn by the Benson party, and to the post office to deliver mail to no one but themselves. The announcement caused a terrible commotion in oil circles. Both Mr. Keene and Mr. Gowan refused to recognize the new board, Mr. Gowan telegraphing in answer to the notification of his election. John Satterfield, Titusville. At 2:45 today I received a dispatch signed with your name as manager and chairman, stating that a meeting of the Board of Managers would be held at noon today. While the notice itself is sufficient to render invalid any action you may have attempted at such meeting as has been held, even if you had power to act at all, I deny your right to call any meeting or act in any manner as an officer of the company, and will hold you and all your associates responsible at law for the occurrences of yesterday, and for your subsequent action thereunder. Signed, F. B. Gowan. The Benson party took immediate action, applying for an injunction restraining the new board from taking possession of the books and offices. This was granted and a date for a hearing appointed. Up to the hearing the old board did business behind barricaded doors. The case was heard in Meadville before Judge Pearson Church, the same who had heard the Patterson case. As it was a case to be decided on purely technical matters, the rules governing elections, no sensation was looked for, but one came immediately. It was a long affidavit from James R. Keene, even more notorious then than now. There were fewer of his kind for deals and corners and devious stock tricks, declaring that both the Patterson case and this attempt to obtain control were dictated by the malicious ingenuity of the Standard for the purpose of destroying the Tidewater and getting hold of its property. From my first connection with the company, said Mr. Keene, it has been hampered and embarrassed in its business by the unscrupulous competition of the Standard Oil Company. When it first began to transport and deliver oil at Tidewater, the refineries which purchased and refined oil were one after another bought up by the Standard Oil Company or driven out of business by vexatious and oppressive annoyances. The most private details of our business have been communicated to the officers of the Standard Oil Company, and they have, by every means in their power, interfered with our affairs. By the arrangement which they were able to make with the railroads leading from the oil regions, other than the Philadelphia and Reading Railroad Company and the Central Railroad of New Jersey, the Standard Oil Company have been able to obtain a control of the business of transporting and refining oil, with the exception of that part of the business which has been carried on by the Tidewater Pipe Company and their refineries, to which it had made deliveries. Repeated efforts have been made by parties in their interest to secure the control of the Tidewater Pipe Company, and if they could succeed, the monopoly thereby secured would add many $1 million a year to their profit. Mr. Keene's putting of the case was undoubtedly correct, but pious horror of commercial brigandage, coming from Jim Keene, was useful only to give joy to a cynical world, unencumbered by the possession of stock in either concern. The Keene sensation was followed by a second. An affidavit from John D. Archbold, of the Standard Oil Company, denying that his company had any interest in the present suit, but adding that for some time the officers of the Tidewater had been seeking an alliance with the Standard. Byron D. Benson and David McKelvey have at various times for the past years met me at their own instance, and have proposed to combine the business of the Tidewater Pipe Company with that of the Standard Oil Company, desiring the Standard Oil Company to agree on a division of the business of transporting and refining oil, and to agree with the Tidewater Pipe Company in fixing the rate of transporting oil and the price of refined oils. These proposals were renewed to me by B.D. Benson during the summer of 1882, he coming to my office at his own instance and urging, by various arguments, such an arrangement. These proposals, in whatever shape made, have always been declined. This deponent has also had many interviews with James R. Keene, and always at his request, upon the same subject, in which interviews said Keene has earnestly urged such a combination and has used many arguments in favor of the advantage which would result from such a combination. These proposals have always been declined. Naturally they were declined. The Standard was not seeking an alliance. It was seeking ownership of the Tidewater, and it expected so to discredit the company that it could buy in its stock for a song. Mr. Archbold's affidavit cooled popular sympathy for the hunted concern no little, however. A suggestion of any kind of a compromise with the Standard was looked upon as rank disloyalty by the oil regions, free competition in rates and in prices being, they contended, the only hope of the country. Mr. Archbold's affidavit must have something in it. Everybody thought, though it might be, as Mr. Benson immediately swore, grossly inaccurate. Such was the character of the charges and counter-charges in this purely technical case. The judge took little notice of them in his decision. But, after an exhaustive discussion of the points involved in the election, decided it was illegal and continued the injunction he had granted against the new board. Judge Church's decision aroused general exultation in the oil regions, as any failure of the Standard to get what it wanted was bound to do, and with good reason. The Tidewater's growth, in the face of the Standard's constant interference with its business, was proof that independent pipelines and independent refineries could be built up if men had sufficient brains and courage and patience. What one set of men had done, another could do. Their hope of restoring freedom of competition to the oil business was still further brightened in June by the news that the legislature of Pennsylvania had passed a free pipeline bill, the measure that they had been urging for 12 years without avail. With a sturdy example of independence, like the Tidewater, before them, and the right of eminent domain for pipes, the future of competition in oil seemed to be up to the oilmen themselves. But the oil regions have always been prone to jump at conclusions. They were forgetting Mr. Rockefeller's record when they concluded that he was through with the Tidewater, because he had failed in his old South Improvement Company trick, that is, failed to create a panic among Tidewater stockholders, and so get their property at panic prices, was no reason at all to suppose he had abandoned the chase. There still remained a legitimate method of getting into the company, and, as a last resort, Mr. Rockefeller accepted it. He bought the minority stock of the concern, held by the Taylor party. Up to this time Mr. Rockefeller had appeared in Tidewater affairs as a destroyer. He now appeared in a role in which he is quite as able as a pacifier, and his extraordinary persuasiveness was never exercised to better effect. "We own $200,000 worth of your stock," he could tell the people he had been fighting. "If you will consent to confine yourselves to a fixed percentage of our joint business, and will sustain pipage rates and the price of refined oil, we will let you alone. Let us dwell together in peace." The Tidewater, tired of the fight, accepted. And so these men, to whom the oil business owes one of its most remarkable developments, who, in face of the most powerful and unscrupulous opposition, had in 4 years built up a business worth $5.5 million, signed contracts in October 1883, fixing the relative amount of business they were henceforth to do as 11.5% of the aggregate, the Standard having 88.5%. The two simply became allies. The agreement between them was the same in effect as all Mr. Rockefeller's running agreements. It limited and kept up prices. 89. Any benefit the oil business might have reaped from natural and decent competition between the two was of course ended by the alliance. For all practical purposes, the two were one. In the phrase of the region, the tidewater had gone over to the Standard, and there it has always remained. The contract was made for 15 years, but since its expiration it has been lived up to honorably by both parties without other than a verbal understanding. 4. Note this, Mr. Rockefeller always keeps his word. Indeed, in studying his career, one is frequently reminded of Tom Sawyer's great resolution never to sully piracy by dishonesty. The tidewater has prospered within the boundary Mr. Rockefeller drew for it, as those who have accepted submissively his boundaries have never failed to do. Mr. Rockefeller is right when he says, as he does so often, that all who come with him prosper. That the company would have succeeded in becoming eventually a formidable rival of the Standard, and in controlling much more than 11% of the business, no one can doubt who knew Mr. Benson, Major Hopkins, Mr. McKelvey, and their colleagues. They were businessmen of the first order, as their tremendous work from 1878 to 1883 shows. Once more the good of the oil business was secure, and Mr. Rockefeller at once proceeded to arrange his great house in the new order made necessary by the introduction of the seaboard pipeline. The entire transportation department of the business had to be reorganized. When the seaboard pipeline became a factor in the oil business, in 1879, the Standard Oil Company owned practically the entire system of oil gathering pipelines, that is, the lines carrying oil from the wells to the storing or shipping points. These lines were organized under the name of the United Pipelines, and the organization was magnificent in both extent and in character of service rendered. Never, indeed, has the ability of the men Mr. Rockefeller gathered into his machine shown to better advantage than in the building up and management of the pipeline business. At the end of 1883, when the alliance was made with the Tidewater, the United Pipelines were taking from the wells of Pennsylvania fully 1.5 million barrels of oil a month. Their pipes, of an aggregate length of 3,000 miles, connected with thousands of wells scattered all over the wide oil regions. Whenever the oil men opened a new field, no matter how remote from those already developed, the United Pipelines immediately went there to care for the oil. In more than one case, in these years of rapid and excessive development of oil territory, the pipeline company invested great sums in preparing to take care of oil fields whose yield never paid the cost of the pipe laid. Thus, in 1882, there was a tremendous excitement over the opening of the Cherry Grove field. The Standard spent $2 million getting ready to take care of a great outpouring of oil which came, but did not stay. In 1882, Cherry Grove produced 2,345,400 barrels, in 1883, 755,512. It cost the company 46 cents a barrel to take care of the production of one short-lived group of wells in this field, on which they never realized more than 20 cents pipage. The Standard not only gathered this oil, it stored it, to wait its owner's demand. At this date it controlled 40 million barrels of iron tankage, in which it stored the enormous stocks, over 35 million barrels, which had accumulated in the 5 previous years. When the oil passed to the pipeline, the owner received his money for it at once, if he wished, or the line carried it. When a producer had 1,000 barrels In the line, he received a pipeline certificate for it. In December of 1883, the United Pipelines had issued certificates for nearly all of the 35 million barrels of stocks above ground. The oil men thus had a bank for their oil, a bank recognized generally as sound as any in the United States. Such were the returns from the pipeline for its services that no business ever justified more fully the extraordinary outlays of money and energy which it had taken to perfect it. For each barrel of oil the United Pipelines gathered, they received, when it was taken from the lines, 20 cents. The service cost them perhaps 2 cents after installation, though in these years, when they were obliged to carry some 30 million barrels, they had constantly $6 million on their books, on which they did not at once realize. They could afford to let this sum stand because of the storage charge. For every 1,000 barrels carried in their tanks they received $6.25 each, 15 days, $1.52 a year. Now, tankage did not cost over $250 per 1,000 barrels, so that the storage more than paid its cost in 2 years. There were often great losses by fire, but these were paid by the owners of the oil, a pro rata assessment being made. There was a deterioration in quantity and quality of oil from holding, but this again was paid by the owners in a shrinkage charge of 3 per cent, deducted from the quantity of oil when run. Thus on every side the pipeline business was guarded. So long as it could keep out competition and hold up its prices, there was no better paying business in the United States than piping oil. As we have seen, Mr. Rockefeller began to add long-distance pipelines to his business as soon as the Tidewater demonstrated their feasibility. And before the time the Tidewater was brought into harmony, he had a complete system to the seaboard and to his inland refinery points, organized under the name of the National Transit Company. The United Pipelines and the National Transit Company were really one business, the former consisting of local lines and the other of trunk lines, and to make the organization more compact the former was transferred to the latter on April 1, 1884. The paid-up capital of the concern at this date was $31 million. Just as Mr. Rockefeller claimed, in 1878, that he was prepared to enter into a contract to refine all the petroleum that could be sold in the markets of the world, so now he could announce that he was prepared to gather, store and transport all the crude petroleum not only that the markets of the world demanded, but that the producers took from the ground. As things now stood, the only remaining point where he could possibly be affected by competition was the railroads. A new relation to the railroads was created by the new development. Mr. Rockefeller was not only independent of them, he was their competitor, for, like them, he was a common carrier obliged to transport what was offered. His open rate to New York was 45 cents, to Philadelphia 40, though the actual service probably did not cost over 10 cents. By the alliance with the Tidewater, any danger of competition from a pipeline, which could of course afford to cut the price, was shut off. The railroads might possibly, however, lower the prices a little and still make a profit. It was very necessary that the price be kept up in order that too much encouragement should not be given to outside refiners. The only group which threatened to grow to large proportions, at this time, was in the oil regions, a group which was the direct outgrowth of the Compromise of 1880. As will be remembered, the agreement with the Pennsylvania Railroad made then stipulated that all rates should be open, and that if a rebate was given to one shipper another could have it on demand. After the compromise, Pennsylvania had undertaken again to stimulate the growth of independent refineries, and several plants had been built in Titusville and Oil City, having removed the New York group from competition by the alliance. With the Tidewater, it was Mr. Rockefeller's business to make it as hard as possible for the independents in the oil regions to do business, and to do this he must make a contract with the Pennsylvania. Moreover, when Mr. Rockefeller entered New Jersey with his seaboard pipeline, he had been obliged to cross the Pennsylvania Railroad. He could not do so without the consent of the company, there being no free pipeline in the country. He accordingly had been obliged to make a traffic arrangement with them to get his pipe through. A new arrangement was now necessary in order to prevent competition, and in August 1884, a contract was signed, for considerations mutually interchanged, by which the National Transit Company agreed to give to the Pennsylvania Railroad 26 per cent of all petroleum brought to the Atlantic seaboard by all existing carriers, whether rail or pipe, now engaged in transporting such property, or which may hereafter engage in such transportation in conjunction with the Transit Company's pipes. At the same time that the Transit Company agreed to give the railroad this amount of oil, it also signed an agreement to carry this oil for the railroad on a sliding scale. When the open rate of the pipeline was 40 cents to Philadelphia, the railroad was to pay the company 8 cents with each 5 cents difference, up or down, in the open rate. There was to be 1 cent difference to the railroad, the transit never to receive less than 6 or more than 10 cents. 90. Suppose, for example, that the entire seaboard shipment of oil in the month ending December 20, 1884, had been 1 million barrels. 260,000 barrels belonged to the Pennsylvania. If the Transit Company ran all the railroads percentage, it would get 8 cents a barrel for the service, $20,800. And it would pay the railroad $104,000 less $20,800, or $83,200. The pipeline probably never ran the whole amount. More or less refined oil, naphtha, benzene, and other petroleum products would necessarily go by rail. Large sums were paid monthly by the National Transit, however, to the railroad. Mr. Rockefeller seems to have been paying the Pennsylvania Railroad this money not to compete with him as an oil carrier. It would be difficult to find in our variegated commercial history a more beautiful example of the beneficence of combination to those in the deal. With the removal of danger of any competition by the Pennsylvania Railroad, the Transportation Department of the Standard Oil Trust seems to have been as nearly a perfect machine, both in efficiency and in its monopolistic power, as ever has been devised. It was more perfect, indeed, than the refining end of the trust, for independent refiners did exist, and since 1880 they had been showing increasing vigor, whereas there seemed now no opportunity for an independent pipeline ever again to develop. Who, with the Tidewater's story in mind, would be bold enough to attempt to reach the sea? For the time being, then, the Standard Oil Company had things all its own way. It collected with its ally, the Tidewater, practically the entire output of a great raw product. It manufactured fully 90 per cent of this product, and aimed to manufacture 100%. It was a common carrier, and so obliged to deliver oil to rival refineries if they called for it, but these refineries paid 40 or 45 cents for a service which cost the Standard Oil Trust not over 1/4 of the sum. Mr. Rockefeller had every reason to be satisfied with oil transportation in 1884, but there was a part of the oil business which was not so completely in his grasp. The markets of the country were still open. There the few independent refiners who had escaped strangulation were free to barter as they could. But the right to make all the oil in the world, which Mr. Rockefeller claimed, carried with it the right to sell all the oil the world consumed. The independent was therefore a poacher in the market and must be driven out. Chapter 10. Cutting to Kill. Rockefeller now plans to organize oil marketing as he had already organized oil transporting and refining wonderfully efficient and economical system, installed curious practices, introduced reports of competitors' business secured from railway agents, competitors' clerks sometimes secured as allies, in many instances full records of all oil shipped are given standard by railway and steamship companies. This information is used by Standard to fight competitors driven out by underselling. Evidence from all over the country pretended independent oil companies started by they. Standard's explanation of these practices is not satisfactory. Public derives no benefit from temporary lowering of prices made abnormally high when competition is destroyed. To know every detail of the oil trade, to be able to reach at any moment its remotest point, to control even its weakest factor, this was John D. Rockefeller's ideal of doing business. It seemed to be an intellectual necessity for him to be able to direct the course of any particular gallon of oil from the moment it gushed from the earth until it went into the lamp of a housewife. There must be nothing in his great machine he did not know to be working right. It was to complete this ideal, to satisfy this necessity, that he undertook, late in the 70s, to organize the oil markets of the world, as he had already organized oil refining and oil transporting. Mr. Rockefeller was driven to this new task of organization not only by his own curious intellect. He was driven to it by that thing so abhorrent to his mind, competition. If, as he claimed, the oil business belonged to him, and if, as he had announced, he was prepared to refine all the oil that men would consume, it followed as a corollary that the markets of the world belonged to him. In spite of his bold pretensions and his perfect organization, a few obstinate oil refiners still lived and persisted in doing business. They were a fly in his ointment, a stick in his wonderful wheel. He must get them out, otherwise the great purpose would be unrealized. And so, while engaged in organizing the world's markets, he incidentally carried on a campaign against those who dared intrude there. When Mr. Rockefeller began to gather the oil markets into his hands, he had a task whose field was literally the world, for already, in 1871, the year before he first appeared as an important factor in the oil trade, refined oil was going into every civilized country of the globe. Of the 5.5 million barrels of crude oil produced that year, the world used 5 millions, over 3.5 of which went to foreign lands. This was the market which had been built up in the first 10 years of business by the men who had developed the oil territory and invented the processes of refining and transporting, and this was the market, still further developed, of course, that Mr. Rockefeller inherited when he succeeded in corralling the refining and transporting of oil. It was this market he proceeded to organize. Illustration: John D. Rockefeller in 1880. From a photograph by Sereny. The process of organization seems to have been natural and highly intelligent. The entire country was buying refined oil for illumination. Many refiners had their own agents out looking for markets, others sold to wholesale dealers, or jobbers, who placed trade with local dealers, usually grocers. Mr. Rockefeller's business was to replace independent agents and jobbers by his own employees. The United States was mapped out and agents appointed over these great divisions. Thus, a certain portion of the Southwest, including Kansas, Missouri, Arkansas and Texas, the Waters Pierce Oil Company, of St. Louis, Missouri, had charge of a portion of the South including Kentucky, Tennessee and Mississippi. Chess, Carley and Company, of Louisville, Kentucky, had charge of. These companies in turn divided their territory into sections, and put the subdivisions in the charge of local agents. These local agents had stations where oil was received and stored, and from which they and their salesmen carried on their campaigns. This system, inaugurated in the 70s, has been developed until now. The Standard Oil Company of each state has its own marketing department, whose territory is divided and watched over in the above fashion. The entire oil buying territory of the country is thus covered by local agents, reporting to division headquarters. These report in turn to the head of the state marketing department, and his reports go to the general marketing headquarters in New York. To those who know anything of the way in which Mr. Rockefeller does business, it will go without saying that this marketing department was conducted from the start with the greatest efficiency and economy. Its aim was to make every local station as nearly perfect in its service as it could be. The buyer must receive his oil promptly, in good condition, and of the grade he desired. If a customer complained, the case received prompt attention and the cause was found and corrected. He did not only receive oil, he could have proper lamps and wicks and burners, and directions about using them. The local stations from which the dealer is served today are models of their kind, and one can easily believe they have always been so. Oil, even refined, is a difficult thing to handle without much disagreeable odor and stain, but the local stations of the Standard Oil Company, like its refineries, are kept orderly and clean by a rigid system of inspection. Every 2 or 3 months an inspector goes through each station and reports to headquarters on a multitude of details, whether barrels are properly bunged, filled, stenciled, painted, glued, whether tank wagons, buckets, faucets, pipes, are leaking, whether the glue trough is clean, the ground around the tanks dry, the locks in good condition, the horses properly cared for, the weeds cut in the yard. The time the agent gets around in the morning and the time he takes for lunch are reported. The prices he pays for feed for his horses, for coal, for repairs, are noted. In fact, the condition of every local station, at any given period, can be accurately known at marketing headquarters, if desired. All of this tends, of course, to the greatest economy and efficiency in the local agents. But the Standard Oil agents were not sent into a territory back in the 70s simply to sell all the oil they could by efficient service and aggressive pushing. They were sent there to sell all the oil that was bought. The coal oil business belongs to us, was Mr. Rockefeller's motto, and from the beginning of his campaign in the markets his agents accepted and acted on that principle. If a dealer bought but a barrel of oil a year, it must be from Mr. Rockefeller. This ambition made it necessary that the agents have accurate knowledge of all outside transactions in oil, however small, made in their field. How was this possible? The South Improvement Scheme provided perfectly for this, for it bound the railroad to send daily to the principal office of the company reports of all oil shipped, the name of shipper, the quantity and kind of oil, the name of consignee, with the destination and the cost of freight. 91. Having such knowledge as this, an agent could immediately locate each shipment of the independent refiner, and take the proper steps to secure the trade. But the South Improvement Scheme never went into operation. It remained only as a beautiful ideal, to be worked out as time and opportunity permitted. The exact process by which this was done it is impossible to trace. The work was delicate and involved operations of which it was wise for the operator to say nothing. It is only certain that little by little a secret bureau for securing information was built up until it is a fact that information concerning the business of his competitors, almost as full as that which Mr. Rockefeller hoped to get when he signed the South Improvement Company contracts, is his today. Probably the best way to get an idea of how Mr. Rockefeller built up this department, as well as others of his marketing bureau, is to examine it as it stands today. First, then, as to the methods of securing information which are in operation. Naturally and properly the local agents of the Standard Oil Company are watchful of the condition of competition in their districts, and naturally and properly they report what they learn. We ask our salesmen and our agents to keep their eyes open and keep us informed of the situation in their respective fields, a Standard agent told the Industrial Commission in 1898. We ask our agents, as they visit the trade, to make reports to us of whom the different parties are buying, principally to know whether our agents are attending to their business or not. If they are letting too much business get away from them, it looks as if they were not attending to their business. They get it from what they see as they go around selling goods. But there is no such generality about this part of the agent's or salesman's business as this statement would lead one to believe. As a matter of fact, it is a thoroughly scientific operation. The gentleman who made the above statement, for instance, sends his local agents a blank like the following to be made out each month. Illustration. Exhibit BR 92. The local agent gets the information to fill out such a report in various ways. He questions the dealers closely. He watches the railway, freight stations. He interviews everybody in any way connected with the handling of oil in his territory. All of which may be proper enough. When, in the early 80s, Howard Page, of the Standard Oil Company, was in charge of the Standard Shipping Department in Kentucky, his agents visited the depots once a day to see what oil arrived there from independent shippers. A record of these shipments was made and reported monthly to Mr. Page. He was able to tell the Interstate Commerce Commission, in 1887, almost exactly what his rivals had been shipping by rail and by river. Mr. Page claimed that his agents had no special privileges, that anybody's agents would have been allowed to examine the incoming cars, note the consignor, contents, and consignee. It did not appear in the examination, however, that anybody but Mr. Page had sent agents to do such a thing. The Waters Pierce Oil Company, of St. Louis, once paid one of its Texas agents this unique compliment: "We are glad to know you are on such good terms with the railroad people that Mr. Clem, an agent handling independent oil, gains nothing by marking his shipments by numbers instead of names." In the same letter the writer said, "Would be glad to have you advise us when Clem's first 2 tanks have been emptied and returned, also the second 2 to which you refer, as having been in the yard 9 and 16 days, that we may know how long they have been held in Dallas. The movement of tank cars enters into the cost of oil, so it is necessary to have this information that we may know what we are competing with." 93. The superior receiving the filled blanks carefully follows them by letters of instructions and inquiries, himself keeping track of each dealer, however insignificant, in the local agent's territory, and when one out of line has been brought in, never failing to compliment his subordinate. But however diligent the agent may be in keeping his eyes open, however he may be stirred to activity by the prodding and compliments of his superiors, it is of course out of the question that he get anything like the full information the South Improvement Scheme ensured. What he is able to do is supplemented by a system which compares very favorably with that famous scheme and which undoubtedly was suggested by it. For many years independent refiners have declared that the details of their shipments were leaking regularly from their own employees or from clerks in freight offices. At every investigation made, these declarations have been repeated and occasional proof has been offered. For instance, a Cleveland refiner, John Teagle, testified in 1888 to the Congressional Committee that one day in 1883 his bookkeeper came to him and told him that he had been approached by a brother of the secretary of the Standard Oil Company at Cleveland, who had asked him if he did not wish to make some money. The bookkeeper asked how, and after some talk he was informed that it would be by his giving information concerning the business of his firm to the Standard. The bookkeeper seems to have been a wary fellow, for he dismissed his interlocutor without arousing suspicion and then took the case to Mr. Teagle, who asked him to make some kind of an arrangement in order to find out just what information the Standard wanted. The man did this. For $25 down and a small sum per year he was to make a transcript of Mr. Teagle's daily shipments with net price received for the same. He was to tell what the cost of manufacturing in the refinery was, the amount of gasoline and naphtha made and the net price received for them, what was done with the tar, and what percentage of different grades of oil was made, also how much oil was exported. This information was to be mailed regularly to Box 164 of the Cleveland Post Office. Mr. Teagle, who at that moment was hot on the tracks of the Standard in the courts, got an affidavit from the bookkeeper. This he took with the money which the clerk had received to the secretary of the Standard Oil Company and charged him with bribery. At first the gentleman denied having any knowledge of the matter, but he finally confessed and even took back the money. Mr. Teagle then gave the whole story to the newspapers, where it, of course, made much noise. Several gentlemen testified before the recent Industrial Commission to the belief that their business was under the constant espionage of the Standard Oil Company. Theodore Westgate, an oil refiner of Titusville, told the commission that all of his shipments were watched. The inference from his testimony was that the Standard Oil Company received reports direct from the freight houses. Lewis Emery, Jr., of Bradford, a lifelong contestant of the Standard, declared that he knew his business was followed now in the same way as it was in 1872 under the South Improvement Company contract. He gave one or two instances from his own business experience to justify his statements, and he added that he could give many others if necessary. Mr. Gall, of Montreal, Canada, declared that these same methods were in operation in Canada. When our tank cars come in, Mr. Gall told the commission, the Standard Oil Company have a habit of sending their men, opening a tank car, and taking a sample out to see what it contains. Mr. Gall declared that he knew this a long time before he was able to get proof of it. He declared that they knew the number of cars that he shipped and the place to which they went, and that it was their habit to send salesmen after every shipment. Mrs. G. C. Butts, a daughter of George Rice, an independent refiner of Marietta, Ohio, told the Ohio Senate Committee which investigated trusts in 1898 that a railroad agent of their town had notified them that he had been approached by a Standard representative, who asked him for a full report of all independent shipments, to whom and where going. The agent refused, but, said Mrs. Butts, we found out later that someone was giving them this information and that it was being given right from our own works. A party writing us from the Waters Pierce office wrote that we had no idea of the network of detectives, generally railroad agents, that his company kept, and that everything that we or our agents said or did was reported back to the managers through a regular network of detectives who were agents of the railroads and oil company as well. But while the proofs the independents have offered of their charges show that such leaks have occurred at intervals all over the country, they do not show anything like a regular system of collecting information through this channel. From the evidence, one would be justified in believing that the cases were rare, occurring only when a not over nice Standard manager got into hot competition with a rival and prevailed upon a freight agent to give him information to help in his fight. In 1903, however, the writer came into possession of a large mass of documents of unquestionable authenticity, bearing out all and more than the independents' charge. They show that the Standard Oil Company receives regularly today, at least from the railroads and steamship lines represented in these papers, information of all oil shipped. A study of these papers shows beyond question that somebody having access to the books of the freight office's records regularly each oil shipment passing the office, the names of consignor and consignee, the addresses of each, and the quantity and kind of oil are given in each case. This record is made out usually on a sheet of blank paper, though occasionally the recorder has been indiscreet enough to use the railroad company's stationery. The reports are evidently intended not to be signed, though there are cases in the documents where the name of the sender has been signed and erased, in one case a printed head bearing the name of the freight agent had been used. The name had been cut out, but so carelessly that it was easy to identify him. These reports had evidently been sent to the office of the Standard Oil Company, where they had received a careful examination, and the information they contained had been classified. Wherever the shipment entered was from one of the distributing stations of the Standard Oil Company, a line was drawn through it, or it was checked off in some way. In every other case, in the mass of reports there was written, opposite the name of the consignee, the name of a person known to be a standard agent or salesman in the territory where the shipment had gone. Now what is this for? Copies of letters and telegrams accompanying the reports show that as soon as a particular report had reached Standard headquarters and it was known that a carload, or even a barrel, of independent oil was on its way to a dealer, the Standard agent whose name was written after the shipment on the record had been notified. If you can stop car going to X, authorize rebate to Z, name of dealer, of 3/4 cent per gallon, one of the telegrams reads. There is plenty of evidence to show how an agent receiving such information stops the oil. He persuades the dealer to countermand the order. George Rice, when before the House Committee on Manufactures in 1888, presented a number of telegrams as samples of his experience in having orders countermanded in Texas. 4 of these were sent on the same day from different dealers in the same town, San Angelo. Mr. Rice investigated the cause, and, by letters from the various firms, learned that the Standard agent had been around threatening the trade that if they bought of me they would not sell them any more, as he put it. Mrs. Butts in her testimony in 1898 said that her firm had a customer in New Orleans to whom they had been selling from 500 to 1,000 barrels a month, and that the Standard representative made a contract with him to pay him $10,000 a year for 5 years to stop handling the independent oil and take Standard Oil. Mrs. Butts offered as evidence of a similar transaction in Texas the following letter. Lockhart, Texas, November 30, 1894. Mr. Keenan, who is with the Waters Pierce people at Galveston, has Made us several visits and made us propositions of all kinds to get us out of the business. Among others, he offered to pay us a monthly salary if we would quit selling oil and let them have full control of the trade, and insisted that we name a figure that we would take and get out of the business, and also threatened that if we did not accept his proposition they would cut prices below what oil cost us and force us out of business. We asked him the question, should we accept his proposition, would they continue to sell oil as cheap as we were then selling it, and he stated most positively that they would advance the price at once should they succeed in destroying competition. J.S. Lewis and Company. In the Ohio investigation of 1898, John Teagle, of Cleveland, being upon his oath, said that his firm had had great difficulty in getting goods accepted because the standard agents would persuade the dealers to cancel the orders. They would have their local man, or some other man, call upon the trade and use their influence and talk lower prices, or make a lower retail price, or something to convince them that they'd better not take our oil, and, I suppose, to buy theirs. Mr. Teagle presented the following letter, signed by a standard representative, explaining such a countermand. Des Moines, Iowa, January 14, 1891. John Fowler. Hampton, Iowa. Dear Sir, our Marshalltown manager, Mr. Ruth, has explained the circumstances regarding the purchase and subsequent countermand of a car of oil from our competitors. He desires to have us express to you our promise that we will stand all expense provided there should be any trouble growing out of the countermand of this car. We cheerfully promise to do this. We have the best legal advice which can be obtained in Iowa, bearing on the points in this case. An order can be countermanded either before or after the goods have been shipped, and, in fact, can be countermanded even if the goods have already arrived and are at the depot. A firm is absolutely obliged to accept a countermand. The fact that the order has been signed does not make any difference. We want you to absolutely refuse, under any circumstances, to accept the car of oil. We are standing back of you in this matter, and will protect you in every way, and would kindly ask you to keep this letter strictly confidential. Yours truly, E. P. Pratt. Peter Scholl, of the Independent Oil Company of Mansfield, Ohio, testified before the same committee to experiences similar to those of Mr. Teagle. If I put a man on the road to sell goods for me, said Mr. Scholl, and he takes orders to the amount of 200 to 300 barrels a week, before I am able to ship these goods possibly, the Standard Oil Company has gone there and compelled those people to countermand those orders under a threat that, if they don't countermand them, they will put the price of oil down to such a price that they cannot afford to handle the goods. In support of his assertion, Mr. Scholl offered letters from firms he has been dealing with. The following citations show the character of them. Tiffin, Ohio, February 1, 1898. Independent Oil Company. Mansfield, Ohio. Dear Sirs, the Standard Oil Company, after your man was here, had the cheek to come in and ask how many barrels of oil we bought and so forth, then asked us to countermand the order, saying it would be for our best. We understand they have put their oil in our next door and offer it at 6 cents per gallon, at retail. Shall we turn tail? Or show them fight? If so, will you help us out any? Yours truly, Talbot and Son. Tiffin, Ohio, January 24, 1898. Independent Oil Company. Dear Sirs, I am sorry to say that a Standard Oil man from your city followed that oil car and oil to my place, and told me that he would not let me make $1 on that oil, and was dogging me around for 2 days to buy that oil, and made all kinds of threats and talked to my people of the house while I was out, and persuaded me to sell, and I was in a stew what I should do, but I yielded, and I have been very sorry for it since. I thought I would hate to see the bottom knocked out of the prices, but that is why I did it, the only reason. The oil was all right. I now see the mistake, and that is of getting a carload, 2 carloads coming in here inside of a week is more than the other company will stand. Yours truly, H.A. Irick. In case the agent cannot persuade the dealer to countermand his order, more strenuous measures are applied. The letters quoted above hint at what they will be. Many letters have been presented by witnesses under oath in various investigations showing that Standard Oil agents in all parts of the country have found it necessary for the last 25 years to act at times as these letters threaten. One of the most aggressive of these campaigns waged at the beginning of this war of exterminating independent dealers was by the Standard marketing agent at Louisville, Kentucky, Chess, Carley and Company. This concern claimed a large section of the South as its territory. George Rice, of Marietta, Ohio, had been in this field for 8 or 10 years, having many regular customers. It became Chess, Carley and Company's business to secure these customers and to prevent his getting others. Mr. Rice was handicapped to begin with by railroad discrimination. He was never able to secure the rates of his big rival on any of the southern roads. In 1888, the Interstate Commerce Commission examined his complaints against 8 different southern and western roads, and found that no one of them treated him with relative justice. Railroad discriminations were not sufficient to drive him out of the Southwest, however, and a war of prices was begun. According to the letters Mr. Rice himself has presented, he certainly in some cases began the cutting, as he could well afford to do. For instance, Chess, Carley and Company were selling water white oil in September 1880, in Clarksville, Tennessee, at 21 cents a gallon delivered in carloads. Export oil was selling in barrels in New York at that date at 10 cents a gallon. Rice's agent offered at 18 cents. The dealer to whom he made the offer, Armstrong by name, wished to accept, but as he had been buying of Chess, Carley and Company, went first to see them about the matter. He came back scared almost out of his boots, wrote the agent to Rice. Carley told him he would break him up if he bought oil of anyone else, that the Standard Company had authorized him to spend $10,000 to break up any concern that bought oil from anyone else, that he, Carley, would put all his drummers in the field to hunt up Armstrong's customers and sell his customers' groceries at 5 per cent below Armstrong's prices, and turn all Armstrong's trade over to Moore, Bremaker and Company, and settle with Moore, Bremaker and Company for their losses in helping to break Armstrong up, every 30 days. That if Armstrong sent any other oil to Clarksville, Tennessee, he, Carley, would put the price of oil so low in Clarksville as to make the party lose heavily, and that they, the Standard, would break up anyone that would sell him, Armstrong, oil, and that he, Carley, had told Steege and Riling the same thing. Did you ever? What do you think of that? Illustration. Very soon after this, Chess, Carley and Company took in hand a Nashville firm, Wilkinson and Company, which was buying of Rice. It is with great reluctance, they wrote, that we undertake serious competition with any one, and certainly this competition will not be confined to coal oil or any one article, and will not be limited to any 1 year. We always stand ready to make reasonable arrangements with anyone who chooses to appear in our line of business, and it will be unlike anything we have done heretofore if we permit anyone to force us into an arrangement which is not reasonable. Any loss, however great, is better to us than a record of this kind. And 4 days later they wrote, if you continue to bring on the oil, it will simply force us to cut down our price, and no other course is left to us but the one we have intimated. Wilkinson and Company seem to have stuck to Rice's oil, for 16 months later we find Chess, Carley and Company calling on the agent of a railroad, which already was giving the standard discriminating rates, to help in the fight. The screw was turned, Mr. Rice affirms, his rate being raised 50% in 5 days. Rice carried on his fight for a market in the most aggressive way, and everywhere he met disastrous competition. In 1892 he published a large pamphlet of documents illustrating standard methods, in which he included citations from some 70 letters from dealers in Texas, received by him between 1881 and 1889, showing the kind of competition his oil met there from the Waters Pierce Oil Company, the Standard's Texas agents. A dozen sentences, from as many different towns, will show the character of them all. I have had wonderful competition on this car. As soon as my car arrived, the Waters Pierce Oil Company, who has an agent here, slapped the price down to $1.80 per case. 110. Oil was selling at this point for $2.50 per case, and as soon as your car arrived it was put down to $1.50, which it is selling at today. The Waters Pierce Oil Company reduced their prices on brilliant oil from $2.60 to $1.50 per case and is waging a fierce war. Waters Pierce Oil Company has our state by the throat and we would like to be extricated. I would like to handle your oil if I could be protected against the Waters Pierce Oil Company. I am afraid if I would buy a car of oil from you, this company would put the oil way below what I pay and make me lose big money. I can handle your oil in large quantities if you would protect me against them. The Waters Pierce Oil Company has cut the stuffing out of coal oil, and have been ever since I got in my last car. They put the price to the merchants at $1.80 per case. We have your quotations on oil, while they are much lower than what we pay, yet unless a carload could be engaged it would pay no firm to try and handle, as Waters Pierce Oil Company would cut below cost. On same the day your oil arrived here, their agent went to all my customers and offered their European oil at 10 cents per gallon in barrels and $1.50 per case, and lower grades in proportion, and told them if they did not refuse to take the oil he would not sell them any more at any price, and that he was going to run me out of the business. And then they would be at his mercy. Now we think Waters Pierce Oil Company have been getting too high a price for their oil. They are able and do furnish almost this entire state with oil. They cut prices to such an extent when any other oil is offered in this state that they force the parties handling the oil to abandon the trade. Trace and hurry up car of oil shipped by you. We learn it is possible that your oil is sidetracked on the line, that Waters Pierce might get in their work. If we were to buy a car or more, the Waters Pierce Oil Company would manage to sell a little cheaper than we could, and continue doing so until they busted me up. In regard to oil, we are about out now, and Waters Pierce have put their oil up again and quote us at the old price. Jobbers say when they take hold of another oil they are at once boycotted by Waters Pierce Oil Company, who not only refuse to sell them, but put oil below what they pay for it, and thus knock them out of the oil trade, unless they sell at a loss. If I find that I can handle your oil in Texas without being run out and losing money by this infernal corporation, the Waters Pierce Oil Company, I want to arrange with you to handle it extensively. I received verbal notice this morning from their agent that they would make it hot for me when my oil got here. Mr. Rice claims, in his preface to the collection of letters here quoted from, that he has hundreds of similar ones from different states in the Union, and the writer asked to examine them. The package of documents submitted in reply to this request was made up literally of hundreds of letters. They came from 12 different states, and show everywhere the same competitive method cutting to kill. One thing very noticeable in these letters is the indignation of the dealers at the standard methods of securing trade. They resent threats. They complain that the standard agents knows about their premises, that they ask impudent questions, and that they generally make the trade disgusting and humiliating. In Mississippi, in the 80s, the indignation of the small dealers against Chess, Carley and Company was so strong that they formed associations binding themselves not to deal with them. These same tactics have been kept up in the Southwest ever since. A letter, dated April 28, 1891, from the Vice President of the Waters Pierce Oil Company, A.M. Finlay, to his agent at Dallas, Texas, says bluntly, "We want to make the prices at Dallas and in the neighborhood on brilliant and water white oil, that will prevent Clem, an independent dealer, from doing any business." And Mr. Finlay adds, "Hope you will make it a point to be present at the next meeting of the City Council tomorrow night and do everything possible to prevent granting a permit to build within the city limits, unless building similar to ours is constructed, for it would not be fair to us to allow someone else to put up constructions for the storage of oil, when they had compelled us to put up such an expensive building as we have." 94. Mr. Rice is not the only independent oil dealer who has produced similar testimony. Mr. Teagle and Mr. Scholl, in Ohio, have furnished considerable. "The reason we quit taking your oil is this," wrote a Kansas dealer to Schofield, Shima, and Teagle, in 1896, "The Standard Oil Company notified us that if we continued handling your oil they would cut the oil to 10 cents retail, and that we could not afford to do, and for that reason we are forced to take their oil or do business for nothing or at a loss. The standard agent has repeatedly told me that if I continued buying oil and gasoline from your wagon," wrote an Ohio dealer to the same firm in 1897, "they would have it retailed here for less than I could buy." I paid no attention to him, but yesterday their agent was here and asked me decidedly if I would continue buying oil and gasoline from your wagon. I told him I would do so, then he went and made arrangements with the dealers that handle their oil and gasoline to retail it for 7 cents. Mr. Scholl summed up his testimony before the same committee to which Mr. Teagle gave the above, by declaring, "You take $10,000 and go into the business and I will guarantee you won't be in business 90 days. Their motto is that anybody going into the oil business in opposition to them, they will make life a burden to him. That is about as near as you can get to it." Considerable testimony of the same sort of practices was offered in the recent hearing before the Industrial Commission, most of it general in character. The most significant special case was offered by Mr. Westgate, the treasurer of the American Oil Works, an independent refinery of Titusville, Pennsylvania. The American Oil Works, it seems, were in 1894 shipping oil called Sunlight in barrels to South Bend, Washington. This was in the territory of the Standard agents at Portland, Oregon, one of whom wrote to a South Bend dealer when he heard of the intrusion, "We will state For your information that never a drop of oil has reached South Bend of better quality than what we have always shipped into that territory. They can name it sunlight, moonlight, or starlight, it makes no difference. You can rest assured if another carload of sunlight arrives at your place, it will be sold very cheap. We do not purpose to allow another carload to come into that territory unless it comes and is put on the market at one half its actual cost. You can convey this idea to the young man who imported the carload of sunlight oil. When John D. Archbold, of the Standard Oil Company, had his attention called to this letter by Professor Jenks, of the Industrial Commission, Mr. Archbold characterized the letter as a foolish statement by a foolish and unwise man and promised to investigate it. Later he presented the commission with an explanation from the superior of the agent, who declared that the writer of the letter did not have any authority to say that oil would be sold on the basis mentioned. The letter, he continued, was intended to be written in a jocular manner, to deny a claim that he was selling oil inferior in quality to that sold by others. It is hard for the mere outsider to catch the jocularity of the letter, and it must have been much more difficult for the dealer who received it to appreciate it. Independent oil dealers of the present day complain bitterly of a rather novel way employed by the Standard for bringing into line dealers whose prejudices against buying from them are too strong to be overcome by the above methods. This is through what are called bogus oil companies. The obdurate dealer is approached by the agent of a new independent concern, call it the ABC Oil Company, for illustration. The agent seeks trade on the ground that he represents an independent concern and that he can sell at lower prices than the firm from which the dealer is buying. Gradually he works his way into the independent's trade. As a matter of fact, the new company is merely a standard jobbing house which makes no oil, and which conceals its real identity under a misleading name. The mass of reports from railroad freight offices quoted from in this article corroborate this claim of the independents. The ABC Oil Company is mentioned again and again as shipping oil, and in the audited reports it is always checked off in the same fashion as the known Standard companies, and none of its shipments is referred to Standard agents. Independents all over the country tell of loss of markets through underselling by these bogus companies. The lower price which a supposedly independent concern gives to a dealer who will not, under any condition, buy of the Standard, need not demoralize the Standard trade in the vicinity if the concession is made with caution. After the trade is secure, that is, after the genuine independent is ousted, the masquerading concern always finds itself obliged to advance prices. When the true identity of such a company becomes known, its usefulness naturally is impaired, and it withdraws from the field and a new one takes its place. There is never a dealer in oil too small to have applied the above methods of competition. In recent years they have frequently been applied even to oil peddlers. In a good many towns of the country oil is sold from door to door by men whose whole stock in trade is their peddling wagons. Many of these oil peddlers build up a good trade. As a rule they sell Standard oil. Let one take independent oil, however, and the case is at once reported. His customers are located and at once approached by a Standard tank wagon man, who frequently, it is said, not only sells at a lower price than they have been paying, but even goes so far as to clean and fill the lamps. In these raids on peddlers of independent oil, refined oil has been sold in different cities at the doors of consumers at less than crude oil was bringing at the wells, and several cents per gallon less than it was selling to wholesale dealers. In refined, it is claimed by independents that at the present time they Bogus companies generally manage this matter of driving out peddlers, thus saving the Standard the unpopularity of the act and the dissatisfaction of the rise in price which, of course, follows as soon as the trade is secured. The general explanation of these competitive methods which the Standard officials have offered, is that they originate with overzealous employees and are disapproved of promptly if brought to the attention of the heads of the house. The cases seem rather too universal for such an explanation to be entirely satisfactory. Certainly the system of collecting information concerning competitive business is not practiced by the exceptional overzealous employee, but is a recognized department of the Standard Oil Company's business. In the mass of documents from which the reports of oil shipments referred to above were drawn, are certain papers showing that the system is nearly enough universal to call for elaborate and expensive bookkeeping at the headquarters of each Standard marketing division. For instance, on the next page is a fragment illustrating the page of a book kept at such a headquarters. What does this show? Simply that every day the reports received from railroad freight agents are entered in records kept for the purpose. That there is on file at the Standard Oil headquarters a detailed list of the daily shipments which each independent refiner sends out, even to the initials and number on the car in which the shipment goes. From this remarkable record, the same set of documents shows that at least two sets of reports are made up. One is a report of the annual volume of business being done by each particular independent refiner or wholesale jobber. The other of the business of each individual local dealer, so far as the detectives of the Standard have been able to locate it. For instance, among the documents is the report on a well-known oil jobbing house in one of the big cities of the country, reproduced on the next page. Illustration: the figures, dates, consignees, and destination on the above are fictitious. The names of shippers were copied from the original in possession of the writer. A comparison of this report with the firm's own accounts shows that the Standard came within a small % of an accurate estimate of the XYZ's business. Illustration: the above is similar to the form compiled by the Standard Oil Company. Another curious use made of these reports from the freight offices is forming a card catalog of local dealers. See form on page 55. Oil is usually sold at retail by grocers. It is with them that the local agents deal. Now the daily reports from the freight offices show the oil they receive. The competition reports from local agents also give more or less information concerning their business. A card is made out for each of them, tabulating the date on which he received oil, the name and location of the dealer he got it from, the quality, and the price he sells it. In a space left for remarks on the card there is written in red ink any general information about the dealer the agent may have picked up. Often there is an explanation of why the man does not buy Standard Oil. Not infrequently this explanation reads, is opposed to monopolies. It is impossible to say from documentary evidence how long such a card catalog has been kept by the Standard, that it has been a practice for at least 25 years. The following quotation from a letter written in 1903 by a prominent Standard official in the Southwest to one of his agents shows, where competition exists, says the official, it has been our custom to keep a record of each merchant's daily purchase of bulk oil, and I know of one town at least in the Southern Texas division where that record has been kept, whether there was competition or not, for the past 15 years. 95. Illustration: the names, figures, and locations on the above form are fictitious. The remarks are copied from cards in possession of the writer. The inference from this system of keeping the eyes open is that the Standard Oil Company knows practically where every barrel shipped by Every independent dealer goes, and where every barrel bought by every corner grocer from Maine to California comes from. The documents from which the writer draws the inference do not, to be sure, cover the entire country, but they do cover in detail many different states, and enough is known of the standard's competitive methods in states outside this territory to justify one in believing that the system of gathering information is in use everywhere. That it is a perfect system is improbable. Bribery is not as dangerous business in this country as it deserves to be. Of course, nothing but a bribe would induce a clerk to give up such information as these daily reports contain, but, happily, such is the force of tradition that even those who have practiced it for a long time shrink from discovery. It is one of those political and business practices which are only respectable when concealed. Naturally, then, the above system of gathering information must be handled with care, and can never have the same perfection as that Mr. Rockefeller expected when he signed the South Improvement Company Charter. The moral effect of this system on employees is even a more serious feature of the case than the injustice it works to competition. For a consideration, railroad freight clerks give confidential information concerning freight going through their hands. It would certainly be quite as legitimate for post office clerks to allow Mr. Rockefeller to read the private letters of his competitors, as it is that the clerks of a railroad give him data concerning their shipments. Everybody through whose hands such information passes is contaminated by the knowledge. To be a factor, though even so small a one, in such a transaction, blunts one's sense of right and fairness. The effect on the local standard agent cannot but be demoralizing. Prodded constantly by letters and telegrams from superiors to secure the countermand of independent oil, confronted by statements of the amount of sales which have gotten away from him, information he knows only too well to have been secured by underhand means, obliged to explain why he cannot get this or that trade away from a rival salesman, he sinks into habits of bullying and wheedling utterly inconsistent with self-respect. Is there nothing you independents can do to prevent our people finding out who you sell to? An independent dealer reports a hunted standard agent asking him, "My life is made miserable by the pressure brought on to chase up your sales. I don't like such business. It isn't right, but what can I do?" The system results every now and then, naturally enough, in flagrant cases of bribing employees of the independents themselves. Where the freight office does not yield the information, the rival's own office may, and certainly if it is legitimate to get it from one place it is from the other. It is not an unusual thing for independent refiners to discharge a man whom they have reason to believe gives confidential information to the standard. An outrageous case of this, which occurred some 10 years ago, is contained in an affidavit which has been recently put at the writer's disposition. It seems that in 1892 the Lewis Emery Oil Company, an independent selling concern in Philadelphia, employed a man by the name of Buckley. This man was discharged, and in September of that year he went into the employ of the leading Standard Refinery of Philadelphia, a concern known as the Atlantic Refining Company. According to the affidavit made by this man Buckley, the managers of the Standard concern, sometime in February 1893, engaged him in conversation about affairs of his late employer. They said that if they could only find out the names of the persons to whom their rival sold, and for what prices, they could soon run him out of business. And they asked Buckley if he could not get the information for them. After some discussion, one of the Standard managers said, "What's the matter with the nigger?" alluding to a colored boy in the employment of the Lewis Emery concern. Buckley told them that he would try him. "You can tell the nigger," said one of the men, "that he needn't be afraid, because if he loses his position there's a position here for him." Buckley saw the Negro and made a proposition to him. The boy agreed to furnish the information for a price starting from February 1893. Says Mr. Buckley, and lasting up to about August of the same year, this boy furnished me periodically with the daily shipments of the Lewis Emery concern, which I took and handed personally, sometimes to one end, sometimes to the other manager. They took copies of them, and usually returned the originals. The Negro also brought what is known as the price book to Buckley, and a complete copy of this was made by the standard managers. "In short," says Mr. Buckley in his affidavit, "I obtained from the Negro all the inside facts concerning the Lewis Emery Oil Company's business, and I furnished them all to the standard managers. In return for this information the Negro lad was paid various sums, amounting in all to about $90. Buckley says that they were charged upon the standard books to his special expenses. The transaction was ended by the discharge of the colored boy by the Lewis Emery concern. The denouement of this case is tragic enough. The concern was finally driven out of business by these and similar tactics, so Mr. Emery and his partner both affirm. The Negro was never taken into the Atlantic refinery, and Buckley soon after lost his position, as he of course richly deserved to. A man who shows himself traitorous, lying, thieving, even for the good of the oil business, is never kept long in the employment of the Standard Oil Company. It is notorious in the oil regions that the people who sell to the Standard are never given responsible positions. They may be shifted around to do dirty work, as the oil region's phrase goes, but they are pariahs in the concern. Mr. Rockefeller knows as well as any man ever did the vital necessity of honesty in an organization, and the Buckleys and Negroes who bring him secret intelligence never get anything but money and contempt for their pains. For the general public, absorbed chiefly in the question, how does all this affect what we are paying for oil, the chief point of interest in the marketing contests is that, after they were over, the price of oil has always gone back with a jerk to the point where it was when the cutting began, and not infrequently it has gone higher the public pays. Several of the letters already quoted in this chapter show the immediate recoil of the market to higher prices with the removal of competition. A table was prepared in 1892 to show the effect of competition on the price of oil in various states of the Union. The results were startling. In California, oil which sold at non-competitive points at 26½ cents a gallon, at competitive points brought 17½ cents. In Denver, Colorado, there was an oil war on in the spring of 1892, and the same oil which was selling at Montrose and Garrison at 25 cents a gallon, in Denver sold at 7 cents. This competition finally killed opposition, and Denver thereafter paid 25 cents. The profits on this price were certainly great enough to call for competition. The same oil which was sold in Colorado in the spring of 1892 at 25 cents, sold in New York for exportation at 6.10 cents. Of course the freight rates to Colorado were high. The open rate was said to be 9 cents a gallon. But that it cost the Standard Oil Company 9 cents a gallon to get its oil there, one would have to have documentary proof to believe, and even if it did, there was still some 10 cents profit on a gallon, $5 on a barrel. In Kansas, at this time, the difference between the price at competitive and non-competitive points was 7 cents, in Indiana 6 cents, in South Carolina 4½ cents. 96. In 1897 Schofield, Shima, and Teagle, of Cleveland, prepared a circular showing the difference between prices at competitive and non-competitive points in Ohio, and sent it out to the trade. According to this circular, the public paid from 25 to 33 per cent more where there was no competition. The fact that oil is cheaper where there is competition, and also that the public has to pay the cost of the expensive oil wars, which have been carried on so constantly for the last 25 years, all over the country, is coming to be recognized, especially in the Middle West of this country, by both dealers and communities. There is no question that the attempts of standard agents to persuade or bully dealers into countermanding orders, or giving up an independent with whose oil they are satisfied, meet with much less general success than they once did. It even happens now and then that communities who have had experience with oil wars will stand by an independent dealer for months at a time, resisting even the temptation to have their lamps cleaned and filled at next to nothing. Briefly put, then, the conclusion, from a careful examination of the testimony on standard competitive methods, is this: the marketing department of the Standard Oil Company is organized to cover the entire country, and aims to sell all the oil sold in each of its divisions. To forestall or meet competition, it has organized an elaborate secret service for locating the quantity, quality, and selling price of independent shipments. Having located an order for independent oil with a dealer, it persuades him, if possible, to countermand the order. If this is impossible, it threatens predatory competition, that is, to sell at cost or less, until the rival is worn out. If the dealer still is obstinate, it institutes an oil war. In late years, the cutting and the oil wars are often entrusted to so-called bogus companies, who retire when the real independent is put out of the way. In later years, the Standard has been more cautious about beginning underselling than formerly, though if a rival offered oil at a less price than it had been getting, and generally even small refineries can contrive to sell below the non-competitive prices of the Standard, it does not hesitate to consider the lower price a declaration of war and to drop its prices and keep them down until the rival is out of the way. The price then goes back to the former figure or higher. John D. Archbold's testimony before the Industrial Commission in 1898 practically confirms the above conclusion. Mr. Archbold said that the Standard was in the habit of fighting vigorously to hold and advance its trade, even to the extent of holding prices down to cost until the rival gives way, though he declared it to be his opinion that the history of the company's transactions would show that the competitor forces the fight. Mr. Archbold told the Commission that he personally believed it was not advisable to sell below cost for the sake of freezing out a smaller rival, save in greatly aggravated cases, though he admitted the Standard sometimes did it. The trouble is that, accepting Mr. Rockefeller's foundation principle that the oil business belongs to him, any competition is an aggravated case. All that is reassuring in the situation has come from the obstinate stand of individuals, the refiners, who insisted on doing an independent business, on the theory that this is a free country, the grocers who resented the prying and bullying of Standard agents, and asserted their right to buy of whom they would, the rare, very rare, community that grasped the fact that oil sold below cost temporarily, meant later paying for the fight. These features of the business belong to the last decade and a half. At the period we have reached in this history, that is, the completion of the monopoly of the pipelines in 1884 and the end of competition in transporting oil, there seemed to the independents no escape from Mr. Rockefeller in the market. The sureness and promptness with which he located their shipments seemed Uncanny to them. The ruthlessness and persistence with which he cut and continued to cut their prices drove them to despair. The character of the competition Mr. Rockefeller carried on in the markets, particularly of the South and Middle West of this country, at this time, aggravated daily the feeble refining element, and bred contempt far and wide among people who saw the cutting, and perhaps profited temporarily by it, but who had neither the power nor the courage to interfere. The knowledge of it fed greatly the bitterness in the oil regions. Part of the stock in conversation of every dissatisfied oil producer or ruined refiner became tales of disastrous conflicts in markets. They told of crippled men selling independent oil from a hand cart, whose trade had been wiped out by a standard cart which followed him day by day, practically giving away oil. They told of grocers driven out of business by an attempt to stand by a refiner. They told endless tales, probably all exaggerated. Perhaps some of them false, yet all of them believed, because of such facts as have been rehearsed above. There came to be a popular conviction that the Standard would do anything. It was a condition which promised endless annoyance to Mr. Rockefeller and his colleagues. It meant popular mistrust, petty hostilities, misinterpretations, contempt, abuse. There were plenty of people even willing to deny Mr. Rockefeller ability. That the Standard was in a venture was enough in those people's minds to damn it. Anything the Standard wanted was wrong. Anything they contested was right. A verdict for them demonstrated the corruption of the judge and jury, against them their righteousness. Mr. Rockefeller, indeed, was each year having more reason to realize. Monopoly building had its trials as well as its profits. Chapter 11. The War on the Rebate. Rockefeller's silence belief in the oil regions that combined opposition to him was useless individual opposition still. Conspicuous the Standard's suit against Schofield, Schima and Teagle seeks to enforce an agreement with that firm to limit output of refined oil. Schofield, Schima and Teagle attempt to do business independently of the Standard and its rebates find their lot hard. They sue the Lake Shore and Michigan Southern Railway for discriminating against them, a famous case, and won. The railway loses another case in this war of individuals on the rebate shows the Standard still to be taking drawbacks. The case of George Rice against the receiver of the Cincinnati and Marietta Railroad. The apathy and inaction which naturally flow from a great defeat lay over the oil regions of northwestern Pennsylvania long after the compromise with John D. Rockefeller in 1880, followed, as it was, by the combination with the Standard of the great independent seaboard pipeline which had grown up under the oil men's encouragement and patronage. Years of war with a humiliating outcome had inspired the producers with the conviction that fighting was useless, that they were dealing with a power verging on the superhuman, a power carrying concealed weapons, fighting in the dark, and endowed with an altogether diabolic cleverness. Strange as the statement may appear, there is no disputing that by 1884 the oil regions as a whole looked on Mr. Rockefeller with superstitious awe. Their notion of him was very like that which the English common people had for Napoleon in the first part of the 19th century, which the peasants of Brittany have even today for the English, a dread power, cruel, omniscient, always ready to spring. This attitude of mind, altogether abnormal and daring, impetuous, and self-confident men, as those of the oil regions were, was based on something more than the series of bold and admirably executed attacks which had made Mr. Rockefeller master of the oil business. The first reason for it was the atmosphere of mystery in which Mr. Rockefeller had succeeded in enveloping himself. He seems by nature to dislike the public eye. In his early years his home, his office, and the Baptist Church were practically the only places which saw him. He did not frequent clubs, theaters, public meetings. When his maneuvers began to bring public criticism upon him, his dislike of the public eye seems to have increased. He took a residence in New York, but he was unknown there save to those who did business with him or were interested in his church and charities. His was perhaps the least familiar face in the Standard Oil Company. He never went to the oil regions, and the oil regions said he was afraid to come, which might or might not have been true. Certainly the oil regions never hesitated to express opinions about him calculated to make a discreet man keep his distance. Even in Cleveland, his home for 25 years, Mr. Rockefeller was believed to conceal himself from his townsmen. It is certain that the operations of his great business were guarded with the most jealous care. The New York Sun sent an experienced observer to Cleveland in 1882 to write up the Standard concern. He speaks with amazement in his letters of the atmosphere of secrecy and mystery which he found enveloping everything connected with Mr. Rockefeller. You could not get an interview with him, the observer complained. Even his home papers had ceased to go to the Standard offices to inquire about the truth of rumors which reached them from the outside. The hundreds of employees of the trust in the town were as silent as their master in all that concerned the business, and if one talked well, he was not long an employee of Mr. Rockefeller. There was between the Standard Oil Company and the town and press of Cleveland none of the camaraderie the mutual goodwill and pride and confidence which usually characterize the relations between great businesses and their environment. In Cleveland, as in the oil regions, Mr. Rockefeller's careful effort to cover up his intentions and his tracks had been at first met with jeers and blunt rebuffs, but he had finally succeeded in silencing and awing the people. It is worth noting that while all of the members of the Standard Oil Company followed Mr. Rockefeller's policy of saying nothing, there was no such popular dread of any other one of them. In the oil regions, for instance, there was a bitter hatred of the Standard Oil Company as an organization, but for the most part the people liked the men who served it, and certainly had no awe of them, for these men circulated freely among their fellow townsmen. They were active in all the pleasures and enterprises of the communities in which they lived. They were generous, able, cordial, and whatever the people said of the concern they served, they generally qualified it by expressing their personal likings for the men themselves. A second reason for the popular dread of Mr. Rockefeller was that this man, whom nobody saw and who never talked, knew everything, even unexpected and trivial things, and those who saw the effect of this knowledge and did not see how he could obtain it, regarded him as little short of an omniscient being. There was really nothing in the least occult about Mr. Rockefeller's omniscience. He obtained part of his knowledge of other people's affairs by a most extensive and thoroughly organized system of news gathering, such as any bright businessman of wide sweep might properly employ. But he combined with this perfectly legitimate work the sordid methods of securing confidential information described in the last chapter. Certainly there is nothing of the transcendental in this kind of omniscience, and the feeling of supernaturalism which Mr. Rockefeller had inspired by 1884 has entirely evaporated since, as evidence of his methods has been circulated. The source was, however, long secret, and when again and again men who could hardly suppose their existence known to Mr. Rockefeller saw movements anticipated which they believed known only to themselves and their confidential agents, they began to dread him and to invest him with mysterious qualities. If Mr. Rockefeller had been as great a psychologist as he is business manipulator, he would have realized that He was awakening a terrible popular dread, and he would have foreseen that one day, with the inevitable coming to light of his methods, there would spring up about his name a crop of scorn which would choke any crop of dollars and donations which the wealth of the earth could produce. The effect of this dread was deplorable, for it intensified the feeling, now widespread in the oil regions, that it was useless to make further effort at a combined resistance. And yet these men, who were now lying too supine in Mr. Rockefeller's steel glove even to squirm, had laid the foundation of freedom in the oil business. It has taken 30 years to demonstrate the inestimable value of the efforts which in 1884 they regarded as futile, 30 years to build even a small structure on the foundation they had laid, though that much has been done. The situation was saved at this critical time by individuals scattered through the oil world who were resolved to test the validity of Mr. Rockefeller's claim that the coal oil business belonged to him. "We have a right to do an independent business," they said, "and we propose to do it." They began this effort by an attack on the weak spot in Mr. Rockefeller's armor. The 12 years just past had taught them that the realization of Mr. Rockefeller's great purpose had been made possible by his remarkable manipulation of the railroads. It was the rebate which had made the Standard Oil Trust, the rebate, amplified, systematized, glorified into a power never equaled before or since by any business of the country. The rebate had made the trust, and the rebate, in spite of 10 years of combination, petroleum associations, producers' unions, resolutions, suits in equity, suits in quo warranto, appeals to Congress, legislative investigations, the rebate still was Mr. Rockefeller's most effective weapon. If they could wrest it from his hand, they could do business. They had learned something else in this period, that the whole force of public opinion and the spirit of the law were against the rebate, and that the railroads, knowing this, feared exposure of discrimination, and could be made to settle rather than have their practices made public. Therefore, said these individuals, we propose to sue for rebates and collect charges until we make it so harassing and dangerous for the railroads that they will shut down on Mr. Rockefeller. The most interesting and certainly the most influential of these private cases was that of Schofield, Shima, and Teagle, of Cleveland, one of the firms which, in 1876, entered into a joint adventure with Mr. Rockefeller for limiting the output and so holding up prices. 97 The adventure had been most successful. The profits were enormous. Schofield, Shima and Teagle had made 34 cents a barrel out of their refinery the year before the adventure. With the same methods of manufacture, and enjoying simply Mr. Rockefeller's control of transportation rates and the enhanced prices caused by limiting output, they made $2.52 a barrel the first year after. This was the year of the Standard's first great coup in refined oil. The dividends on 88,000 barrels this year were $222,047, against $41,000 the year before. In 4 years Schofield, Shima, and Teagle paid Mr. Rockefeller $315,345 on his investment of $10,000 and rebates. After 4 years the Standard began to complain that their partners in the adventure were refining too much oil. The first year the books showed they had exceeded their 85,000 barrel limitation by nearly 3,000, the second year by 2,000, the third by 15,000, the fourth by 5,000. Dissatisfied, the Standard demanded that the firm pay them the entire profit upon the excess refined, for, claimed Mr. Rockefeller, our monopoly is so perfect that we would have sold the excess if you had not broken the contract, consequently the profits belong to us. Schofield, Schima and Teagle paid half the profit on the excess, but refused more. And they persisted in exceeding their quota, then Mr. Rockefeller, controlling by this time the crude supply in Cleveland through ownership of the pipelines, shut down on their crude supply. If they would not obey the contract of their own will, they could not do business. The firm seems not to have been frightened. "We are sorry that you refused to furnish us crude oil as agreed," they wrote Mr. Rockefeller. "We do not regard the limitation of 85,000 barrels as binding upon us, and as we have a large number of orders for refined oil we must fill them, and if you refuse to furnish us crude oil on the same favorable terms as yourselves, we shall get it elsewhere as best we can and hold you responsible for its difference in cost." Illustration: William C. Schofield, senior member of the firm of Schofield, Schirmer, and Teagle, of Cleveland, plaintiff in important suits against Lake Shore Railroad for freight discriminations. Illustration: Daniel Schirmer, associate of Mr. Schofield and Mr. Teagle in the War on Railroad rebates which the firm waged for nearly 20 years. Illustration: John Teagle, independent refiner of Cleveland, Ohio, prominent in struggle against freight discriminations by the railroads. Illustration: Charles B. Matthews, independent refiner of Buffalo, plaintiff in Buffalo case, where members of the Standard Oil Company were indicted for conspiracy. Mr. Rockefeller's reply was a prayer for an injunction against the members of the firm, restraining them individually and collectively from distilling at their said works at Cleveland, Ohio, more than 85,000 barrels of crude petroleum of 42 gallons each in every year, and also from distilling any more than 42,500 barrels of crude petroleum of 42 gallons each and every 6 months, and also from distilling any more crude petroleum until the expiration of 6 months from and after July 20, 1880, and also from directly and indirectly engaging in or being concerned in any business connected with petroleum or any of its products except in connection with the plaintiff, under their said agreement, and that on the final hearing of this case, the said defendants may in like manner be restrained and enjoined from doing any of said acts until the expiration of said agreement, and for such other and further relief in the premises as equity can give. In this petition, really remarkable for its unconsciousness of what seems obvious that the agreement was preposterous and void because confessedly, in restraint of trade, the terms of the joint adventure are renewed in a way to illustrate admirably the sort of tactics with refiners which, at this time, was giving Mr. Rockefeller his extraordinary power over the price of oil. 98. Schofield, Schima, and Teagle did not hesitate to take up the gauntlet, and a remarkable defense they made. In their answer they declared the so-called agreement had at all times been utterly void and of no effect, as being by its terms in restraint of trade and against public policy. They declared that the Standard Oil Company had never kept the terms of the agreement, that it had intentionally withheld the benefits of the advantages it enjoyed in freight contracts, and that it now was pumping crude oil from the oil regions to Cleveland at a cost of about 12 cents a barrel and charging them, Schofield, Schima, and Teagle, 20 cents. They denied that the Standard had sustained any damage through them, but claimed that their business had been carried on at a large profit. There is such a large margin between the price of crude oil and refined, declared the defendants, that the manufacture and sale of refined oil is attended with large profit. It is impossible to supply the demand of the public for oil if the business and refineries of both plaintiff and defendant are carried on and run to their full capacities. And if the business of the defendants were stopped, as prayed for by the plaintiff, it would result in a still higher price for refined oil and The establishment of more perfect monopoly in the manufacture and sale of the same by plaintiff. To establish such a monopoly, the defendants went on to declare, had been the sole object of the Standard Oil Company. In making this contract with them, and similar ones with other firms, to establish a monopoly and so maintain unnaturally high prices. 99 and certainly Schofield, Schema, and Teagle knew whereof they swore, for they had shared in the spoils of the winter of 1876 and 1877, and at this very period, October, 1880, they were witnessing an attempt to repeat the coup. The charge of monopoly Schofield, Schema, and Teagle sustained by a remarkable array of affidavits, the most damaging set for the Standard Oil Company which had ever been brought together. It contained the affidavits of various individuals who had been in the refining business in Cleveland at the time of the South Improvement Company and who had sold out in the panic caused by it. It contained a review of the havoc which that scheme and the manipulation of the railroads by the Standard which followed it had caused in the refining trade in Pennsylvania, and it gave the affidavits of Mrs. B. and of her secretary and others concerning the circumstances of her sale in 1878, see Chapter 6. They affidavits filed by John D. Rockefeller, Oliver H. Payne and Henry M. Flagler in reply to the set presented by Schofield, Schema, and Teagle are curious reading. From the point of view of our present knowledge, they deny a number of things now known to be true. 100. It was not necessary, however, for the defendants to have presented their elaborate array of evidence to support the charge of intended monopoly. The character of the agreement itself was sufficient to prevent any judge from attempting to enforce it. The amazement was that the Standard Oil Company ever had the hardihood to ask for its enforcement, that it should venture to ask the assistance of a court of equity to enforce a contract to limit the production and raise the price of an article of so universal use as kerosene oil, said the Chicago Tribune, shows that the Standard Oil Company believed itself to have reached a height of power and wealth that made it safe to defy public opinion. This case is not the only one belonging to the period which goes to support the opinion of the Tribune. Schofield, Schema, and Teagle were now obliged to stand on their own feet. They could refine all the oil they wished, but they must make their own freight contracts, and they found rates when you worked with Mr. Rockefeller were vastly different from rates when you competed with him. The agent of the Lake Shore Railroad, by which most of their shipments went, told them frankly that they could not have the rates of the Standard unless they gave the same volume of business. The discrimination against them was serious. For instance, in 1880, when the Standard paid 65 cents a barrel from Cleveland to Chicago, Schofield, Schema, and Teagle paid 80. From April 1 to July 1, 1881. The Standard paid 55 cents and their rival 80 cents. From July 1 to November 1, 1881, the rates were 35 and 70 cents, respectively, and so it went on for 3 years, when the firm, despairing of any change, took the case into court. This case, fought through all the courts of Ohio, and in 1886 taken to the Supreme Court of the United States, is one of the clearest and cleanest in existence. For studying all the factors in the rebate problem, the argument and pressure by which the big shipper secures and keeps his advantage, the theory and defense of the railroad in granting the discrimination, the theory on which the suffering small shipper protests, and finally the law's point of view. The first trial of the case was in the Court of Common Pleas, and the refiners won. The railroad then appealed to the District Court, the present Circuit Court, where it was argued. So, Important and difficult did the judges of the district court find the questions involved to be, that on the plea of the railroad they sent their findings of the facts in the case to the Supreme Court of the state for decision, a privilege they had under the law in force at that time. These findings are elaborate, including some 23 propositions. 101 they have been confused by certain writers with the opinion on them given later by the Supreme Court. For instance, in an economic study recently published, The Rise and Progress of the Standard Oil Company, the 12th and 13th and part of the 14th proposition which the district court sent up to the Supreme Court in its findings of facts are quoted separately, and the inference from the context is that the writer supposed he was citing part of the court's opinion. As the reader will see from what follows, the paragraphs in question are important, for, taken as quoted, they seem to show that the rebate the Standard received, and which Schofield, Schema, and Teagle wanted, was on account of facilities it gave which the other refiners could not give. The court further find that prior to 1875 it was a question whether the Standard Oil Company would remain in Cleveland or remove its works to the oil-producing country, and such question depended mainly upon rates of transportation from Cleveland to market, that prior thereto said Standard Company did ship large quantities of its products by water to Chicago and other lake points, and from thence distributed the same by rail to inland markets, that it then represented to defendant the probability of such removal, that water transportation was very low during the season of navigation, that unless some arrangement was made for rates at which it could ship the year round as an inducement, it would ship by water and store for winter distribution, that it owned its tank cars and had tank stations and switches, or would have, at Chicago, Toledo, Detroit, and Grand Rapids, on and into which the cars and oil in bulk could be delivered and unloaded without expense and annoyance to defendant, that it had switches at Cleveland leading to its works at which to load cars, and would load and unload all cars, that the quantity of oil to be shipped by the company was very large, and amounted to 90% or more of all the oil manufactured or shipped from Cleveland, and that if satisfactory rates could be agreed upon it would ship over defendant's road all its oil products for territory and markets west and northwest of Cleveland, and agree that the quantity for each year should be equal to the amount shipped the preceding year, that upon the faith of these representations the defendant did enter into the contract and arrangement substantially as set forth in defendant's answer, that the rates were not fixed rates, but depended upon the general card tariff rates as charged from time to time, but substantially to be carried from time to time for about 10 cents per barrel less than tariff rates, and, in consideration of such reduced rates as to bulk oil, the Standard Company agreed to furnish its own cars and tanks, load them on switches at distributing points, and unload them into distributing tanks, and was also to load and unload oil shipped in barrels, and without expense to defendant, and with, by reason thereof, less risk to defendant, which entered into the consideration, and was also to ship all its freight to points west and northwest of Cleveland, except small quantities to lake ports not reached by rail, and to so manage the shipments, as to cars and times, as would be most favorable to defendant, that defendant then agreed to said terms, that said agreement so made in 1875 has remained in force ever since. That, at a cost exceeding $100,000, said Standard Company had and constructed the terminal facilities promised and herein found, that, in fact, the risk of danger from fire to defendant, the expense of handling, in loading and unloading, and in the use of the Standard Tank cars is less, but how much the testimony does not show, then. Upon oil shipped without the use of such or similar terminal facilities, that said Standard Company commenced by shipping about 450,000 barrels a year over Defendants Road, which increased from year to year until, in 1882, the year before filing the petition in this action, the quantity so shipped on Defendants Road amounted to 742,000 barrels, equal to 2,000 barrels or one full train load per day. That said arrangement was not exclusive, but was at all times open to others shipping a like quantity and furnishing like service and facilities, that it was not made or continued with any intention on the part of the defendant to injure the plaintiffs in any manner. Now, as a matter of fact, other propositions in this same set from which the above are quoted, find that Schofield, Shima, and Teagle offered the railroad exactly the same facilities as the Standard, a switch, loading racks, exemption from loss by fire or accident. 102 The manner of making shipments for plaintiffs and for the Standard Oil Company was precisely the same, and the only thing to distinguish the business of the one from the other was the aggregate yearly amounts of freight shipped, said Judge Atherton, of the Supreme Court, who gave the decision on the findings of fact, and he held in common with his predecessors that a rebate on account of volume of business only was a discrimination in favor of capital, and contrary to a sound public policy, violation of that equality of rights guaranteed to every citizen, and a wrong to the disfavored person. We hold, he said, that a discrimination in the rate of freights resting extensively on such a basis ought not to be sustained. The principle is opposed to sound public policy. It would build up and foster monopolies, add largely to the accumulated power of capital and money, and drive out all enterprise not backed by overshadowing wealth. With the doctrine, as contended for by the defendants, recognized and enforced by the courts, what will prevent the great grain interest of the Northwest, or the coal and iron interests of Pennsylvania, or any of the great commercial interests of the country bound together by the power and influence of aggregated wealth and in league with the railroads of the land, driving to the wall all private enterprises struggling for existence, and with an iron hand thrusting back all but themselves. Judge Atherton was scathing enough in his opinion of the contract between the Lake Shore and the Standard. Look at it, he said, and see just what is shown. In consideration of the company giving to the railroad its entire freight business in oil, they transport this freight about 10 cents a barrel cheaper than for any other customer. The understanding was to keep the price _down for the favored customer, but _up for all others, and the inevitable tendency and effect of this contract was to enable the Standard Oil Company to establish and maintain an overshadowing monopoly, to ruin all other operators and drive them out of business in all the region supplied by the Defendants Road, its branches and connecting lines. Judge Atherton was particularly hard on the portion of the contract 103, which pledged the Standard to give the Lake Shore all its freight in return for the rebates, and for this reason, in 1883 a new road westward was opened from Cleveland, the New York, Cincinnati, and St. Louis. It might become an active competitor in transporting petroleum for customers other than the Standard Oil Company. It might establish such a tariff of rates that other operators in oil might successfully compete with the Standard Oil Company. To prevent this, the Lake Shore Road, on the completion of the new road, entered into a tariff arrangement giving to it a portion of the westward shipments of the Standard Oil Company, on condition of its uniting in carrying out the understanding in regard to rebates to the Standard Oil Company. How peculiar, exclaimed Judge Atherton. The defendant, by a contract made in 1875, was entitled to all the freights of the Standard Oil Company, and yet, say the District Court, for the purpose of securing the greater part of said trade, they entered into a contract to divide with the new railroad, if the latter would only help to keep the rates down for the Standard and up for everybody else. Such a contract so carried out was, in the opinion of the court, not only contrary to a sound public policy, but to the lax demands of the commercial honesty and ordinary methods of business. Another fact found by the district court incensed Judge Atherton. This was that the contract was not made or continued with any intention on the part of the defendant to injure the plaintiffs in any manner. It does not make any difference in the case, he declared. The plaintiffs were not doing business in 1875, when the contract was entered into. And, of course, it was not made to injure them in particular. If a man rides a dangerous horse into a crowd of people, or discharges loaded firearms among them, he might, with the same propriety, select the man he injures and say he had no intention of wounding him. And yet the law holds him to have intended the probable consequences of his unlawful act as fully as if purposely directed against the innocent victim, and punishes him accordingly. And this contract, made to build up a monopoly for the Standard Oil Company and to drive its competitors from the field, is just as unlawful as if its provisions had been aimed directly against the interests of the plaintiffs. 104. Having lost their case in the Supreme Court of the state, the Lake Shore now appealed to the Supreme Court of the United States, and the record was filed in November, 1886. It was never heard. The railroad evidently concluded it was useless, and finally withdrew its petition, thereby accepting the decision of the Supreme Court of Ohio restraining it from further discrimination against Schofield, Shima, and Teagle. Illustration: burst in a pipeline. This case, which was before the public constantly during the 6 or 7 years following the breaking up of the Producers' Union, in which the oil regions presented no united front to Mr. Rockefeller, served to keep public attention on the ruinous effect of the rebate and to strengthen the feeling that drastic legislation must be taken if Mr. Rockefeller's exploit was to be prevented in other industries. One other case came out in this war of individuals on the rebate system, which heightened the popular indignation against the Standard. It was a case showing that the Standard Oil Company had not yet abandoned that unique feature of its railroad contracts by which a portion of the money which other people paid for their freight was handed over to them. This peculiar development of the rebate system seems to have belonged exclusively to Mr. Rockefeller. Indeed, a careful search of all the tremendous mass of materials which the various investigations of railroads produced shows no other case so far as the writer knows of this practice. It was the clause of the South Improvement contracts which provoked the greatest outcry. It was the feature of Mr. Cassatt's revelations in 1877 which dumbfounded the public and which no one would believe until they saw the actual agreements Mr. Cassatt presented. The oil regions as a whole did not hesitate to say that they believed this practice was still in operation, but, naturally, proof was most difficult to secure. The demonstration came in 1885, through one of the most aggressive and violent independents which the war in oil has produced, George Rice, of Marietta, Ohio. Mr. Rice, an oil producer, had built a refinery at Marietta in 1873. He sold his oil in the state, the West, and South. 6 years later his business was practically stopped by A sudden raise in rates on the Ohio roads, an advance of fully 100 per cent being made on freights from Marietta, where there were several independent refineries, although no similar advance was made from Wheeling and Cleveland, where the Standard refineries were located. These discriminations were fully shown in an investigation by the Ohio State Legislature in 1879. From that time on, Mr. Rice was in constant difficulty about rates. He seems to have taken rebates when he could get them, but he could never get anything like what his big competitors got. In 1883, Mr. Rice began to draw the crude supply for his refinery from his own production in the Maxburg field of southeastern Ohio, not far from Marietta. The Standard had not at that time taken its pipelines into the Maxburg field. The oil was gathered by a line owned by A.J. Brundred, and carried to the Cincinnati and Marietta Railroad. Now, Mr. Brundred had made a contract with this railroad by which his oil was to be carried for 15 cents a barrel, and all other shippers were to pay 30 cents. Rice, who conveyed his oil to the railroad by his own pipeline, got a rate of 25 cents by using his own tank car. Later he succeeded in getting a rate of 17½ cents a barrel. Thus the rebate system was established on this road from the opening of the Maxburg field. In 1883 the Standard Oil Company took their line into the field, and soon after Brundred retired from the pipeline business there. When he went out, he tried to sell the Standard people his contract with the railroad, but they refused it. They describe this contract as the worst they ever saw, but they seem to have gone Mr. Brundred one better, for they immediately contracted with the road for a rate of 10 cents on their own oil, instead of the 15 cents he was getting, and a rate of 35 on independent oil. And in addition, they asked that the extra 25 cents the independents paid be turned over to them . If this was not done, the Standard would be under the painful necessity of taking away its shipments and building pipelines to Marietta. The Cincinnati and Marietta Railroad at that time was in the hands of a receiver, one Phineas Pease, described as a fussy old gentleman, proud of his position and fond of riding up and down the road in his private car. It is probably a good description. Certainly it is evident from what follows that the receiver was much fussed up ethically, anxious to keep up the income of his road. Mr. Pease finally consented to the arrangement the Standard demanded. But he was worried lest his immoral arrangement be dragged into court, and wrote to his counsel, Edward S. Rapallo, of New York City, asking if there was any way of evading conviction in case of discovery. Upon my taking possession of this road, the receiver wrote, the question came up as to whether I would agree to carry the Standard Company's oil to Marietta for 10 cents per barrel, in lieu of their laying a pipeline and piping their oil. I, of course, assented to this, as the matter had been fully talked over with the Western and Lake Erie Railroad Company before my taking possession of the road. And I wanted all the revenue that could be had in this trade. Mr. O'Day, manager of the Standard Oil Company, met the general freight agent of the Western and Lake Erie Railroad and Mr. Terry, at Toledo, about February 12, and made an agreement, verbal, to carry their oil at 10 cents per barrel. But Mr. O'Day compelled Mr. Terry to make a 35-cent rate on all other oil going to Marietta, and that we should make the rebate of 25 cents per barrel on all oil shipped by other parties, and that the rebate should be paid over to them, the Standard Oil Company, thus giving us 10 cents per barrel for all oil shipped to Marietta, and the rebate of 25 cents per barrel going to the Standard Oil Company, making that company say $25 per day clear money on George Rice's oil alone. In order to save the oil trade along our line, and especially to save the Standard Oil trade, which would amount to 7 times as much as Mr. Rice's. Mr. Terry verbally agreed to the arrangement, which, upon his report to me, I reluctantly acquiesced in, feeling that I could not afford to lose the shipment of 700 barrels of oil per day from the Standard Oil Company. But when Mr. Terry issued instructions that on and after February 23 the rate of oil would be 35 cents per barrel to Marietta, George Rice, who has a refinery in Marietta, very naturally called on me yesterday and notified me that he would not submit to the advance, because the business would not justify it, and that the move was made by the Standard Oil Company to crush him out. Too true. Mr. Rice said, I am willing to continue the 17.5 cent rate which I have been paying from December to this date. Now, the question naturally presents itself to my mind, if George Rice should see fit to prosecute the case on the ground of unjust discrimination, would the receiver be held, as the manager of this property, for violation of the law? While I am determined to use all honorable means to secure traffic for the company, I am not willing to do an illegal act, if this can be called illegal, and lay this company liable for damages. Mr. Terry is able to explain all minor questions relative to this matter. 105. Mr. Rapallo, after consulting his partner and representative bondholders, fixed it for the receiver in the following amazing decision. You may, with propriety, allow the Standard Oil Company to charge 25 cents per barrel for all oil transported through their pipes to your road, and I understand from Mr. Terry that it is practicable to so arrange the details that the company can, in effect, collect this direct without its passing through your hands. You may agree to carry all such oil of the Standard Oil Company, or of others, delivered to your road through their pipes, at 10 cents per barrel. You may also charge all other shippers 35 cents per barrel freight, even though they deliver oil to your road through their own pipes, and this, I gather from your letter and from Mr. Terry, would include Mr. Rice. 106. Now, how was this to be done with propriety? Simply enough. The Standard Oil Company was to be charged 10 cents per barrel, less an amount equivalent to 25 cents per barrel upon all oil shipped by Rice. Provided your accounts, bills, vouchers, etc., are consistent with the real arrangement actually made, you will incur no personal responsibility by carrying out such an arrangement as I suggest. Even in case the receiver was discovered, nothing would happen to him. So decided the council. It is possible that, by a proper application to the court, some person may prevent you, in future, from permitting any discrimination. Even if Mr. Rice should compel you, subsequently, to refund to him the excess charge over the Standard Oil Company, the result would not be a loss to your road, taking into consideration the receipts from the Standard Oil Company. Fortified by his counsel, Receiver Pease put the arrangement into force. And beginning with March 20, 1885, a joint agent of the Standard Pipeline and of the Cincinnati and Marietta Road collected 35 cents per barrel on the oil of all independent shippers from Maxburg to Marietta. 10 cents of this sum he turned over to the receiver and 25 cents to the pipeline. When Mr. Rice found that the rate was certainly to be enforced, he began to build a pipe of his own to the Muskingum River, whence he was to ship by barge to Marietta. By April 26, he was able to discontinue his shipments over the Cincinnati and Marietta Road. This was not done until a rebate of 25 cents a barrel had been paid to the Standard Oil Company on 1,360 barrels of his Oil $3.40 in all. Mr. Rice, outraged as he was by the discrimination, was looking for evidence to bring suit against the receiver, but it was not until October that he was ready to take the matter into court. On the 13th of that month he applied to Judge Baxter of the United States Circuit Court for an order that Phineas Pease, receiver of the Cleveland and Marietta Railroad, report to the court touching his freight rates and other matters complained of in the application. The order was granted on the same day the application was made. It was specific. Mr. Pease was to report his rates, drawbacks, methods of accounting for discrimination, terms of contracts, and all other details connected with his shipment of oil. No sooner was this order of the court to receiver Pease known than the general freight agent, Mr. Terry, hurried to Cleveland, Ohio, to meet Mr. O'Day of the Standard Oil Company, with whom he had made the contract. The upshot of that interview was that on October 29, 12 days after the judge had ordered the contracts produced, a check for $340, signed by J.R. Campbell, treasurer, a Standard Pipeline official, was received from Oil City, headquarters of the Standard Pipeline, by the agent who had been collecting and dividing the freight money. This check for $340 was the amount the pipeline had received on Mr. Rice's shipments between March 20 and April 25. The agent was instructed to send the money to the receiver, and later, by order of the court, the money was refunded to Mr. Rice. But the Standard was not out of the scrape so easily. Receiver Pease filed his report on November 2, but the judge found it evasive and unsatisfactory, and further information was asked for. Finally the judge succeeded in securing the correspondence between Mr. Pease and Mr. Rapallo, quoted above, and enough other facts to show the nature of the discrimination. He lost no time in pronouncing a judgment. And he did not mince his words in doing it. But why should Rice be required to pay $250 or more for the carriage of his oil than was exacted from his competitor? The answer is that thereby the receiver could increase his earnings. This pretense is not true, but suppose it was, would that fact justify, or even mitigate, the injustice done to Rice? May a receiver of a court, in the management of a railroad, thus discriminate between parties having equal claim upon him, because thereby he can accumulate money for the litigants? It has been repeatedly adjudged that he cannot legally do so. Railroads are constructed for the common and equal benefit of all persons wishing to avail themselves of the facilities which they afford, while the legal title thereof is in the corporation of individuals owning them, and to that extent private property, they are by the law and consent of the owners dedicated to the public use by its charter and the general contemporaneous laws of the state which constitute the contract between the public and the railroad company. The state, in consideration of the undertaking of the corporators to build, equip, keep in repair and operate said road for the public accommodation, authorized it to demand reasonable compensation from everyone availing himself of its facilities, for the service rendered. But this franchise carried with it other and correlative obligations. Among these is the obligation to carry for every person offering business under like circumstances, at the same rate. All unjust discriminations are in violation of the sound public policy, and are forbidden by law. We have had frequent occasions to enunciate and enforce this doctrine in the past few years. If it were not so, the managers of railways in collusion with others in command of large capital could control the business of the country, at least to the extent that the business was dependent on railroad transportation for its success, and make and unmake the fortunes of men at will. The idea is justly abhorrent to all fair minds. No such dangerous power can be tolerated. Except in the modes of using them, every citizen has the same right to demand the service of railroads on equal terms that they have to the use of a public highway or the government mails. And hence when, in the vicissitudes of business, a railroad corporation becomes insolvent and is seized by the court, and placed in the hands of a receiver to be by him operated pending the litigation, and until the rights of the litigants can be judicially ascertained and declared, the court is as much bound to protect the public interests therein as it is to protect and enforce the rights of the mortgagors and mortgagees. But after the receiver has performed all obligations due the public and every member of it, that is to say, after carrying passengers and freight offered for a reasonable compensation not exceeding the maximum authorized by law, if such maximum rates shall have been prescribed, upon equal terms to all, he may make for the litigants as much money as the road thus managed is capable of earning. But all attempts to accumulate money for the benefit of corporators or their creditors, by making one shipper pay tribute to his rival in business at the rate of $25 per day, or any greater or less sum, thereby enriching one and impoverishing another, is a gross, illegal, inexcusable abuse of a public trust that calls for the severest reprehension. The discrimination complained of in this case is so wanton and oppressive it could hardly have been accepted by an honest man having due regard for the rights of others, or conceded by a just and competent receiver who comprehended the nature and responsibility of his office, and a judge who would tolerate such a wrong or retain a receiver capable of perpetrating it ought to be impeached and degraded from his position. A good deal more might be said in condemnation of the unparalleled wrong complained of, but we forbear. The receiver will be removed. The matter will be referred to a master to ascertain and report the amount that has been as aforesaid unlawfully exacted by the receiver from Rice, which sum, when ascertained, will be repaid to him. The master will also inquire and report whether any part of the money collected by the receiver from Rice has been paid to the Standard Oil Company, and if so how much, to the end that, if any such payments have been made, suit may be instituted for its recovery. 107. On December 18 George K. Nash, a former governor of Ohio, was appointed Master Commissioner to take testimony and clear up the point doubtful in the judge's mind to whom had the extra money paid by Rice been paid. The receiver declared that he never paid the Standard Oil Company any part of Rice's money. Mr. Nash summoned a large number of witnesses and gradually untangled the story told above. Mr. Pease spoke truly, he had never paid the Standard Oil Company any part of Mr. Rice's money. A joint agent of the railroad and the pipeline had been appointed, at a salary of $85 a month, $60 paid by Pease and $25 by the Standard, who collected the freight on independent shipments and divided the money between the two parties. It was from this agent that it was learned that, 12 days after Judge Baxter ordered receiver Pease to bring his contracts into court, the money paid on Mr. Rice's oil had been returned by the Standard Oil Company. 108 While the investigation in regard to Mr. Rice's oil was going on, complaints came to Commissioner Nash from two other oil works at Marietta that they had been suffering a like discrimination for a much longer time. The Commissioner investigated the cases and found the complaints justified. The Standard Oil Company had received $649.15 out of the money paid by one concern to the railroad for carrying its oil, and $639.75 out of the sum paid by another concern. Both of these sums were returned by the Standard. 109. Of course the case aroused violent comment. In 1888 it came before the Congressional Committee which was investigating trusts, and an effort was made to explain the 25 cents extra as a charge of the pipeline for carrying oil to the railway. Now, the practice in vogue in the oil regions then and now is that the purchaser of the oil pays the pipeline charge. The railroad has nothing to do with it. Even if the Standard Oil Company puts a tax on railroads for allowing them to take oil carried by its pipelines, thus collecting double pay, the tax would not apply in Mr. Rice's case, for the oil came to the Cincinnati and Marietta Road not through standard pipes but through Mr. Rice's own pipes. This much Mr. O'Day was obliged to admit in 1888. Q. But did that other oil which was in competition with you pass through your pipe? A. No, sir. Q. Did not they, therefore, on that oil which only passed over their railroad and not through your pipeline, pay to you the same allowance or rebate that they did on your oil which did pass? A. They did, but we returned it through the advice of our counsel. Mr. Dodd. Q. Now, out of that sum how much did you get from the railroad out of what they had received from Mr. Rice? A. We did not get any, that is, we did not retain any. The railroad company agreed to account to us for the oil that went over its lines, and they did make an accounting, to my recollection, of about $200, or something like that, on oil other than that which passed through the lines. Our counsel, Mr. Dodd, advised me that we could not do that business, and we refunded the money. Soon after the report of the Congressional Committee was published, John D. Rockefeller himself explained the case in an interview published in the New York World for March 29, 1890, when the arrangement was reported to the officers of the company at New York. Mr. Rockefeller told the interviewer, it was not agreed to because our counsel pronounced it illegal in so far as it embraced oil carried by the pipeline. Some $250 had been paid to the pipeline under this contract on oil which the line had not transported. This was refunded. We repudiated the contract before it was passed upon by the courts and made full recompense. In a business as large as ours, conducted by so many agents, some things are likely to be done which we cannot approve. We correct them as soon as they come to our knowledge. The public hears of the wrong, it never hears of the correction. In the Digest of Evidence made by the Industrial Commission in its report published in 1900, page 158, it is stated that the money collected was refunded before suit was brought. The facts show that the statement in the report of the Industrial Commission that the money was refunded before suit was brought is wrong, and that, while Mr. Rockefeller is technically correct in stating that the Standard repudiated the contract before it was passed on by the courts, he should have added they did not repudiate the contract until 8 months after it was made, and did not refund the money until 12 days after it became certain that the contract would be produced in court. He also does not explain why the Standard Oil Company did not return the money unjustly paid to them on the shipments of the other independent oil concerns of Marietta until exposure by Commissioner Nash's investigation made it inevitable. 110. But it was not only manipulation of the railroads by the Standard Oil Company of which the public was complaining at this time. The policy of making it impossible for even small independent concerns to do business was attracting more and more attention. Indeed, there was going on in Buffalo, New York, simultaneously with these two cases, a most sensational trial, growing out of an indictment for the crime of conspiracy, by the grand jury of Erie County, New York, of 3 prominent members of the Standard Oil Company: H. Rogers, John D. Archbold and Ambrose McGregor, with 2 refiners with whom they were associated: H. B. Everest and C. M. Everest. The case is reported in the next chapter at some length, because of the importance it has assumed in the popular controversy which has been going on for the last 20 years over standard methods, it being the case on which is based the often repeated charge that Mr. Rockefeller, to win his point, has been known to burn refineries. Chapter 12. The Buffalo Case. The Standard buys 3/4 of the vacuum oil works of Rochester. 2 vacuum employees establish Buffalo Lubricating Oil Company and take with them an experienced stillman from the vacuum. The Buffalo Lubricating Oil Company has an explosion and the stillman suddenly leaves. The Buffalo Lubricating Oil Company is sued by vacuum for infringement of patents. Matthews sues the Everests of the vacuum for deliberately trying to ruin his business. Matthews wins his first civil suit. He files a second suit for damages, and secures the indictment of several Standard officials for criminal conspiracy. Rogers, Archbold, and McGregor acquitted the Everests. Fined. Very soon after, Mr. Rockefeller began to acquire independent refineries, whose owners were loath to sell or go out of business. Unpleasant stories began to be circulated in the oil world of the methods used in getting the offending plants out of the way. When freight discriminations, cutting off of crude supply, and price wars in the market failed, other means were tried, and these means included: sometimes, it was whispered, the actual destruction of the plants. The only case in which this charge was made which ever came to trial was that of the Buffalo Lubricating Oil Company, Limited. For sake of clearness, a narrative of the case has been drawn from the testimony offered, no statements being admitted which were not brought out in the trials. It seems that sometime in 1879 the owners of the vacuum oil works of Rochester, New York, H. B. and C. M. Everest, father and son, sold to H. Rogers, J. D. Archbold and Ambrose McGregor of the Standard Oil Company, for $200,000, a 3/4 interest in that concern. The purchase was not made for the gentlemen in whose names it appeared, but for the Standard. Thus, when on the witness stand J. D. Archbold was questioned as to the real ownership of the stock which had been bought in his name, the examiner wanted to know whether the purchasers represented themselves or somebody else. "Mr. Archbold," he asked, "you made the contract, did you not, with reference to the transfer of the 75 shares of the Vacuum Oil Company's stock by the Messrs. Everest _A. I bought the 75 shares, yes, sir. *********** Q. Whom did you represent in that transaction? _A. I represented the shareholders of the Standard Oil Company. _Q. After this purchase was made, did you continue to represent the purchasers in the management of the affairs of the Vacuum Oil Company? _A. I did. Q. By virtue of power delegated to you, or by virtue of being a member of the board of directors or trustees of the Vacuum? _A. By the virtue of power delegated to me. Q. By the purchasers? A. By the purchasers. The vacuum manufactured principally lubricating oils used on harness and car wheels. It controlled several valuable patents and had been doing a prosperous business for a number of years. By the terms of the sale in 1879, the Everests remained as managers of the refinery, on a salary of $10,000 a year. They also contracted to enter into no outside oil Business for 10 years. The business policy of the vacuum, including the fixing of salaries, was dictated by a board of directors made up of Messrs. Rogers, Archbold, McGregor, and the two Everests. The meetings of this board were held at the office of the Standard Oil Company, in New York or in Rochester, as convenient. So far as can be inferred from the testimony, the works were well managed, the dividends large, and the employees well treated. In 1880, the salesman of the concern, J. Scott Wilson, decided to leave the vacuum and go into business for himself. The decision seems natural, for until 1878 Mr. Wilson had carried on an independent oil business of one kind or another. He had been a partner in a refinery and understood making oils. He had been a jobber on his own account before going with the Everests, and as such had had a considerable clientele. Wilson told one of his fellow employees, Charles B. Matthews, of his decision, and asked him to go with him. Matthews had been with the Everests about the same length of time as Wilson, some 2 years. Previous to this engagement he had been a farmer, and his acquaintance with the vacuum people had come about by his drilling on his farm for oil. Matthews was worth some $20,000, but he had had no experience in oil refining, for his duties at the vacuum had been mainly looking after outside business. For instance, he had several times gone to New York to consult J. D. Archbold and H. H. Rogers concerning business matters, and particularly concerning patents owned by the vacuum, of whose validity there was some doubt. For some time Matthews had been dissatisfied with his salary. He had asked for a raise, but had not got it, a fact which probably made him more favorable to Wilson's suggestion. The two men decided finally to form a company and to build an oil refinery at Buffalo. Wilson said on the witness stand that he did not want to handle the vacuum processes in the new works, but to make only the oils with which he was familiar. Matthews, however, had convinced himself that the patents which covered certain of the vacuum processes and apparatus were invalid, and insisted that they build at least one vacuum still. The question of what steps the vacuum might take to stop them was discussed, and according to Wilson's testimony, Matthews remarked that he expected they would pay $100,000 or $150,000 to prevent their going into business. Matthews's remark was natural enough, considering the conditions under which outside refiners were forced to do business. It is probable that no man undertook any kind of independent oil business at that time, particularly oil refining, without considering the possibility of being driven to sell. The new firm needed an experienced stillman accustomed to the vacuum processes, and early in 1881 they asked one Albert Miller, a stillman in the vacuum works, to join them. If we have Miller, they told each other, we can go to the customers of the Vacuum Oil Company and say to them, we have the same process and the same apparatus and the same oils as the Vacuum Oil Company, and we have their former superintendent, M.R. Miller, to manufacture the oils. Miller had been with the Everests for several years, having worked his way up from a laborer at $2 a day to a position where, as stillman, he was paid by the hour, and earned from $1,200 to $1,400 a year. He and his wife had been thrifty, and had several $1,000s in property. Miller thought there was money in the new venture, and consented to join Wilson and Matthews. They three set about carrying out their plans before they notified their employers of their intention to leave Miller, going so far as to order certain iron castings needed in the construction of their works, made after patterns owned by the Everests. He had these made at the foundry patronized by the Everests. He paid for them himself, and carried them away, presumably giving the impression that they were for his employers. Early in March, Matthews and Miller notified C.M. Everest, who was in charge, his father being in California, that they were going to leave and establish at Buffalo an independent oil refinery. Mr. Everest, surprised out of discretion by the news, told them plainly that although he had nothing against them personally, he should do all in his power to injure the proposed concern. He asked them where they expected to get oil, and they replied that they would get it from the Atlas Refining Company, an independent concern in Buffalo, which had its own pipeline. "You will wake up some morning and find it is in the Standard," replied Mr. Everest. Apparently Mr. Everest's threat had little influence on the men, for they pushed the building of the works in Buffalo as rapidly as possible. On March 15 they signed an agreement to carry on the proposed business for 5 years, each man to put in $2,000. A month later the 3 men, with 2 relatives of Matthews, organized a stock company, the Buffalo Lubricating Oil Company, Limited, with a capital of $40,000.